by the Iebc for the conduct of the 2022 general elections completely failed the standards of a secure, transparent electronic voting system, and thereby yielded what has aptly been described by my colleagues as an unverifiable, inaccurate, and therefore invalid results. Our further submission in this regard is that the technology was so inherently corrupted, manipulated, and tainted that the results declared by Mr. Chebukati, the third respondent, cannot be, in an objective case, said to be representative of the true will of the Kenyan people, as we and as I will demonstrate in my further submissions. On the evidence, the components, principles that ought to have been met in order to meet the constitutional standard of a secure and transparent system are as follows. Confidentiality is the first one I propose to deal with. This requires that the information within the process, and I'm not talking about the public portal, I'm talking about the back end, should have been accessed by only those legitimately authorized. And those authorized, in order for them to be accountable, are persons whom the entire commission, in its, as defined by my colleague Paul Mwangi, the entire commission ought to have been fully aware of, gazetted where necessary, and it would certainly help if they were also Kenyan nationals. Integrity is the information used should be accurate, complete, protected by various and protected from malicious modification, which includes alteration or obstruction, either by authorized or unauthorized persons. Availability. The information required must be available as and when required by those authorized to use or access it in compliance with the constitutional requirements and the Elections Act. Non-repudiation. An audit trail must be maintained on activities related to the information. An audit trail in this regard is, should the court so require, should a party so require, it must be readily available in the appropriate manner. Authenticity. The information itself must be proved to be genuine, and the source must also be proved to be genuine. I submit on behalf of the petitioners that on the security aspect, there was lack of security. The first instance of that demonstrates this is the operation and use of the Iebc and availability to, I repeat that again. The first is operation and use of Iebc election materials and equipment to identified unauthorized persons. And I'm referring in this regard to the now infamous Venezuelan nationals. I will elaborate on that in a few seconds. The second is the penetration by way of hacking and illegally granted access of the Iebc system by known and unknown persons. I distinguish between hacking and unauthorized grant of access. Hacking is where a person outside the system doesn't have the key, and I'm using the simple illustration, and so he accesses it through the roof, a room through the roof or the back door, and he enters the system. The illegal grant of access is a situation where the codes, the credentials that are otherwise legitimate are granted to unknown persons. In the case of the now infamous Venezuelans, there is plenty of affidavit evidence on record, and I particularly refer to the affidavit of Martha Karua, the second petitioner, dated the 21st of August 2022, which contains or encloses the statements by the DCI, and of course the rebuttal by Chebukati on behalf of the IBC. Your Ladyship, my Lords, I also refer to the affidavit of Juliana Cherera. I also refer to Annexure JC3, the National Police Service press statement dated 22nd of July 2022. Annexure JC4, press statement by ABC Chairman dated 21st July 2022, stating that the 3 key personnel responsible for the deployment and management of elections infrastructure and that the 3 Venezuelans were employees of Smartmatic International BV. I also refer to the Annexure JC5, press release by the Directorate of Criminal Investigations dated 23rd of July 2022, detailing the crucial election materials irregularly and illegally found in the possession of 3 Venezuelan nationals. Their names: Jose Gregorio Camargo Castellanos, that is one name, one person; Joel Gustavo Rodriguez Garcia; Salvador Javier Sosa Suarez. Those were the persons named in the detailed Directorate of Criminal Investigations report. Hello, and your Ladyships, I would like to emphasize that the Directorate of Criminal Investigations is the national institution charged with the responsibility of investigating crime. Crime in relation to the Penal Code, the Elections Act, all crime. And that evidence, the statement by the DCI regarding the Venezuelans, is not a matter that can be taken lightly and wished away by the chairman of the IEBC. I will deal then with the issue of the penetration or the compromise of the IEBC system. And I ask the court to look at the affidavit evidence of John Mark Gidongo, 2 affidavits or 3 affidavits, Benson Wesonga, an IT forensics expert, George Njoroge, IT forensics expert, and the forensic analysis of the DCI of a laptop confiscated from one Kip Ngosos at the National Tallying Center. I also asked the court to look at the affidavit of Justice Nyangaya, who is one of the commissioners, which responded? 6th respondent. Thank you. I will summarize the affidavits. The evidence of John Makidongo, he has sworn 2 affidavits, one on the 21st of August 2022 and the other on the 28th of August 2022. In his affidavit, at paragraphs 2, 3, 8, 9, and 10, he talks about the illegal access into the system and manipulation of the presidential results, how it was orchestrated and implemented. At page 4, paragraph 12, he produces evidence of a video recording. Paragraph 8, page 8, paragraph 16, he witnesses how he saw this young person illegally and very easily access the IBC system, while where he was able to see information including that of his name and other accredited observers at the IEBC National Tallying Center, and pages 13 and 18 of certain screen grabs. In the affidavit dated 28th August 2022, page 2, paragraph 4, John Githongo clarifies what was given to him in the first affidavit, but more importantly, at page 2, paragraph 6, he produces the actual logs that were used to show access to the system. I wish to make a short submission regarding the evidence of John Githongo and the transcribed interview he had with this young person. And I'm discussing this in the context of the probative value of that conversation he had with this young witness. It came out that somewhere, somehow, in the current suburb, there was a group of about 50 people who had access to the ICT systems of IEBC, whereby they were intercepting results before they were uploaded on the public portal. When that was put out and the responses first came, that suggestion was rubbished. But in further evidence, I will demonstrate to the court that it now turns out that that is probably and most likely what happened and what created this entire mess that is called the election results of the 2020-22 presidential election. In the case of George Njoroge, whose affidavit is on record, whose CV is on record, a computer forensic expert with wide-ranging experience in investigating all manner of crimes, including those involving terrorism through investigating the IT aspect. In his affidavit dated 28th August 2022, he has attached his detailed audit and analysis report of IEBC results transmission system and operating system log files. And I emphasize that amongst those he analyzed are the logs annexed to the affidavit of Justice Nyangaya, who is the 6th respondent and who was the commissioner of IEBC in charge of ICT. I emphasize this because it tells us the logs, that information from the logs comes from within the IEBC, the first respondent. And therefore, it must be taken as correct. Indeed, in one of the witness statements we have, or affidavits we have from one Mr. Nyaga, in various affidavits, together with Mr. Uma, they are defensive, together with Mr. Chepkati, they reject the suggestions, but when the logs from Mr. Nyangaya are finally analyzed, they are suddenly, in particular Mr. Nyaga, forthcoming. In the case of Mr. Nyaga, and I will refer to his affidavit, his first reaction is to suggest that they have been illegally obtained and a crime has been committed and somebody should be prosecuted. In fact, the DCI should take action. That is an admission that at all times something vital to the verification of the process was being withheld, not only from this court, from the entire Republic of Kenya. George Njoroge has provided a detailed audit and analysis report, and he, at page 1, paragraph 5, confirms that he analyzed the log files. Page 11 shows the image application for each of the 6 IEBC servers that had information. And of course, at this point, I'm hopeful that in the scrutiny, the same 6 IEBC servers shall be availed by the IEBC as quickly as possible. Page 3, which is the part of the report that confirms several authorized individuals were illegally authenticated to gain access into the core of the life system. Several authorized individuals who are illegally authenticated. We'll go and demonstrate that, because authorized could mean you are within Iebc, but illegally authenticated, you have gone well above your pay grade. Page 14, 40, page 14 of the report, 14, 40, and 41, confirms that there was evidence of remote access to the system on the 13th of August 2022. 13th being 3 days after the voting. Remote access means somebody outside the walls, virtual walls of Iebc. In other words, somebody somewhere sitting out of the system has the key and can log in. Transmissions of numerous forms from a single host server whose IP address was given or is given as 172 full stop 21 full stop 5 full stop 4. Contrary to the expectations that the forms would come from various KIMS kits directly to the NTS public portal. I illustrate this, or I explain this by stating that Mr. Chepkati, chairman, went on record as saying this is a very simple system. From the constituency level, it shall come to the National Tallying Center onto the portal that is public. He has no intervention whatsoever. He can't stop it. It comes. To the extent that I remember one conversation on in one press statement, he was asking the press, "Why are you so slow? You know, I'm faster than you." But that is how it was supposed to happen. But the evidence will show that we have provided that there was an illegal, malicious, and unauthorized existence of commission staff who are not officially gazetted and mandated to be part of the electoral process, but who had access. Page 15, and one of them I should state now was his personal assistant, whose name I shall provide shortly. Page 15 shows that there was evidence of, this is important, there's evidence of downloading and conversion of the forms from the system and thereafter uploading them with new information. Your Ladyship, my Lords, I explain this by saying a Form 34A has been uploaded from the constituency level by the returning officer. Before it hits the front end of the public portal, meaning the side that we will all have access to, it is downloaded, it is changed, converted into a system known as CSV, which is comma separated values, that's what it means, which is an editable format from the original PDF format. PDF, we all use that abbreviation without getting what the meaning. It means portable document format. The PDF cannot be edited, whilst the CSV provides the opportunity, the facility for editing. So if one were minded, that is the point, and we submit that is what happened when the numbers are changed within the Form 34As. Otherwise, there would have been no need for downloading the system, the documents, and uploading them after a bit of time, sometimes hours, sometimes a few seconds. Page 16 and 21 shows a continuous generation and regeneration of 35C, yet 35C was 34C, yet 34C was supposed to be generated only once at the very end of all the information from 34B coming in, and of course 34A. Page 17 this is an important component of our submission, there was overwhelming evidence of back-tallying of presidential results. This means that a Form 34C was being generated with a result, a desired result, and thereafter what seems to happen is a process of going backwards to change Form 34B and 34A to give the result that was desired. This happens continuously, and it is illustrated very well in the evidence of Mr. Njoroge. What is obvious, but bears repeating, is that the process, the system was only supposed to work forward going, not by way of back tallying, meaning 34A, the aggregate of the 34A was to create the 34B, and the 34B aggregate would create 34C. Once 34A, as many as there are polling stations, etc., going forward. But what you see from the report of Mr. Njoroge is after the voting, until the results are announced, far too much activity, all starting with the generation of a 34C. The analyst is not able to know exactly what is going on, but it can be surmised from the abbreviated logs that show you're seeking to generate a document, and in computer parlance, that means you're seeking to edit something, you're seeking to change something. My hypothesis from where I stand is, and I'll state at the very end, clearly a result for the first respondent, that is Mr. Ruto, was being arrived at well before the tally was in. And each time work was being done to try and fit A and B into that result. And through the confusion, because people who engage in such exercises make mistakes, at the very end, the result is forced on Kenyans through a defective 34C, where the commissioners cannot agree, and Mr. Chebukati walks and says, it doesn't matter, third respondent, it is my result, and you can tell what you want to the birds at Serena. So, the process ought to have been, ideally, 46,232 Form 34As ought to have been generated into 291 34Bs, and in turn have generated one, I repeat, one 34C. However, you will find, your ladyships and my lords, that an analysis of the logs shows several regeneration of 34Cs, which in turn lead to what I have just described. But at all times, you see a downloading of 34As in the CSV format, which is the editable format. 12th August 2022 was done on the 14th of August 2022 at 3:57 Page 23 shows that Form 34C was received in a PDF format at 3:57:01. Thereafter, instructions issued to the system to receive data to create 34C. And thereafter, an action of starting document Form C generation is commenced and finally was successful. Page 25 shows the above action was repeated on the same day at 4:1:33, and it goes on and on. I don't wish to take up too much time. It is all clear. Page 65 shows on the 14th of August 2022 at 15:34:12 there is an ambiguous and intentional modification overriding the whole process to finally generate Form C document. Data from Form 34B is then entered only once into the Form C, when there should be several entries to the Form C on different dates. Page 15 shows that there's a presence of illicit data in the presidential tallying system. Illicit means unexpected. There was plenty of Form 35Bs, which should not have been in the same portal. I move on. This you will find is repeated on and on. Page 43, 76, and 77. We see IEBC personnel who were not gazetted for the purposes of the restricted and accountable access to the system were granted access to the system. In particular, the personal assistant of the chairman of the third respondent, Mr. Dickson Kwanusu, is granted access. As a rejoinder, we have seen a belated authority to have such access, which is well after the election. But he is not gazetted, so he is invisible. This court, if we hadn't brought the logs, it would never have been known that Mr. Dickson Kwanusu had wide powers in this system. So, whilst in this dispute, we may not see the fingerprints of the third respondent in the ICT system, we see his palm, his much larger presence through the actions of his PA. Indeed, you will find, when you study the system, that Dickson Kwanusu performed a purported verification process of 34As 1,743 times. The same scrutiny revealed that at page 28, one Abdi Dahir, who was not gazetted and who is belatedly granted access and privileges to the system, purportedly verified 659 Form 34As. Yeah. So, I ask the court to look at the affidavits of Ben Wasonga. He is also another computer forensic expert. His evidence is substantially the same as George Njoroge. I will ask the court to note that the tender documents did provide that whoever was to provide the system was to be able to provide a KIMS kit that would provide compressed color photograph images using a compression technique that is in compliance with JPEG. However, the court will find that all finally displayed Form 34As were in black and white. I will shortly mention that it becomes evident that there is interception of data. It's called a man-in-the-middle or machine-in-the-middle attack, and it gives probability and great it supports fully the evidence of George Njoroge and John Githongo that in fact the system had unauthorized persons. I would go quickly to the evidence of again Benson, who in his affidavit shows that there was not only one foreigner involved, there was several of them, and the ones I had mentioned earlier, and throughout the process of counting, several of them were involved as super administrators. Super administrators is the power to even create and join servers to the system, change, alter documents, delete documents. This is at page 2 of paragraph 9 of the affidavit sworn on 28th August 2022, where the super administrator, in this case, the one JCA Margo, who occasionally uses a different name, is able to create user accounts, install applications, change user roles, assign resources, read documents, write documents, modify or edit documents, and delete documents. I honorably suggest that it shows that this election was controlled from everywhere except Iebc. And I have read the affidavit of Mr. Chebukati. He suggests that the Venezuelans felt harassed after their arrest and left the country, but I respectfully submit that they remained fully connected to the Iebc servers. I have said page 3, paragraph 8 shows the unauthorized users accessing the system, a total of 6 of them being, I found the page, is C. Silva, Josio, Vito, JCA, Margo, Ogudino, and J. Lugo. I conclude by saying, what is the response of all these very serious allegations? I say that we get it from the affidavits of the 4 commissioners who have differed with the chairman. They have stated categorically that that whole system was created by was controlled by one person, the third respondent. They were kept in the dark. Mr. Nyangaya, who was in charge of ICT, was also shocked that foreigners were controlling the system and had access during and after the election. And I point out that Mr. Chebukati did not offer this to the court in his replying affidavit, and it only was offered through his subordinates when the evidence was availed. I conclude by submitting that what we have before the court is clearly a corrupted, and I'm not talking about a person, I'm talking about the verb, a corrupted and compromised RTS system which does not meet the demands of the Constitution and the Act. And it is only a matter, that will be determined after scrutiny whether something can be retrieved from the system, which includes, and we focus on the results that were first uploaded onto the KIMS kits. Perhaps that's where we will find some truth. But whatever got to Bomas of Kenya was totally corrupted, I submit, by corrupt IEBC officials. I lastly point out that you will find in the affidavit of Mr. Benson Masonga, Smartmatic, by some strange coincidence, is reportedly mired in several controversies in the management of elections technology around the world, including Venezuela and the Philippines. So perhaps that makes them unqualified to most of us, but makes them eminently qualified for the fraudulent objectives of the first and second respondents. Thank you.
My Lady Chief Justice, my ladies, my lords of the court, I address the court on issues 8 and 9, the magnitude of the matters which you've been listening to and which are set out in all our documents, and I will turn later to the prayers. This morning, in the last three of the submissions from my colleagues, the question of what Mr. Chebukati was doing when Article 183 began to operate, 138 began to operate once the 34As moved from the polling stations to the constituency levels to become 34B, and then from there to the National Tallying Center. And Article 138.3 is, Article 138 is entitled, the marginal note, Procedure at Presidential Election. And sub-article 3 is, in a presidential election, paragraph C, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. 138.3c. And so there are 3 steps to be taken after leaving the polling stations. They shall be tallied and verified and the result declared. And the party that is tasked with the duty of doing these 3 things is, under the Constitution, the Independent Electoral and Boundaries Commission. But as you have heard, as you have read all the documents, we saw only Mr. Chebukati doing these duties and not doing these duties as part of the commission, but by himself, together with his clerks, together with his team members, to which I will come in a moment, but not in their capacity as having any decision-making powers over the steps he was taking as the person doing tallying and verifying. Why was there not the Independent Electoral and Boundaries Commission not taking these steps by itself or through itself? And the answer to that is given by Mr. Chebukati himself, and it is in his replying affidavit, sworn on the 26th day of August 2022. And this is what he is setting out in paragraph 108. Sorry, 103. Thank you. On page 10, members of the court, my apologies, to paragraph 37. And this is what Mr. Chebukati says, that the commission, from Gazette Notice number 9540, number 155, dated 8th of August 2022, a day before the election, outlined the result pathway from the polling station to the national tallying as follows. And then he quotes the Gazette notice, subtitle, "The Presidential Returning Officer," into brackets, Commission Chairman, Roman 1, receives Form 34As and 34B. Article 138 is reading that the form should be received by the Iebc. Roman 2 from the Gazette notice, the Presidential Returning Officer Commission Chairperson verifies. And later on, again, he says, declares. Where does he get this authority from? Is from the Gazette notice. And so that Gazette notice is set out in his affidavit. And the Gazette notice is reading on page 36. This Gazette notice is in the X made, and it sets out the result paths at the National Tallying Center, which we have seen. And so we search for the authority to move away from Article 138. How did it get from Iebc to Mr. Chebukati? In exercise of the powers confirmed by Articles 88, 44 of the Constitution, Section 4 of the Iebc Act, Sections 38, 39 of the Elections Act, and Regulations 87(1)(b) of the Elections General Regulations 2012. This shift has come through these General Regulations 2012, which were amended at a different time, and brings a different receiving party. And that receiving party is the returning officer, into brackets, Commission Chairman, and the 87 itself, the regulation, is an amendment and is referred to by Mr. Chebukati. We submit that Regulation 87 and this pathway that he has put down is a repeat of Article 138(3)(c), but with one significant alteration. Instead of the Iebc receiving the votes, instead of the Iebc verifying the votes and declaring the tally and the verification, he has put his own name, the chairman. Simple submission we have that this is subsidiary legislation. The pathway which he was relying on in the Gazette notice is void totally. The subsidiary legislation from which the Gazette notice is derived is void, as being in total conflict with not only its principal legislation, but with the Constitution itself. this is what takes the tallying and verification process away from the Iebc and took it into what was happening from the 9th of August right up to the 15th of August. And this was breaking every single national value set out in Article 10. And because this too was a checkpoint, it is widely believed, and the chairman is the first to fan this, that there is only one key checkpoint in the process of counting, and that is 34A at the polling station, close of polling, a photograph, the Keams skit, and that's the check. We have to understand that there isn't only one check. There is a second key check from the 34As to the 34Bs. There is generated 34C, and 34C is so key that it needs a second check. And who is there to do that checking? No longer the agents at the polling stations. In their place, the Constitution sets the Iebc, the 7 commissioners. And the 7 commissioners are checking the movement of the thousands of 34As into 292 or 290 of the 34Bs. And the people watching them are the 7 commissioners who are representing the people of Kenya, overlooking the process. And by shutting them out, as has been set out by numerous of the affidavits and the television itself, that those 6 were kept away from the process of verification, so that the participation of the people of Kenya over the process of establishing the will of the people was closed down. But there is even a more dangerous thing going on here, and it is this. By this amendment, there was a concentration of the entire process, both of the verification as well as the decision-making as a consequence of that tallying and verification, a concentration into only one individual. And it gave him the power, that Gazette notice, that subsidiary legislation, in violation of the Constitution itself, to take these decisions, and vested in him an asset, a power to find a result all by himself with no check. And if such a person were an auctioneer, then he had got into his hands, if you want to be a successful auctioneer, you must have something to auction. And this, the supreme prize in our politics, in our national life, in our institutions, had come into the hands of one person. This is the danger, so great that it has been the push from the beginning of this election campaign, before the election. Keep your eyes on 34A at the polling station. Anybody who questions anything after that is an agitator, a person who is out to commit violence, is a person seeking this and that and the other. These are all decoys, taking away the key information that one man is doing this, and this petition is the most important petition that we have had. It is from this bench. There are 3 counsel here who filed and were present and argued the first presidential election petition against an incumbent 25 years ago, in 1992, now 30 years ago. And we have had to move step by step, pushing from very crude checking against very crude stuffing of ballot boxes to this day, when our ballot boxes are being stuffed with a highly sophisticated other writing form. And this is not about 2 people. It's not about 1 person. It's not about political ambition. This is what happens when this chairman is left to do what he has carefully managed to do. And it is therefore our first prayer that this court, the Supreme Court, holds and declares that the Gazette notice and the 87 subsidiary legislation of the general regulations is null and void for being contrary to its principal legislation and constitution. This is why there are people going to people's houses at 3 a.m. and 4 a.m. But is it something so unbelievable? No, this method, how is it that every 5 years, under the chairmanship of this particular officer, we have a crisis? Let me show you another step taken by Mr. Chebukati in this election. On the 8th of August, Mr. Chebukati announced that the gubernatorial elections for the next day in Mombasa and in Kakamega were postponed. And he puts it out in a Gazette notice. Once again, we have queried whether that was a decision of the Commission or of himself. And we asked the reasons. And he has set out the reasons in that same affidavit at page 25. And at page 25, he sets out why he had to do it. Sorry. And this is what he says. Paragraph 103 of that affidavit on page 25, that despite spirited efforts by him and his whole teams, whatever they are, to have the printer replace the ballot papers urgently, it was not possible, he says, to complete all the logistics in time for the elections. In the circumstances, the Commission was constrained. Now he is seeking there umbrella, was constrained to postpone the gubernatorial elections in Kakamega and Mombasa, and then he gives the authority. Pursuant to Section 55B of the Elections Act and Regulation 64 of the Elections General Regulations, which allows the Commission to postpone an election in a constituency, county, or ward, quote, I've been quoting, quote, where it is impossible for an election to proceed, full stop. Then he says that the postponement was for a limited. So he has set out that it was postponed under these two sections and regulations where it is impossible for an election to proceed. So we look up Section 55B of the Elections Act. Here is 55B of the Elections Act. Postponement of elections by the Commission. Section 1. The Commission may, where a date has been appointed for holding an election, postpone the election in a constituency, county, or ward for such period as it may consider necessary, where A, there is reason to believe that a serious breach of peace is likely to occur if an election is held on that date. But Mr. Chebukati says that's not the reason. B, it is impossible to conduct the elections as a result of a natural disaster or other emergencies. He hasn't said it was because of the natural disaster or other emergencies. He doesn't say they were there. C, that there has been occurrence of an electoral malpractice of such a nature and gravity as to make it impossible for an election to proceed. A, B, C. None of these were applicable, but even if they were invoked, none of them were present in fact. But see what Mr. Chebukati had done. He had lied. He said that in Section 55B, it is provided that they may postpone if it is impossible to conduct the elections, full stop. And when we look at Regulation 67, it's identical with the same conditions. Once again, he is lying. And there is not the slightest concern, for the values of Article 10 and the whole Constitution. This is two things here to watch, members of the court. Number one, that this is a person who is saying these things with impunity. This is a person who sets out the wrongdoing that he is practicing with mens rea. This is not a mistake. This is a very calculated, very calculated subversion of forethought. He plans this, does it on the last day, doesn't explain what those conditions are which make it impossible, and delays it. And then it does not matter to him that at least 2-3 million people in Mombasa County and Kakamega County have been deprived of their right to vote. That it is important and reversing that a presidential election has to be held on the days when the general election is held. This is how the mess that has brought 100, a full Supreme Court, here. Because this man, when you ask him these things, justifies it, knows that it is wrong, and puts it in an affidavit. And then says to us, you explain it. So, it is important not that we cannot rely on a single thing. This is a practiced artist of the destruction of our institutions, because that is what happens. He did it in 2017. He was caught. When the court ordered him to disclose more things, he disobeyed the order, never did it, and took the benefit of the continued change of circumstances, a new election, etc. And now, back again, he is here. Same person, same sort of tricks. This was in 2012 and 2013, this amendment. This man has been practicing this for 2 election cycles. And he comes here, read this affidavit. Every 2 sentences he says, I'm conscious of the importance of my work as a state organ or a state officer. I'm a practicing advocate, and my professional integrity would never allow me to do these things. I told the NSIS, I am standing up for what is right. I told the 4 commissioners, never, I don't do things like that. When people are running, the person who calls out loudest, thief, thief, thief. So that this is what has been going on, and it is destroying our institutions. This case is about the democratic institutions of Kenya. And it is about how we protect those institutions and how we stop people who are attacking those institutions. We cannot do it on the streets. We do it through the institutions. We were doing it through the bar. Now the burden has come to the judiciary because of the new constitution. And we pray that that burden will be borne constantly, persistently, with courage, because when such burdens are not borne, all of us fall down, including courts. And is that something that should be, is that something that has to be spoken to, I mean spoken for, by a party who is seeking justice? And the answer, fortunately, is no. The Constitution itself gives the answer. And that is set out in Article 3(2), which says that it is the duty, every person has an obligation to respect, uphold, and defend this Constitution. Defend? Armies coming from abroad don't care about our Constitution. We're not defending this Constitution against armed incursion from anywhere. That defense is from enemies within, who use this type of thing. It is not unusual. The subsidiary legislation emanates, as we all know, from the institution itself. And a letter goes to the Attorney General saying, I would like to amend this. This is what I want. The Attorney General says, give us a draft. The draft comes, sent to the draftsman, legal draftsman. First draft goes to various ministries, Attorney Generals, other departments, public, to the Interior Ministry, la. So this has been done very calculatedly. Very few of us are going to read this to see it, but no one even saw it in 2017. So we have work ahead of us. And so may I turn then to the second issue that I'm coming on to submit to your ladyships and lordships, and that is sure. Thank you. Sorry, Mary. So the prayers are there. We are asking for prayers in the petition, and we respectfully request that the court looks at them and deliberates on them. But the court also has powers from other places. For example, in the Elections Act itself, under Section 80, subsection 4, the court has power. The court has power to, if there is evidence that you find, you may issue directions that the certificate is to be made out in the name of the person who has secured more votes. The second prayer we do make outside this is this, that we cannot have, whatever the outcome of this petition, we cannot have the self-discredited person who is giving false affidavits, doing all these things, to be the chairperson of the Iebc or anything at all. And so we are also saying that there are two prayers in relation to this. The Article 3 of our Constitution says this. Article 3, sub-article 2. And this is at the heart, I pray, of the judgment that this honorable court gives. 2, any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. Any attempt to establish a government otherwise than in compliance with this Constitution is unlawful. And so, in what is a 34C? A 34C is what leads to 34B, which leads to the declaration of a precedent, which is the formation of a new government. That is what was going on the 15th of August there. An attempt, and even here, right now in this court, there are people who have filed things in contravention of the saying that what is in contravention of the Constitution is correct. And right here in this, there is an attempt to establish a government otherwise than in compliance with this Constitution. It's unlawful. So, if this Honorable Court finds that Mr. Chebukati is responsible for and has committed actions and decisions which are an attempt to establish a government otherwise than in compliance with this Constitution, we pray that you make a holding that he has done such an attempt, which is a mechanism within the Constitution itself and within this election petition's four corners, and a second and another declaration that this person, pursuant to Article 33, sub-Article 2, is no longer fit to hold public office. We go further. Is it possible that we can stop it by stopping Mr. Chebukati alone and we submit? No. It doesn't matter whether Mr. Chebukati will find another Mr. Chebukati next time. We have to stop those people who do not take those steps, but who take the benefit of those steps. And those people who take the benefit of the steps which the Constitution itself says is unlawful cannot take public office on the basis of a false 34C, 34D, of a declaration made by a person who knows he's made it falsely, so that we also pray that those who seek to benefit from the wrongdoing of Mr. Chebukati are themselves caught by Article 3, sub-Article 2, and you have the powers to make the same orders, that they too are making an attempt to establish a government in Kenya otherwise than in compliance with this Constitution. And we pray that this court moves our country forward with those two steps of orders in relation to all parties benefiting and all parties carrying out this mass attack upon Kenyan democracy. Thank you.
I pray to the court to allow me to say a few things in conclusion. And I'm honored to come after my senior, Mr. Feroz Norji, senior counsel. I cannot forget to put it on record that in 1993 I filed a similar petition challenging the election of the then president, and my lawyer was Mr. Feroz Norji and Mr. Paul Mwangi, and I'm forever grateful. And so was Mr. Paul Mwite, senior counsel. Many times I was locked up, he was always available to appear for me, and like many other counsels who are here. I want to urge the court that what has been put on record, and particularly the evidence that has come through the submissions of my learned friend, Mr. Morgor, it's so important in terms of making a decision as to what to do with the elections that were held on the 9th of August this year. And Mr. Morgor has put evidence before you which has not been controverted. For example, there is evidence of interference, if not invasion, of the technology infrastructure of Iebc. and the evidence of Mr. George Njoroge, which was covered by Mr. Murgor. I want the court, with respect, to look at what the Iebc has said in return or in response to those very, very serious allegations through Mr. Martin Wachira Nyaga, again was referred to by Mr. Murgor. He does not deny the disclosure of the 6 logs from the 6 servers. In his affidavit, he actually acknowledges the logs which speak to access to the servers without authorization. And he puts the question the other way around. Instead of this matter going into inquiry by the Electoral Commission, he questions the authority of Mr. Njoroge in accessing, in obtaining those logs. And he says the same things about the logs that have been put forward by Mr. Justice Nyangaya. The authenticity and integrity of those logs have not been rebutted. We are treated to an explanation in the affidavit of Mr. Wachira, in particular about the generation of Form 34C. And those rebuttals do not answer the question as to why there are these unauthorized access to the servers of the Iebc and obtaining those particular logs. There is also in the bundle, in the evidence through the affidavit of Mr. Nyangasi, of 2 Form 34Cs, one generated on the day the results of the elections were declared on the 15th of August, and the one that was generated on the 15th of August 2022 is based on the results obtained at the county level. The next day, again, another Form C was generated. All that is in the bundle of Mr. Nyangasi. Another Form 34C. That one was computed on the basis of the results that were obtained from the polling stations. So we got 2 Form 34Cs. There is no explanation given as to why there was those 2 forms. So, Your Lordships, we pray that the orders that we prayed for are justified. But probably in future, there may need to be a thorough inquiry as to what happened. Not just looking at the question of whether Mr. Ruto was validly elected, but looking at the criminality that characterized this entire enterprise. And that is when the Kenyan people will know the truth. But for now, I think the Kenyan people will be happier if this court can make sure that the authority, their sovereign will, is not taken away. I thank you.
Thank you very much for keeping time. We will take one more before we break for lunch. Petition number E001 of 2022, John Njoroge Kamau.
My lady.
I request for indulgence of the court just to introduce 3 people I'm appearing with, but they were in the other room, they didn't get access to court. And that is Emmanuel Bitter, Christopher Marwa, and Radhika Arora, I would like to put them on record. Thank you.
Thank you. That is noted.
My lady, Madam Chief Justice, my lady, the Deputy Chief Justice, my lords and my lady of the Supreme Court, I don't believe I need to introduce myself again, since I did that right at the beginning, but all I wish to state is I appear for the petitioner, Mr. John, I'm so sorry, there was Mr. John Njoroge Kamau, who has been called as a surrogate in some of the affidavits, and unfortunately yesterday was called a proxy. My ladies and my lords, Article 1.1 of the Constitution relates to the sovereignty of the people. Article 3.1 of the Constitution, it is the duty of every Kenyan, and most of us sitting here are Kenyans, to uphold and defend the Constitution. Hence, it is very sad to see that when Wanjiko, or in this case, John Njoroge Kamau, comes to court, he or she is immediately vilified and stigmatized. All he is doing is exercising his constitutional duty and following the law, never wanting to go back to where we went about 15 years ago. And like I said, in social media, everybody gets vilified. We don't need to read social media, as I was told 10 minutes ago. Notwithstanding the same, John Njoroge Kamau, on the 9th of August 2022, in exercise of his constitutional right to vote under Article 38 of the Constitution, went to his polling station to vote for his preferred presidential candidate, and then went home to await the result. It was a long wait for 6 days, but that is not his gripe at all. He is not complaining about the 6 days. As far as he was concerned, he had this legitimate expectation there was going to be a free, fair, credible, accurate, transparent, and verifiable election pursuant to Article 86 of the Constitution. But my poor client, lo and behold, to his shock and horror, at about 4 p.m. on the 15th, a public statement was made by Juliana Cherera, Irene Masset, Justice Nyangaya, and Francis Wanderi, and I will call them as the 4 commissioners because I won't continue to repeat their names. And in that statement, before the declaration of who he wanted to know was his president, before that declaration, they came out and stated that this election was opaque. Subsequently, at about 6:05, the chairperson of the Iebc declared a result to say who the president-elect of the country was, and this was duly gazetted. To confound it all, on the 16th of August, people started calling, and the 4 commissioners started calling this the Chebukati's results. On the 17th of August, 2022, a statement was issued by the chairperson of the IEBC, and I'm not going to get personal here, I will call him by his title that he's got at the moment, stating the reasons why the 4 commissioners, and the drama continues. My ladies and my lord, this is a voter who is watching all this unfold in public. His simple question is, did my vote matter? Or was it Chebukati's result? Or was it an opaque result? What happened? And that's why that's who I am representing. And I'm very curious for myself. Where did my vote go? Did it go anywhere? Or was it not there? My lords and my ladies and my lords, in order to meet the constitutional threshold of being a credible, transparent, verifiable, accurate process. The electoral process must be conducted in strict compliance of the law. We have filed on behalf of the petitioner very extensive submissions. These were filed on the 26th of August 2022. I am caught in a position where I could sit here and reread everything that's been said or everything that has been reiterated by my learned seniors who are, for once in my life, I can say who are much older than me, because normally I'm one of the oldest people in a room, who are much older than me. So I don't wish to repeat everything that they have said, because that we don't have the luxury of time. I will just keep it very, very short, because I am sure your ladyships and your lordships will read the 23-page submissions that we have done. 1. Under Article 138.3 C of the Constitution, it specifically states that after counting the votes at a polling station, Iebc shall, it is not say, may, shall tally and verify the count. That's what our framers said. Article 138.310 now starts distinguishing. It says the chairperson of the Iebc. As yesterday was said by Madam Chief Justice, the framers of the Constitution decided to give you 14 days. It's not easy to complete this election petition. It's got to be done within 14 days. The framers of the Constitution knew exactly what they were doing because of where we had come from, culminating in 2007. Hence, the declaration was to be done by the chairperson, but the verification and tallying, if they wanted to do it by the chairperson, they would have said it. Secondly, if, as is being stated by the chairperson of the Iebc, as he's put in his statement that was issued on the 17th of August, it is me. It is me who has to verify and tally pursuant to regulation. There's a regulation 87.3, which my learned friend Mr. Feroz now took your lordships and your ladyships to. I can do it. If he could do it, why wasn't it said? And if he says he can do it, why do you need a commission of 7 people? Why do we spend so much money, taxpayers' money, on a commission of 7 people? Have 3. This court has ruled that 3 people constitute a commission. Have 3. Why do you need 7? Let's take it further. If it's only him, and according to some of the submissions and arguments that are going to be placed before you, the issue of Schedule 5 regarding quorum, and that he doesn't need quorum, it's only in the normal business. My ladies and my lords, sorry, what exactly does the Iebc do? Voter registration, but what is its main function related to? Elections. It is all about elections. That's what they do. I don't believe there's been much boundary delineation, but I will stand to be corrected on that by my learned friends on this side. They may know a little more than that. And so, if it is only the chairperson whose argument is there is 34A, so there is an announcing declaration there, then there is the polling center, and then it comes to him at the tallying center, and he does it. I still go back to 30 billion shillings on an election, and this is what we've got. It's a very sad state of affairs we are in. One man, let's have a commission of 3, going by what he says. Taking it now to the regulations that he relied upon on the 17th, with your lordship's permission, I would state those regulations, unfortunately, when your ladyships and your lordships decided as my young associates say it in my office, I don't know how they do it, but they say it, Raila and another versus the Iebc of 2017, they claim that according to terminology they use, it's called Raila 2, and then the subsidiary one, the second one that came, when it came for clarification, they call it Raila 2.5. So I don't know why they do that, but that's what the young lawyers do, so I'm going to use their terminology. When Maina Kiai was decided, and this particular Maina Kiai was decided, I believe it was in, I'd written the date down, but Maina Kiai was decided in June 2017. Subsequently, the chairperson of the Iebc came to your lordships and your ladyships asking for a clarification as to exactly how Maina Kiai was interfering with your decisions in Raila 2. It was so clear on what this court said. And the saddest part is, Regulation 87 that he is relying upon was not brought to your attention, and from 2017 to 2022, all Iebc does is hold elections but doesn't look at its regulations. And are these regulations, are these going to be the mundane matters that the Commission has to decide? Because we've been told, besides verifying and telling, the Commission does everything, and those are in their submissions. My lords and my ladies, if you look at my written submissions, and I'm going to take you through them very quickly as to, if you look at, and this is, the page numbers are verified, the case numbers, we've put in a bundle of documents. What that statement of the 17th of August said, if you could look at page 8 of my written submissions, at paragraph 19, from about line 18. And this is a quote from the Maina Kiai case. It is, in our view, fallacious and flies in the face of clear principles and values of the Constitution to claim that the chairperson of the appellant can alone, at the tallying center or wherever, purport to confirm, vary, or verify the results alone. This honorable court further said the same thing in the Raila 2.5, which is set out at page 11 of the submissions at the bottom. And you go to page 12, this is at paragraph 20, and it will be paragraph 292 of the Raila 2.5. The failure by the first respondent, Iebc, to verify the results in consultation with the second respondent, Iebc chairperson, before the latter declared them, therefore went against the expectations of Article 138(3)(3)(c). And there are several quotations I have put in there that show that this court has already made the decision. My biggest fault with the Iebc, and it's not particular the chairperson in himself, for 5 years you did nothing. The Supreme Court told you in October 2017, you can't do this. You do nothing. You amend in April 2017, you leave it at that. There's been hardly any amendments. It doesn't matter who's the Kenyan voter. Iebc, chairperson, we own this. It's an independent commission, but they have to work within the ambit of the Constitution. My ladies and my lord, I'm just going back now. Like I said, I have 15 minutes, and I think I'm going to be at a space where I'm going to be a very patriotic Kenyan, and I'm going to donate the time back to the court, because I don't think I'm going to take the full time to finish my submission, because it's fully set out where we are going to. There are three things that we've brought up. One, is the issue of the Regulation 87, which has to be made unconstitutional. And we have relied upon the court, the judgment of this court in the case of Rai, where you declared Section 14, where Parliament went way beyond the ambit of what this court was supposed to do. We are relying upon that to declare that, because it appears IEBC is never going to come to you, so we might as well do it once every 5 years to see where they've got it wrong. We're requesting you to declare it unconstitutional. We are going further and stating to your lordships, to your ladyships and your lordships, the issue of the elections, of the cancelled elections. Whilst the elections were cancelled in counties or gubernatorial, and an issue has been taken up that if this court has jurisdiction because interpretation of the Constitution is in the High Court. My ladies and my lords, Article 101 actually gives a date cast in stone when our elections are going to take place. General Assembly, Parliament, Presidential, the whole lot. So it is on the second Tuesday of every 5th year. Article 101 read with Article 136 2A, read with Article 177 1A of the Constitution, and 181, clear, cast in stone. We all know why that happened, because initially dates could be set by whoever they wanted to, and you could have a date on the 29th of December for an election where voters were available or not available. That was the history of that in a very narrow way. We now have a situation where elections were cancelled. Today we have a chairperson and an IEBC who are so disconnected. What happens if in 5 years from now somebody decides to cancel a presidential election on the basis of a national emergency? This is something that really struck us when we were looking at this. It was something that had never crossed our mind. It's a hypothetical, yes, but maybe some direction needs to be given on that. Secondly, the suppression of voter turnout and voters being disenfranchised. We've been told this entire election is mathematical. Take a calculator and you'll get a result. That's what I've been told. If it's as simple as taking a calculator, the national tally that was stated by the chairperson was 65.4% or thereabouts. In Mombasa, where there was no gubernatorial election, and that you can work out from simple mathematics as to the number of people who showed up vis-a-vis the number of people, the voter turnout was 44%. In Kakamega, with a national tally of 65.4%, the total number of voter turnout was 57%. Simple mathematics, even saying that the figures we have are correct. And that is where we've come from, because there was a submission that we've not shown anything. Those two counties were way below the national tally. Whose strongholds they were is not my problem. All we are saying is that there was suppression and therefore voters were disenfranchised. You're cancelling an election at 8 o'clock at night on the 8th for voters the following day. You can imagine the confusion. And what was the reason for the confusion? A mix-up in ballots. This is all in our petition. I am just speaking to your lordships because if you read the petition, all the annexures are there. Oh, sorry, oops, we made a mistake in the ballot papers. There was a mix-up. Yet, there was supposed to be gazettement. A replying affidavit by the CEO, and it was supposed to be done by the 1st of July. A replying affidavit put in this petition by the CEO. Oh, we gave it to the national printers, the government printers, but they didn't print it, and so it should be deemed as done. There are news articles saying 128 ballots came to this country with ballot papers on the 7th of July, 6 days after this gazettement, or 7 days. And it is quite clear that there was an issue with the gazettement. It was backdated. But 128 ballots were already there. And the chairman admitted it, that it was there was a problem with the machine at the government printers for the printing. Even if you assume that it was printed on time, it was sent on the 1st of July. The earliest it could have been done was on the 2nd of July, because they haven't given us a time. We are voters, we are just watching this. We are watching this drama unfold. That being the case, and on the 7th, 128 ballots came. That's a lot of ballots and a lot of ballot papers. Nobody checked, like I keep on saying, 30 billion shillings later. We can't get an election right because there's a mix-up in the ballot. And therefore, my ladies and my lords, what is happening here is not a way to have an election at any level. We don't know what is going on as voters. People who are listening to this are getting even more confused as to what is happening out there. Was this accurate? Was this verifiable? It's our humble submission. The commissioners who came out, the disconnect between the commissioners shows that there is a problem. Mr. Chebukati says it is verifiable and accurate. The voter, what does Mr. John Njoroge know? The commissioners are saying it was opaque. Where does the voter go? Has everybody forgotten the voter in all of this? The political parties are saying, I won, I won. We want to know what happened to our vote. And where we are today, we actually cannot say that where this vote went and what happened. And in view of that, it's my humble submission that one, the petition be allowed as prayed. And there is a prayer we've requested for, that there should be a nullification of this election, because the sovereign will of the people has not been, well, like I said, what we see. Whilst this court says an election is a process, for me, and even as a lawyer, and for Wanjiko and for John Njoroge, an election is an event. You're going to the ballot, you're going to cast your vote, and you're hoping that your vote counts. We shouldn't be in a position where we hope that our votes count. We should be in a position where we know our votes count. And whilst there is a prayer which your lordships and ladyships might tell me off about, we have requested that the chairperson be prohibited from conducting any further elections in view of his behavior and or holding any public office in Kenya in breach of Chapter 6 of the Constitution of Kenya. The reason why we've said that is, unfortunately, whilst we created independent offices, we forgot about Chapter 6. And I think this court needs to show the way, even if it's to the lower courts or subordinate courts, show them the way that it's Chapter 6 that is going to be a question of integrity. In view of that, my ladies and my lord, I have nothing to add except if anybody has any questions, and please, can there not be hard questions?
Thank you very much, Council. You have donated to us 7 minutes. Thank you very much.
Thank you
for your generosity. I think we will adjourn. Yes. We will adjourn until 2 p.m., but before we do so, I recognize that we have observers who have joined us. Yesterday, during the pre-trial, we formally recognized the observers, but I think they were not present. So on behalf of the Supreme Court, my sister and brother judges and the entire court, we wish to welcome all the observers, especially the delegation from the Commonwealth that is led by our retired Chief Justice from Tanzania, the Honorable Justice Herman Mohamed Chande, for taking time to come and observe these proceedings. We thank you for taking your time, which is a mark of friendship and also encouragement, and also an indication that we are all pursuing similar objectives of ensuring there is promotion and protection of the rule of law and constitutionalism, and those institutions that guard and sustain our democracy. So you're most welcome to the proceedings, and our gratitude for your finding time with eminent judges, jurists, and other distinguished delegates who have committed their time to come and be part. And having said that, I think we will arise and resume at 2 p.m. Thank you.
Welcome to Mutembei TV. This is Political Day section with me, Samuel Juang. This is a day, the big day Kenyans have been waiting for. And the 7 judges who are going to preside over this particular presidential petition that has been filed by the Right Honorable Raila Odinga and also the likes of Omkia Omtata. We want to take a look at the judges who have been there. We want to take a look at their history and also to understand who are they and what are they capable of doing. Now let's start with Justice Smoking Wanjala. Smoking Wanjala, remember Smoking Wanjala has been there, has been a judge at the Supreme Court for from the year 2012 to the year 2022 right now. So he has got a very good experience at the Supreme Court after presiding over the 2013 presidential petition and also presiding over the 2017 presidential petition and also the second 2017 presidential petition, and this will be the 4th time.
Good morning, ladies and gentlemen. Welcome to the Supreme Court of Kenya for the hearing of Presidential Election Petition number 5 of 2022, as consolidated petitions number 1, 2, 3, 4, 7, and 8 of 2022, the Honorable Raila Odinga and 7 others versus the Honorable William Ruto and others. The Ready Chief Justice will preside.
Thank you very much, our court assistant. Good morning, Learned Council and the parties, distinguished ladies and gentlemen present this morning. We finalized the pretrial issues this morning, and on behalf of the 7 justices of the Supreme Court, we welcome you to this morning's proceedings. We have a tight schedule. Therefore, without much ado, we will ask the petitioner to start their case. But we will take the appearances. The quorum sheet, I believe, has been filled, but we can take the appearances.
My Lady, the Chief Justice and the President of the Court and members of the Court, for the first and second petitioner, my name is James Orengo. I appear with my learned Learned Counsel, Senior Counsel, Firoz Noraji, together with my learned friends, Mr. Paul Mwangi and Ms. Julie Soweto. We also appear with Senior Counsel, Mr. Philip Morgor, is not in the court, but once I've concluded my submissions, he'll come in to continue to deal with an aspect of our case.
May it please Your Ladyship, Chief Justice, Your Ladyship, my lords, for the first and second respondents, the appearance is as follows. My name is Ngatia. I appear together with my learned friend Kioko Kilukumi, Senior Counsel, Mr. Kirago Kimani, Senior Counsel, and Professor Kindiki. That is the team representing the first and second respondents. Thank you.
Madam Chief Justice and the Honorable Judges of this court, my name is Githu Muigai. I appear for Iebc and the second Mr. Wafula Chebukati jointly. I lead that team. The team for Iebc is Eric Gumbo, George Murugu, Dr. Willie Mutumbwa, Mr. Wekesa Simiu, Mr. Wambua Kilonzo, Mr. Moni Mukele, Mr. Mwangi Kibicho, Mr. Peter Wanyama, Miss Maggie Ngetich, Mr. Emmanuel Wetangula, and Miss Mase Mwinzi. The team for Mr. Wafula Chebukati is Abdikadir Mohammed, Senior Counsel, Kamau Karori, Senior Counsel, Michael Mushemi, Mr. Tito Tiego, George Gilbert, Collins Bush, Herman Omiti, Nancy Kangede, Moses Kipkogei, Innocent Muganda, and Mahat Jomen. Thank you very much.
Chief Justice, Deputy Chief Justice, Your Ladyship, my Lords, Justices of the Supreme Court, Paul Muite, in terms of the orders of this Honorable Court yesterday, Issa and I, in addition to the lawyer counsel on record for the fifth respondent, the sixth respondent, seventh respondent, and eighth respondents. In summary, the four commissioners, in addition to the respective counsel appearing for them, we've agreed in terms of the orders of this court that Issa and I will act collectively for the four commissioners whose views need to be heard. I need to add, for the sake of clarity, that we are not asking for any extra time. We will address this Honorable Court on behalf of those four commissioners by sharing time with the individual counsel for each of the commissioners. I thank you.
Your Ladyship, Madam Chief Justice, Deputy Chief Justice, and judges of appeal, for the fifth petitioners, I appear together with Lydia Mwalimu and Millie Odhiambo not in court. Okiya Omtata will appear in person. I think that is in order. My name is Professor Tom Ojenda, Senior Counsel, just for record so that I don't come back.
Your Ladyship, the Chief Justice, Your Ladyship, the Deputy Chief Justice, my Lady, my Lords of the Supreme Court, my name is George Oraro, appear for the Attorney General.
Madam Chief Justice, Madam Deputy Chief Justice, judges of the Supreme Court, my name is Jan Mohammed. I appear with Mrs. Wambugu for the second petitioner when you had consolidated the cases yesterday.
Your Ladyship, the Chief Justice, members of the court, together with Tom Masharia, Njoki Mboshe, Steve Wandeto, John Njomo, and Paul Kiragu, I am Paul Nyamodi for the third petitioner.
You may please, my Lady Chief Justice, Deputy Chief Justice, my Lady Justice Njoki Ndogo, and my Lords, I'm Mutieno Willis. I do appear together with Mr. Nelson Osiemo, Ms. Caroline Kituku, Ms. Lea Chanimbanga, and Mr. Victor Oduol for the fourth petitioner.
May it please you, my Lady Chief Justice, my Lady the Deputy Chief Justice, and the Justice of the Honorable Court. My name is Degwanjiro, together with Mr. Mituga and Mr. Morara. We appear for the fifth petitioner.
My Lady, my name is Ochiel Dudley for the International Commission of Jurists, as Amicus Curiae, the second amicus. I appear alongside Mr. Isaac Okero and Ms. Anne Ngige. Thank you.
May it please the court, my Lady the Chief Justice, Deputy Chief Justice, and other judges of the Honorable Court. My name is Kibe Mongai, appearing for the seventh petitioner alongside Ms. Wairimo Keru.
Mr. Emmanuel Wetangula and Ms. Mase Mwinzi. The team for Mr. Wafula Chebukati is Abdikadir Mohammed, Senior Counsel, Kamau Karori, Senior Counsel, Michael Mushemi, Mr. Tito Tiego, George Gilbert, Collins Bush, Herman Omiti, Nancy Kangede, Moses Kipkogei, Innocent Muganda, and Mahat Jomen. Thank you very much.
Chief Justice, Deputy Chief Justice, Your Ladyship, my lords, justices of the Supreme Court, Paul Muite, in terms of the orders of this honorable court yesterday, Isa and I, in addition to the lawyer counsel on record for the 5th respondent, the 6th respondent, 7th respondent, and 8th respondent. In summary, the 4 commissioners, in addition to the respective counsel appearing for them, we've agreed in terms of the orders of this court that Isa and I will act collectively for the 4 commissioners whose views need to be heard. I need to add, for the sake of clarity, that we are not asking for any extra time. We will address this honorable court on behalf of those 4 commissioners by sharing time with the individual counsel for each of the commissioners. I thank you.
Your Ladyship, Madam Chief Justice, Deputy Chief Justice, and judges of appeal, for the 5th petitioners, I appear together with Lydia Mwalimu and Millie Odhiambo, not in court. Okiya Omtata will appear in person. I think that is in order. My name is Professor Tom Ojenda, Senior Counsel, just for record so that I don't come back.
Your Ladyship, the Chief Justice, Your Ladyship, the Deputy Chief Justice, my Lady, my Lords of the Supreme Court, my name is George Oraro, appear for the Attorney General.
Madam Chief Justice, Madam Deputy Chief Justice, judges of the Supreme Court, my name is Jan Mohammed. I appear with Mrs. Wambugu for the 2nd petitioner when you had consolidated the cases yesterday.
Your Ladyship, the Chief Justice, members of the court, together with Tom Masharia, Njoki Mboshe, Steve Wandeto, John Njomo, and Paul Kiragu, I am Paul Nyamodi for the 3rd petitioner.
You may please, my Lady Chief Justice, Deputy Chief Justice, my Lady Justice Njoki Ndogo, and my Lords, I'm Mutieno Willis. I do appear together with Mr. Nelson Osiemo, Ms. Caroline Kituku, Ms. Lea Chanimbanga, and Mr. Victor Oduol for the 4th petitioner.
May it please you, my Lady Chief Justice, my Lady the Deputy Chief Justice, and the Justice of the Honorable Court. My name is Degwa Njiro, together with Mr. Mituga and Mr. Morara. We appear for the 5th petitioner.
My Lady, my name is Ochiel Dudley. For the International Commission of Jurists, Amicus Curiae, the 2nd amicus, I appear alongside Mr. Isaac Okero and Ms. Anne Ngige. Thank you.
May it please the court, my Lady the Chief Justice, Deputy Chief Justice, and other judges of the Honorable Court. My name is Kibe Mongai, appearing for the 7th petitioner alongside Ms. Wairimo Keru.
Honorable Chief Justice, good morning, members of the court. On behalf of the Law Society of Kenya's amicus, my name is Stephen Mwenesi. I am in this matter alongside the President of the Law Society, Mr. Eric Theuri, and we have a team of the Public Interest Litigation Committee guided by Counsel Maura Kabata and Dr. Musau and Dan Oino Kemo and others. I thank you for allowing us to participate.
Thank you very much. We have taken the appearances. We will straight away go to the petitioner's case.
It may please the court, I'm going to deal with the issue number 6 amongst the 9 issues that were crafted by the court for purposes of determination. And yes, and my learned friends, Mr. Firoz Norji, will deal with the issues captured in number 8 and 9. And my learned friend, Mr. Mwangi, will deal with the issue number 6. My learned friend, Mr. Philip Murgor, will deal with the issue number 1, 2, and part of 3. And my learned friend, Ms. Julie Soweto, will deal with the issues 3, 4, 5. I appear together with my colleagues for the first and second petitioners in the consolidated petition. The petition was filed on the 22nd of August this year, following the declaration of the results of the presidential elections that were held in the general elections on the 9th of August 2022. And those results were declared on the 15th of August 2022. Following that declaration, the petitioners, the first and second petitioners, were aggrieved with that announcement and consequently filed this petition. The petition is accompanied with a host of affidavits, and it may please the court, I'll refer to about 5 or 6 affidavits in my address. But as a matter of opening, I would want to deal with some constitutional issues as set out in the various articles of the Constitution. My lords and my ladies, after many years, the Kenyan people came about with the Constitution 2010. They enacted this, the Constitution 2010, and as opposed to the previous occasions, we had a constitution which was enacted by the people, in which they declared their sovereign authority. Therefore, anything done in the name of the Republic, in exercise of powers that spelled out in the Constitution, is based on donated or delegated authority as set out in Article 1 of the Constitution. Now, my lords and my ladies, it is important to put into consideration Article 2 on the supremacy of the Constitution, together with Article 3, which talks about the defense of the Constitution. As opposed to the previous periods when we had a constitution which was negotiated at the time of independence with the colonial authorities, this constitution established a republic in which the doctrine of separation of powers was embedded. And more particularly, my lords and my ladies, in this constitution, there are several constitution bodies and agencies that were created, which includes the first respondent, the Independent Electoral and Boundaries Commission. And in accordance with the dictates of the Constitution, the Independent Electoral and Boundaries Commission, just like any other body established under the Constitution, and for that matter, any person who resides in the Republic of Kenya is required not only to recognize the supremacy of the Constitution, but act in accordance of the Constitution and in defense of the Constitution. Under Article 249, all independent offices and independent commissions are required to respect the sovereignty of the people and also to promote constitutionalism. This is important because Article 249, as read with Article 88 of the Constitution, which vests powers on or to the Independent Electoral and Boundaries Commission, requires that those powers must be exercised in accordance with the Constitution. Now, my lords and my ladies, the story that emerges out of the events that occurred on the 9th of August this year, and subsequently following to the 15th of August, upon the declaration of the Constitution, of the elections, the presidential elections, goes contrary to the established provisions in the Constitution, and will enumerate those violations at the appropriate time. But in opening, I want to say this, my ladies and my lords, that this grievance that we place before you, the highest court in the land, is not just a conspiracy theory. It is not just any ordinary event. If you look at the evidence that is placed before you in totality, we invite your lordship to come to the conclusion that what happened on the 9th of August this year and the subsequent events that followed on the 15th of August mark a pattern of violations against the Constitution in order to undermine the authority of the sovereign will of the people, and in effect preside, that is the commission, preside over an election that in effect did not represent the will of the people of Kenya. Now, in saying this, my ladies and my lords, you will be taken through a host of evidence borne out in the affidavits that show clearly that the Electoral Commission, just like they did in 2017, did not preside over an election that was in accord with the requirements of the Constitution as laid out in Article 81 of the Constitution. Article 81 of the Constitution requires that an election held in the Republic of Kenya should abide by the general principles set out in that article, and more particularly, Article 81 Article 81E that the elections must be free and fair, and Roman 4, the elections must be transparent, and Roman 5 of that article, that the election should be administered in an impartial, neutral, efficient, accurate, and accountable manner. My lords and my ladies, I want to emphasize the words accurate and accountable manner. And those provisions in Article 81 read together with Article 86, which requires that at every election, the Independent Electoral Commission shall ensure that whatever voting method that is used, the system is simple, accurate, again, the word accurate, verifiable, secure, accountable, and transparent. And more importantly, that the votes cast are counted, tabulated, and the results announced promptly, and that is at the polling stations. My lords, you would notice that as we appear before you today, we have something that has never happened in this country, that you have a commission that is divided right in the middle. That speaks to a dysfunctional constitutional body that is not capable, leave alone the transgressions that we are going to talk about. But we are talking about an electoral commission that is dysfunctional and cannot be able to preside over an election that would give it the stamp of legality and legitimacy as spelled out in the Constitution. And I think that is a matter that this court should not disregard. And we'll come to that a little later in our address. Indeed, the Tower of Babel has been brought down by the appearance of two factions within the commission before your lordships and my ladies. And this, in event, has created a situation where no Kenyan can believe that the pronouncement of the first, of the ninth, I think the second respondent, Mr. William Samoei Ruto, as president-elect, came out of circumstances as envisioned in the Constitution of the Republic of Kenya. And your lordships, we would invite you, and my learned friends are going to address you on this point as to what really happened within the commission. Now, coming to the subject matter that I'm going to address you on in the question of the issue number 7, that states that the declared president-elect, whether the declared president-elect attained 50% plus 1 vote of all the votes cast in accordance with Article 138, sub-Article 4 of the Constitution. We want to persuade you that the second respondent never attained that constitutional threshold. And going back to the Constitution on that particular article, Article 138, sub-Article 4, it was made part of the Constitution by the framers of the Constitution to give legitimacy to anybody elected as president, to the effect that he had widespread support of the Kenyan people, and that is evidenced by the requirement that the president-elect must have at least 25% of the votes cast in each of the more than half of the counties. We are not dealing with that point. We're dealing with Article 4A, that it is a requirement, mandatory requirement, that the person elected as president must receive more than half of all the votes cast in the election. Now, talking about numbers in those two provisions speaks to the need for accuracy and accountability to give an election the legitimacy that the holder of that office would carry while exercising the powers of the President of the Republic of Kenya. And it's not an idle matter, because we went through an experience, before the enactment and proclamation of this Constitution, that a person would be elected by way of a simple majority, and in circumstances in which you would find that the person elected as president did not garner more than half the votes which are cast in a presidential election. So this is an important matter. And the difficulty about this particular article is that it requires, at the end of an election before the declaration, that the Commission carries out some mathematics, some mathematical calculation and computation based on proper returns of the votes that were cast in the polling stations and transmitted, as it were, the results thereof to the National Tallying Center and verified accordingly in terms of the Article 38 and the Elections Act. Now, my lords and my ladies, my starting point would be the fact that in this election, it was declared that, and that is found in paragraph 7 of our petition, that the second respondent in the declared result garnered 7,176,141 votes, which according to the Electoral Commission represented 50.49% of the votes cast in the election. Now, this figure would be correct depending on the calculations that were carried out or computation done by the Electoral Commission based on the votes cast during the elections held on the 9th of August 2022. Now, the complaint on this in this particular regard is contained in paragraph 43 to paragraph 48 of the petition. And for purpose of clarity, with your permission, my lords and my ladies, I would want to read out those particular paragraphs of the petition so that I can properly put it in context. Paragraph 43 avers that the number of voters who turned out to vote in the general election held on the 9th of August 2022 remains indeterminate. The second respondent has been issuing contradictory figures on the voter turnout. On the 9th of August 2022, on or about 1600 hours, 1 hour before the close of polls, the first respondent reported through various public news media outlets the voter turnout around the country was fairly low and was at an average of 52% of the registered number of voters. On 10th of August 2022, at or about 13 hours, in his first media briefing to the public following the close of polling, their second respondent announced that the total voter turnout in the general election as captured in the electronic voter identification kits, that is the KIM kits, was 65.4%, equivalent to 14,466,779 voters. Roman 3, the second respondent, however, indicated that he expected the above number to rise once the number of votes identified manually was taken into account. Contrary to the above declaration and reasonable legitimate expectation, the final voter turnout captured and declared in the final results of the presidential election in Form 3C is stated to be 213,137 votes, which is absurdly lower and not higher as anticipated. Notwithstanding a computation using addition of the valid votes in figures for the presidential elections, candidates in the aggregate results shows that the total number of valid votes is 14,213,027. Now, my ladies and my lords, the first point that is being made there, that if you look at the results as announced by the Electoral Commission and what is stated in Form C as the turnout of voters, and that is 14,213,137 votes. If you compute or add the number of votes cast for each candidate individually, that is the petitioner, the second respondent, and the two other candidates, that the figure that results is not the figure that was stated in Form 34C. The figure is 14,213,037. That is the first point. And this is important because as we proceed, we are going to demonstrate that the number of voters who took part in the elections and the number of votes cast in the election is indeterminate and is a moving target. It keeps on shifting. And I invite your lordships and my ladies to look at the results as set out in Form 34C and I equally invite the court to calculate the number of votes garnered by each of the presidential candidates. The figures do not agree at all. And therefore, the first point of reference, as it were, is that the computation of the figure 50 plus 1 was based on a wrong computation of the total votes cast, as it were, and as proclaimed by the chairman of the Independent Elections and Boundaries Commission. Now, this may be a mathematical paradox or even a conundrum. The numbers of voters who turn out to vote as declared by the Independent Electoral and Boundaries Commission should be the same as the number of voters that are declared emanating from the Kim's kids, because the source of the number of voters that have cast their votes can be garnered in two ways: by looking at the numbers as recorded in the Kim kits, or at the end of the election exercise by computing the number of votes cast in the election. And my ladies and my lords, you would find that in this election, again, if you take the number of votes, or rather of the voter turnout, which was 65.4%, 65.4%, as against the number of registered voters in Kenya, that, my lords and my ladies, would give you the figure of those who turned out to vote. Because the percentage of the registered voters who are declared as having turned out to vote must be the same as the number of voters actually whose votes are counted as valid votes cast, and of course minus what are characterized as rejected votes. So, my lords, if you look at that particular point, and we're going to go through this one, you will find that the chairman of the Electoral Commission, in his announcement of the final results as borne out in Form 34C, and his announcement of the turnout of voters, which is recorded as at 65.4%, is at variance. And therefore, his calculation of the results based on the percentages cannot be correct. In this exercise, I invite you in this exercise, I invite the court to look at the affidavit of one Edgar Ouko Otumba. That affidavit is two affidavits, a supplementary affidavit, and the first affidavit, which he filed on the 22nd of August. And my lords, in that affidavit, he makes the case, and Mr. Otumba has got a doctorate degree in applied statistics from Maseno University, and indeed he did assist this court in the previous petition in 2017. And he talks to the difficulties, that confronts us in terms of the various announcements that the chairman of the Electoral Commission made. And he states that on the 9th of August 2022, the respondent issued a communique, that is on paragraph 10 of his affidavit, on the day of the election, that the total voter turnout at 4 p.m. nationwide was at 56.17%. And that statement update is annexed to the affidavit sworn by the second petitioner, Madam Martha Karua. Then, at the close of the voting, the first respondent again issued a statement that the total number of voter turnout based on the KIMS kit, was 65.4%, which culminates in a total of 14,466,779 votes. And that communique is borne out in the affidavit again of the second petitioner. In an affidavit that is sworn on behalf of the petitioners, first and second petitioners, Mr. Nyangasi Oduo, in his affidavit, he talks to the Form 34C, and I'd referred to this earlier, where the total number of vote cast is 14,213,000. Now, the same Mr. Edgar Otumba saw a supplementary affidavit on the I think this affidavit was sworn on just a minute. On the 20th of August 2002. And I invite you, my ladies and your lordships, to look at this affidavit, because it analyzes several scenarios, including scenarios where the rejected votes are not computed, and scenarios where the declaration made by the chairman of the Electoral Commission as to the manual votes which were cast, which were recorded 86,889, and where those votes recorded as manual votes are computed together with the votes that were transmitted electronically. And then scenarios that would include the constituencies where the votes were declared later, including Ella's constituency. Now, the central point, and I want to make this point again, that the case that we are trying to make out is that if you look at the declaration made by the chairman as to the voter turnout, that will give you, as a percentage of the total number of registered voters, it will give you the number of voters that turned out to vote in the election, as opposed to another way of arriving at the same result, simply counting the number of voters that were recorded to have voted and cast their vote in the election. It is an equation that must agree in a mass submission. If the total number of voters that take part in the election do not agree with the votes that are counted as cast in accordance with Article 138(4), if they don't agree, then it means that the results of that election are not accurate, they're not transparent, and they're not accountable. And therefore, I'm inviting your ladyship and your lordship to go through this affidavit of Mr. Edgar Uko Otumba, because he lays out clearly there's several scenarios in which it is quite clear the second respondent, one William Samoei Ruto, could not have garnered 50% plus one of the vote cast in the election. And since all that is in our submissions, and is in the two affidavits that I refer to. I invite your ladyship and your lordships to go through, and you find that it is indeed very compelling, the analysis given out by Dr. Edgar Otumba. Now, your ladyship and my lords, I'd also invite you to look at the affidavit of one Celestine Anyango Opio, and in that affidavit, which enumerates several constituencies, including Chepalungu and many others, where in terms of the results as transmitted to the public portal, there was a systematic deduction of the votes cast for the first petitioner. And the same number of votes that were deducted from the petitioner were added to the votes of the second respondent. And the unique thing about this scheme is that the number of votes cast, the total number of votes cast, remained the same. The difference only was to the extent that the same number of votes that was the petitioner were given to the second respondent. And I leave that to your lordships to look through when you retire, because the Form 34As, in respect of those particular polling stations, attached to the affidavit of Celestine Anyango Opio. There is also the affidavit, two affidavits from Arnold Ochieng Oginga, and this is particularly important because it contains discrepancies of the results in several areas, and in voter turnout in Form 334C and the KIMS kit. And all this, my ladies and my lords, taken in totality, would affect the results of the elections. In paragraph 16, up to the end, he goes out analyzing areas where there were discrepancies, and you would notice, my lords and my ladies, that in totality, the discrepancies accounted for votes which are more than 140,000 votes. And in our submission, that has an impact on the result of the elections as declared. And I invite your lordships and my ladies to look at those particular analysis and annexures attached to the affidavit of Arnold Oginga. In the same way, in a further affidavit, Mr. Arnold Ochieng Oginga carries out an analysis in response to the responses to the petition by the respondents. And my lords, again, you would notice the number of votes that were being manipulated in order to secure a result that would favor the second respondent. And we have attached the relevant documentation, the forms showing the results, from 34As, 34Bs, those particular forms. And finally, the Form 34B, which is a collation of votes at the constituency tallying centers. Now, my lords, I would conclude by saying that unlike many elections, this particular election, there was deceit, there was manipulation, and all this was premeditated and made possible by the attack, if I may put it that way, on the IT structure and system of the Electoral Commission. The way that the Commission was able to deal with the forms when uploaded and downloaded, staged, transmitted, deleted, all this in totality, if you look at the case we put before you, my lords and my ladies, set out in the affidavits that I referred to, shows an election that was rigged in favor of the second respondent. And on that basis, my lords, we urge that you nullify the elections on the basis of the fact that the second respondent did not attain more than 50% plus one of the votes cast in the election. I thank you. I now invite Ms. Julie Soweto to deal with the second limb of our submissions.
Good morning, my ladies and my lords. I will deal with issue number 3, 4, and 5 as identified by the court, and that is whether there was a difference between Forms 34A uploaded on the IEBC portal and the Forms 34A received at the National Tallying Center and Forms 34A issued to the agents at the polling stations. I will start with that issue. My ladies and my lords, the evidence that we supply for that issue is contained. First of all, the complaint is at paragraphs 81 to 91 of the petition, and the evidence is contained in the affidavits of Celestine Anyango, Arnold Ochieng Oginga, Benjamin Agina, and Benson Wesonga. My lady, in Celestine Anyango's affidavit, the complaint is made that in 41 forms from the polling stations that she looked at, the Forms 34A received by the petitioner's agents vis-a-vis the Forms 34A uploaded in the IEBC portal and those brought to the tallying center are different. The sampled forms were from Bomet, Kiambu, and Kakamega counties. The evidence is at page 18 to 106 of the affidavit of Celestine Anyango. My ladies and my lords, this evidence should be considered together with the evidence in the affidavit of Benjamin Agena, sworn for the petitioner, paragraph 9. Which deals with the Forms 34A that the petitioner, the IEBC had stated it would procure, and the features in those forms that should have been used in the election. It is our contention that what the IEBC set out to procure is not what they procured in the first instance. Therefore, we cannot even match the forms that we have and that have been provided in the election to what they had set out to procure. We have stated in paragraph 110 of the petition, from paragraphs 108 to 110, that the IEBC procured 2 parallel sets of Forms 34A, marked booklets 1 of 2 and 2 of 2. It was intended that only booklet 1 of 2 would be used at the polling station, while booklet 2 of 2 was to be placed in a tamper-proof envelope and not to be used at the polling station. The forms that have been transmitted, of the forms that were used to transmit the results in this election 2022, do not meet the standards or conform to either of the forms that the IEBC said were going to be used, and this evidence is in the affidavit of Benjamin Agena. That is the first limb of the evidence that we submit through Celestine Anyango that shows the deliberate mischief in the use of the statutory forms that was set out in the election and which we now complain of. Going now to the evidence provided by Celestine Anyango in the 41 forms, what was observed is that the forms that the agents have and the forms in the portal are the same in all features. They have the same serial numbers. They are embossed using the same stamps. They're signed by the same agent, presiding and deputy presiding officers. However, the figures in the forms have been tampered with and are different with regards to the results for the first petitioner and the results of the first respondent, William Samoei Ruto. It is in the forms, or the sample of forms, the 41 sample of forms exhibited by Celestine Anyango, that votes have been reduced from the first petitioner and added to the first respondent. We have calculated the total number of votes reduced from the first petitioner and added to the first respondent, and they add up to 2,793 votes. My ladies and my lords, we contend that the figures are important because of the slim margin with which the first respondent won the election or was declared as the winner in the election. And the court, we asked the court to keep a note on that. My ladies and my lords, the difference between the result declared to overcome the 50% plus one threshold is 69,000 votes. 0.49%, which is the margin that the first respondent is said to have overcome the constitutional threshold, is the equivalent of 69,000 votes. And therefore, when we look at the results and the numbers that we will show have been tampered with, either reduced or removed from the first petitioner's votes, we will show that those discrepancies affect the outcome of the election or the result of the election. We have already shown that there is 2,793 votes removed from the first petitioner and added to the first respondent. There is also from Kakamega County the example where votes would be deducted from the first petitioner, but not added to any particular candidate. The mischief that is also borne out in our affidavits is that the intention was to ensure that the total number of voters remained exactly the same. So, for example, just a minute. I beg your pardon. At page 2 of the affidavit of Celestine Anyango's affidavit, at paragraph 4, my lady, just as an example, in Chepalungu, polling station 1 of 1, the first petitioners and the physical copy of the Form 34A that was given to the agent, the first petitioner had 61 votes. In the form that was uploaded, or that is appearing in the Iebc portal, the first petitioner has 1 vote. In the Form 34A of the same polling station, the first respondent, William Ruto, had 109 votes. In the Form 34A in the Iebc portal, William Ruto has 169 votes. The 60 votes that are reduced from the first petitioner are added to William Ruto. The total votes remain the same. The same continues in all the 41 polling stations that we have sampled and annexed to the affidavit. Similar to that issue is the evidence sworn by, in the affidavit sworn by Arnold Odinga at page 4 to 13, where he highlights discrepancies in the Forms 34A issued to the petitioner's agents and the ones uploaded by the first respondent, sorry, not the first, the Iebc, in the public portal. Arnold Odinga sampled polling stations, 25 polling stations in Baringo, 15 polling stations in Nairobi, and he finds the same results as Celestine Onyango, where a total of 1,570 votes are added to the votes of the first respondent, William Samoei Ruto, that are not borne out by the original Forms 34A issued to the agents. From the affidavits or the evidence of Celestine Onyango and Arnold Odinga, we conclude or find that the total number of votes deducted from the first petitioner and added to the first respondent is 4,463 votes. The second issue that I will deal with, my lady, is issue number 4, which is whether the postponement of the gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kachaliba, Rongai, and Pokot South constituencies, and the electoral wards in Nyaki West in North Imenti constituency and Kwanjenga in Embakasi South constituency resulted in voter suppression to the detriment of the petitioners in petition number E005 of 2022. The evidence that we rely upon for this is also in the affidavit of Celestine Onyango, Arnold Odinga, and the affidavit of Ezra Sunguti, who was an agent of the petitioners in petition number E005 of 2022. My ladies and my lords, the first complaint and the issue in this matter is that the elections, first of all, were cancelled only in the strongholds of the first petitioner. That is the consistent theme with all the counties or constituencies where the elections were cancelled. Therefore, as the election started, the first petitioner did not start equally with the first respondent. Ezra Sunguti deposed in his affidavit that polling stations did not open at the stations where he was manning as late as 1 p.m. due to failure of KIMS kits. One of the questions that we want to ask, because consistently the KIMS kits appear to have failed in the same region, in the strongholds of the first petitioner. It cannot be
number 1, 2, 3, 4, 7, and 8 of 2022. The Honorable Raila Odinga and 7 others versus the Honorable William Ruto and others. The Ready Chief Justice will preside.
Thank you very much, our court assistant. Good morning, Running Council and the parties, distinguished ladies and gentlemen present this morning. We finalized the pretrial issues this morning, and on behalf of the 7 justices of the Supreme Court, we welcome you to this morning's proceedings. We have a tight schedule. Therefore, without much ado, we will ask the petitioner to start their case. But we will take the appearances. The quorum sheet, I believe, has been filled, but we can take the appearances.
Lady, the Chief Justice and the President of the Court and members of the Court, for the first and second petitioner, my name is James Orengo. I appear with my learned Senior Counsel, Firoz Noroji, together with my learned friends, Mr. Paul Mwangi and Ms. Julie Soweto. We also appear with Senior Counsel, Mr. Philip Morgor. He is not in the court, but once I've concluded my submissions, he'll come in to continue to deal with an aspect of our case.
May it please Your Ladyship Chief Justice, Your Ladyship, my lords, for the first and second respondents, the appearance is as follows. My name is Ngatia. I appear together with my learned friend Kioko Kilukumi, Senior Counsel, Mr. Kirago Kimani, Senior Counsel, and Professor Kindiki. That is the team representing the first and second respondents. Thank you.
Madam Chief Justice and the Honorable Judges of this court, my name is Githu Muigai. I appear for Iebc and the second and Mr. Wafula Chebukati. Jointly, I lead that team. The team for Iebc is Eric Gumbo, George Murugu, Dr. Willie Mutumbwa, Mr. Wekesa Simiu, Mr. Wambua Kilonzo, Mr. Moni Mokele, Mr. Mwangi Kibicho, Mr. Peter Wanyama, Miss Maggie Ngetich, Mr. Emmanuel Wetangula, and Miss Mase Mwinzi. The team for Mr. Wafula Chebukati is Abdikadir Mohammed, Senior Counsel, Kamau Karori, Senior Counsel, Michael Mushemi, Mr. Tito Tiego, George Gilbert, Collins Bush, Herman Omiti, Nancy Kangede, Moses Kipkogei, Innocent Muganda, and Mahat Jomen. Thank you very much.
Chief Justice, Deputy Chief Justice, Your Ladyship, my Lords, Justices of the Supreme Court, Paul Mwite, in terms of the orders of this Honorable Court yesterday, Issa and I, in addition to the lawyer counsel on record for the 5th respondent, the 6th respondent, 7th respondent, and 8th respondent. In summary, the 4 commissioners, in addition to the respective counsel appearing for them, we've agreed in terms of the orders of this court that Issa and I will act collectively for the 4 commissioners whose views need to be heard. I need to add, for the sake of clarity, that we are not asking for any extra time. We will address this Honorable Court on behalf of those 4 commissioners by sharing time with the individual counsel for each of the commissioners. I thank you.
Your Ladyship, Madam Chief Justice, Deputy Chief Justice, and Judges of Appeal, for the 5th petitioners, I appear together with Lydia Mwalimu and Millie Odhiambo not in court. Okiya Omtata will appear in person. I think that is in order. My name is Professor Tom Ojenda, Senior Counsel, just for record so that I don't come back.
Your Ladyship, the Chief Justice, Your Ladyship, the Deputy Chief Justice, my Lady, my Lords of the Supreme Court, my name is George Oraro, appear for the Attorney General.
Madam Chief Justice, Madam Deputy Chief Justice, Judges of the Supreme Court, my name is John Mohammed. I appear with Mrs. Wambugu for the 2nd petitioner when you had consolidated the cases yesterday.
Your Ladyship, the Chief Justice, members of the court, together with Tom Masharia, Njoki Mboshe, Steve Wandeto, John Njomo, and Paul Kiragu, I am Paul Nyamodi for the 3rd petitioner.
You may please, my Lady Chief Justice, Deputy Chief Justice, my Lady Justice Njoki Ndogo, and my Lords, I'm Mutieno Willis. I do appear together with Mr. Nelson Osiemo, Ms. Caroline Kituku, Ms. Lea Chanimbanga, and Mr. Victor Oduol for the 4th petitioner.
May it please you, my Lady Chief Justice, my Lady the Deputy Chief Justice, and the Justice of the Honorable Court. My name is Degwa Njiru, together with Mr. Mituga and Mr. Morara. We appear for the 5th petitioner.
My lady, my name is Achiel Dudley for the International Commission of Jurists as Amicus Curiae, the second amicus. I appear alongside Mr. Isaac Okero and Ms. Anne Ngige. Thank you.
May it please the court, my lady the Chief Justice, Deputy Chief Justice, and other judges of the Honorable Court. My name is Kibe Mongai, appearing for the 7th petitioner alongside Ms. Wairimo Keru.
Honorable Chief Justice, good morning. Members of the court, on behalf of the Law Society of Kenya's amicus, my name is Stephen Mwenesi. I am in this matter alongside the President of the Law Society, Mr. Eric Theuri, and we have a team of the Public Interest Litigation Committee guided by Counsel Maura Kabata and Dr. Musau and Dan Oino Kemo and others. I thank you for allowing us to participate.
Thank you very much. We have taken the appearances. We will straight away go to the petitioner's case.
It may please the court, I'm going to deal with issue number 6 amongst the 9 issues that were crafted by the court for purposes of determination. And yes, and my learned friends, Mr. Firoz Norji, will deal with the issues captured in number 8 and 9. And my learned friend, Mr. Mwangi, will deal with the issue number 6. My learned friend, Mr. Philip Murgor, will deal with the issue number 1, 2, and part of 3. And my learned friend, Ms. Julie Soweto, will deal with the issues 3, 4, 5. I appear together with my colleagues for the first and second petitioners in the consolidated petition. The petition was filed on the 22nd of August this year, following the declaration of the results of the presidential elections that were held in the general elections on the 9th of August 2022. And those results were declared on the 15th of August 2022. Following that declaration, the petitioners, the first and second petitioners, were aggrieved with that announcement and consequently filed this petition. The petition is accompanied with a host of affidavits, and it may please the court, I'll refer to about 5 or 6 affidavits in my address. But as a matter of opening, I would want to deal with some constitutional issues as set out in the various articles of the Constitution. My lords and my ladies, after many years, the Kenyan people came about with enacted this the Constitution 2010, and as opposed to the previous occasions, the constitution which was enacted by the people, in which they declared their sovereign.
So list of the packages that we have, you can see they're not in a package. So put them together. Those should be the votes that are cast. Not packaged, but they are there. Yeah.
Votes cast?
Yes. Yeah, just record that they are not inside a sealed package, isn't it? An envelope.
These are votes cast.
There are how many rolls? That's one.
This 1, 2,
3, 4.
3, 4. So they can for this is a bunch. We count each.
No. We'll open. Just put them aside. Let's deal with the next packages.
So this is a used schemes supervisor validation forms. Oh, okay.
The third one?
Third one is a unused ballot paper, presidential. Fourth is used counterfoils, presidential. This unused form 32.
Unused form 32. Mm-hmm.
Unused schemes supervisor validation form. Next package. Unused tally sheets.
Or even constitutional.
Governor booklet. Presidential result booklet. Unused presidential seals. Correction. Used presidential seals. Stray ballot papers.
This year, and it starts from the second paragraph. It states in the second paragraph that in my capacity as the chairperson of the commission, I was the returning officer of the presidential election. He then goes on later on in the affidavit at paragraph 45 to state that for the proper management of roles at the tallying center of the presidential elections, I had designated in writing specific roles to each of the commissioners and other commission staff. Annexed here to as WWC 9 is a bundle containing the said communication. Again, this bundle and this communication is important, members of the court, because it states clearly what the other commissioners or the roles that the chairman had designated the other commissioners to do. At page 41, there is an internal memo or a letter signed by the chairman on the 22nd of July, addressed to the vice chairperson Juliana Cherere and Commissioner Molu Boya Molu. And it is headed Appointment to the Media and Call Center Management Team for the Presidential Tallying Center, Bomas of Kenya. And he goes on, he says, consequently, you are hereby appointed to the Media and Incident Reporting Team of the Presidential Election Tallying Center as follows. Juliana Cherere, Team Leader. Commissioner Boya Molu, Alternate Team Leader. And their roles are set out there. Terms of reference of your appointment provide liaison between the Presidential Returning Officer, who is himself, and the National Communication Center, preparing periodic briefs for the Presidential Returning Officer to address the media, briefing the Presidential Returning Officer on electoral activities across the country. Nothing to do with tallying and verification. The two subjects of that letter are commissioners of the IEBC. The next letter is on page 42, also dated the 22nd of July. This one is addressed to Commissioner Francis Wanderi and Commissioner Irene Masit. Again, under the hand of the chairman, and it is appointment to the Logistics, Welfare and Security Team at the Presidential Tally Center, Bomas of Kenya. Again, he appoints them in the second paragraph. Consequently, you are hereby appointed to oversight, provide policy direction and strategy formulation for the Welfare and Security Team of the Presidential Election Tallying Center. He then states their names and he states their terms of reference as security of the Tally Center and installations, the Tallying Center's logistics, planning and organization, security of members of the commission, staff, VIPs and other visitors, transport for commission staff, any other duties assigned. Important, those are two commissioners. None of them has been assigned to tally and verify. The third letter is on page 43, and this one is addressed to Commissioner Justus Nyang'aya. Again, Justus Nyang'aya is appointed to be in charge of dignitaries and protocol. And in the second paragraph, he is told that as team leader for dignitaries and protocol, he will be responsible for providing support services to the commission, managing protocol of dignitaries and VIPs, managing access to the Presidential Tally Center for accreditation, for accredited media, observers and agents, and any other responsibility. Now, those are out of 6 commissioners. Those are 5 commissioners. None of them is assigned to tallying and verification. There is a last letter, also dated the 22nd of July on page 44. This one is addressed to Commissioner Professor Abdi Guliye and Mr. Marjan Hussein Marjan. I wish to point out to this court and ask the court to note that Marjan Hussein Marjan is not a commissioner, but he is merely the CEO of the IEBC. Now, these two are appointed to the results management team at the Presidential Tally Center. Their duties are undertaking quality assurance of result forms received from the Presidential Returning Office desk, tallying and processing of election results. I urge that that is the language of Article 183.3, and assisting the Presidential Returning Officer in managing a record of the election results. Tallying and verification, I submit, on the admission of the chairman of the IEBC, was done by Professor Abdi Guliye and Marjan Hussein Marjan, and not by the IEBC. The tallying process continues, unconstitutionally as it was being conducted, and I want to pose the question and attempt an answer to the question, how does that process then end? That process ends as set out in paragraphs, again, the same affidavit of the chairman, at paragraph 76 onwards. But the story that he tells, or the deposition that he makes, starts in paragraph 66. And I will read it because it is important. He deposed. Shortly after 2 p.m., the commissioners and I had a meeting to be briefed on the final results by the commission secretary, stroke CEO, an alternate leader of the Tally Center. The meeting was only for a briefing. He then goes on to say, the briefing was to be done before my declaration in accordance with Article 138.10 of the Constitution. So according to the chairman, All that was going to take place between him and the commissioners was a briefing, and he then goes on and declares the results. What did he do? After he narrates the story of the visit between paragraph 67 and 75, he then goes on under the substantive heading Commission Briefing of Final Results. After the NSAC team had left, the Commission Secretary and Chief Executive Officer, who was also the alternate leader of the team of the Tallying Center, Mr. Marjan Hussein Marjan, walked into the boardroom. The purpose of the meeting was to receive the final tally of results of the presidential election before I could proceed to declare. From the chairman's own evidence, he assembles a team that comprises Professor Gulie and Mr. Marjan. They tally and verify the result, and Mr. Marjan is merely coming to brief the commission. What happens after that? There is between paragraph 77, where he states that copies of the results were handed to the commissioners, and that is all that was done. The result had been tallied and verified elsewhere. The copies are merely handed. There is a conversation. There is no agreement. And of importance, at paragraph 81, the chairman deposed as follows. I walked out of the meeting room accompanied by Commissioner Professor Gulie, Commissioner Molu, and the Chief Executive Officer. And he then went to the auditorium and declared the results. In the chairman's own words. And I submit that his narrative of what took place is important. That is how the tallying and verification of the result in the presidential election took place. To answer or to attempt an answer to the question that is sought by this court by framing ground number 6 as it is, whether IEBC carried out verification, tallying, and declaration of the results in accordance with Article 138.3c and 138.10, I would answer that question in the negative. Tallying was carried out by the chairman alone. At best, the chairman, Professor Gulie, and Mr. Marjan. A quick look at Section 5.1 of the IEBC Act would disclose that those three gentlemen, however eminent, are not the IEBC. What the Constitution enables the chairman to do on his own is to declare the result. I submit that the election is a process, it is a progressive process, and the completion of one process enables another. If you do not complete voting, you cannot tally. If you don't complete tallying, you cannot declare. I submit that tallying and verification, having not taken place as provided by the Constitution, then there was no result for the chairman to declare. There is an attempted justification by the chairman for his decision to tally and verify the result on his own. That justification exists in an affidavit sworn by the chairman. This time it is drawn by the firm of Iseme Kamau and Maema Advocates. It is at page 14, at page 8, paragraph 62. The chairman attempts to justify his decision to tally and verify alone from this court's decision in Raila 2017. With tremendous respect to the chairman, the issue of his ability on his own was not an issue in Raila 2017. And with the clear provisions of the Constitution, in Article 138.3c, there can be no judicial foundation for the chairman's tallying and verification on his own. At the beginning of my submissions, I had submitted that I wish to demonstrate to this court that the chairman executed a very well calculated scheme to grab the election and to run the election on his own. And this is how, in my estimation, he did it. Elections are normally commenced by a notice of elections that is issued under Section 14 of the Elections Act. Regulation 12 of the Elections General Regulations then provide that certain specific notices will be issued for the presidential election. Regulation 12.2 provides as follows: immediately after the publication of a notice under Section 14, and the notice under Section 14 of the Act is published by the Commission, the returning officer of every constituency shall notify the holding of a presidential election in Form 8. Now that's important, because I had also said that earlier on that there is no such role as a presidential returning officer or national returning officer. And I say so because of the provisions of Article 138.2 of the Constitution. Article 138.2 of the Constitution says, if two or more candidates for president are nominated, an election shall be held in each constituency. An election shall be held in each constituency. A returning officer is defined in Section 2 of the Elections Act as a person who conducts an election. The chairman is merely enabled to declare. The conduct of the election by dint of Article 138.2 is by 290 returning officers. The notice that they were required to publish under Regulation 12.2 was never published. The 290 notices from the 290 returning officers was never published. There is no position like the national returning officer. So the first infraction is that there are no notices. The chairman constitutes himself as the national returning officer, and the notices are not published. The chairman gazetted himself. I believe the gazette notice is the gazette notice, I think it is the 22nd or 28th of May, as the national returning officer. As a matter of good electoral practice, returning officers are gazetted with deputies. The chairman gazetted himself with no deputy. It was his election to run as he saw fit. There is the issue of the deployment or the unilateral transfer of returning officers. My learned colleagues who appear for the commissioners have dealt with that extensively in their affidavits, and I'm sure they will submit on it when they have their time on their feet. Again, the deployment of commissioners at Bomas was not accidental, it was deliberate, it is documented, and the details are spelled out, the duties are spelled out in detail. Again, the postponement of the elections is another issue, and I wish to pose this question at this juncture. We have interpreted constitutional time as being strict, but the chairman of the Iebc has on more than one occasion dealt with constitutional time as if it is elastic. The elections that he postponed on the 8th of August were not the first elections that he postponed. In the second week of March 2000, the then sitting MP for a constituency in Kwale called Msambweni passed away. The Constitution provided that that by-election be held within 90 days. That by-election was not held until the 20th of December 2000, or not 2000, 2020. Again, that is another election that was postponed, and it just went by. The manner in which the commission conducted itself, or the chairman conducted himself, around the commission dealing with these very petitions is also instructive in the manner in which the chairman had, assumed certain roles and capacities to himself. I wish to refer to the affidavit of Juliana Cherere, filed in this court on the 26th of August. And I wish to refer members of the court to the last, to annexure JC12. That annexure is correspondence, it is internal memos within the commission. The first one is signed by the 4 commissioners, and it is a request for a special meeting whose agenda is to deliberate the commission's position in light of the presidential elections petition filed in court on the 22nd of August. That letter is dated the 24th of August, 2 days after the petition is filed. Annexure JC12 or JC13 is a follow-up to that letter. There is no response, or there is no response by the chairman to the initial memo, and there is a follow-up now asking for a meeting on Friday the 26th at 9 a.m. at the Commission's offices to discuss that purpose. Of tremendous importance is the letter, or is the internal memo exhibited as JC14. This is a response to the request for a meeting. This one is not under the hand of the chairman, but under the hand of the CEO, where he convenes that meeting for today, the 31st, the first day of hearing. Is that a chairman acting in the best interest of the commission? Is that a chairman acting constitutionally responsibly? The effect of the unconstitutionality in the election was dealt with by this court's decision in Joho 2014. Anything done under that unconstitutional piece of legislation is a nullity. In the brief time that I have left to answer the ground number 7, it is impossible to tell whether the returned candidate garnered 50% plus 1, because the process by which that finding would have been made did not take place constitutionally. The election having been conducted as it was, there is no result. The votes that were cast by the people of Kenya having not been properly tallied and verified, or verified and tallied, there can be no declaration. I wish to assert the submission made by my learned senior colleagues that an election is a sovereign process that belongs to all Kenyans. And via the Constitution, we have delegated the management of that sovereign process to the Iebc. It was a constitutional infraction of monumental proportions for the chairman to seize the election as he did. And for those reasons, it is my humble request that all the prayers that are sought in petition number 2 of 2022 be granted.
Thank you, Council. Next. Yes.
If may please, my lords and my ladies, I start by saying that election is a process. Otieno Willis appearing for petitioner number 4. Election is a process that ends upon the determination of the true wish of the voter. And when that process is unconstitutional, it is not enough to throw numbers that are arrived at through an unconstitutional way to assert that that is the true will of the voter. The first issue I wish to address, my lords and my ladies, is issue number 6. And issue number 6, caught to it, is Article 138(3)(c) of the Constitution, which vests upon the Iebc the duty to tally and verify results from all polling stations and to declare the result. I want the court to take note of the last part of Article 138(3)(c).
The IEBC shall tally and verify the count and declare the result, not the results. Results is the numbers. Result, without an S, is the outcome. And I want the court to notice that 138(3)(c) is a responsibility on the commission, not on the chairman. So the first declaration of the result of the verified and the tallied counts is made by IEBC as a commission. Then the chairperson, again, the word of the Constitution used is the chairperson in Article 138(10) shall now proceed to formally declare the results and issue the certificate. My Lord and my ladies, Article 138(3) sets out a 4-tier process. Tier 1 is the polling station. Tier 2 is the constituency. Tier 3 is the National Tallying Center, in brackets, IEBC Commission. And Tier 4 is the chairperson. Tier 2 cannot function without Tier 1. A constituency cannot function if polling fails at the polling station. A returning officer cannot go to a polling station and make a declaration of the results of that polling station. It's not his function. The IEBC as a commission cannot go to a constituency and fill Form 34B for a particular constituency. If they do so, they failed it. Similarly, the chairperson cannot move from Tier 4 and go to Tier 3 and purport to verify and tally the votes, the count, and make a declaration. Each tier must perform its function. It is now tried that under Article 81, elections must be conducted by an independent body. The presidential elections whose results we are disputing were conducted by an independent individual, not a body. Because if it was a body, I would not have been served with documents from commissioners confirming they did not participate in the verification and tallying of the count. A majority of the commissioners, IEBC in their replying affidavits served upon me, has confirmed they did not tally and verify those results. My lords and my ladies, I wish to state, Chapter 15 of our Constitution establishes constitutional commissions and independent offices. Where the Constitution desired a function to be performed by an individual, it established an independent office. The Office of Auditor General, the Office of Controller of Budget. But where it desired a function to be performed by a commission, it established an independent commission. The Office of Election Management Body is a commission. It is not established as a chief elections officer as an independent office, as Wafula Chebukati seeks to run the commission. My lords, if the people of Kenya desired to have an individual, they would have simply reverted back to 1988 when we had a supervisor of elections. I will not go back into what has been submitted, but only to add on that point that where a commission has been properly constituted and the number is set as an odd number, the Constitution and the law presupposes there may be dissent. And the oddity of the number is to make sure that ultimately a decision will be arrived at. In this particular case, the oddity of the numbers led to a decision of the commission. And a majority of those commissioners have told us in their affidavits that they did not carry out a tally and verification of the results. Tier 3 failed. Confirmed. Let us go to the state of mind of Mr. Wafula Chebukati on the 15th when he was conducting this function. Just to confirm to you that he did it himself. In page 12 of volume 1 of my documents is a statement dated 17th of August by Wafula Chebukati, in which he says that it was his sole responsibility and that the commissioners had no role in that process. That was his state of mind. But the same person, when he comes to court in his replying affidavit, at paragraph 75, 76, 84, 85, he turns around and says, the commission in a collegiate manner arrived at a decision. Why is he lying? If on the 17th he has told us it was his sole responsibility. When he comes to court now, he says the verification was done by everybody. And it's important that I point out in the replying affidavit by William Ruto at paragraph 16 and 17, he also says that it is the sole responsibility of the chairperson to verify and to tally the results. That was their state of mind. But we are submitting it is not the law. The law is everybody must conduct it. These issues which we are raising were canvassed in the Maina Kiai case. Hele Khalifa, the petitioner number 1 in this petition, was a petitioner there. And the court said the Iebc, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for the election of president, electronically transmitted to it from the near 40,000 polling stations, is required to tally and verify the results received. That was the law in Maina Kiai. And they go further to say the architecture of our laws is that the power to tally and verify cannot be vested in an individual. Supreme Court Raila Odinga 2017, the court said in paragraph 292, the failure by the first respondent to verify the results in consultation with the second respondent, Iebc and the chairman, failing to act together in concert, meant that it went against Article 138(3)(c). That was binding. To drive this point home, my lords and my ladies, taking into account those two decisions, the number of Iebc commissioners are 7 plus the chairperson. The number of Supreme Court judges are 7 plus the Chief Justice. If, as has been...
Counsel,
yes.
Do I understand you to be comparing the Supreme Court, its architecture, and the Iebc?
No. I wanted to give an example.
Be careful.
Okay, I'll try to be very careful. I'll try to be very careful and not extreme. I just use the number of 7. That in terms of 7, the Supreme Court sits as a full bench when constituted. And the rules on arriving at a decision is by majority. And there have been even instances when the Chief Justice of this court has been on a minority. And we never saw a Chief Justice walking out there saying, my minority decision is the decision of the Supreme Court of Kenya. In the instant petition, we have the chairman and Gulie and Mr. Molu walking out saying, our minority decision is the decision of the Iebc. How absurd can it be? And to buttress that point, Mr. Nyamodi has clarified what roles were given to the commissioners as opposed to tallying. The roles given, for example, to judges are known to adjudicate over matters. If it were to happen, and I know it can never happen, that the Chief Justice assigns judges some to go and receive advocates, some to go and receive VIPs, some to go and receive the media, then the Chief Justice remains with only 2 other judges, and they make a decision and tell the people of Kenya, this is the decision of the Supreme Court of Kenya. How absurd will it be? That is what transpired in this particular case. Commissioners were relegated outside their core functions, and the function performed by an individual, what I call a minority of the IEBC. That was never the intention of the law. On the technological aspect, as I move to summarize, I want to refer, my lords and my ladies, that's issue number one, on the qualitative test of the technology. IEBC, under the Elections General Technology Regulations, conducted an independent audit of the biometric voter register. This is what your auditors said. At page 32, volume 1 of my bundle of documents, the KPMG report found that 481,711 persons were not qualified to be on the register, but they were on the register. Duplicates. One person has several entries. If this number was below the margin of victory, it will be insignificant. The start of an election process is the voter register. It must be a very clean document. In this case, they started the race with a register by their own audit as at the 16th of June. The register that was gazetted on the 20th of June, that register had 481,711 persons who were not supposed to be there. Duplicates, several entries. The margin of victory by which William Ruto passes 50% plus 1 is less than 70,000 within this margin. The margin of victory by which is declared more than Raila Odinga, 200,000, again less than this. So the universe of the elections was already compromised ab initio, and the number by which it is compromised could affect and did affect the results. To use my Supreme Court example, I would say, if all the judges were biometrically registered, we know there are 7 judges, but we go a biometrics audit, we find there are 9 voters in that register. Would we say that that register is authentic if they were to vote on an issue and then the return is 4-3 and yet the register had 9 people? Would we say that only those who are legitimately qualified to vote participated? I would say not. In page 36 of my volume 1, the audit report finds that 638,814 entries were noted to be null IDs. You have registered voters on the register who don't have ID numbers. Null. That is the quality of your election document. And at page 37, the auditors find that there are generic users who cannot be attached to anyone, generic users of the biometric voter register system who cannot be attributed to anyone. But more importantly, the auditors found that there were 14 non-returning officers, users, accounts that had been granted voter access privileges on the identity data management system. Non-users, some of them are referred to as Embakasi South clerks. People who had access to the system and they were able to make changes on the persons who are supposed to be on the register. Non-authorized users, their own document. At page 39, audit report finds that there are users who are not gazetted returning officers that have access to the database. It is important that we note this. Page 42, IEBC's response to the audit queries. They said it was not humanly possible within the time available to deduplicate the register. That is, to remove those erroneous entries. So they are confirming they went into an election in which the register was compromised, and the number by which it is compromised could and did affect the results. They also purport to say that they cleaned the unauthorized users. At the time when they're doing it, your system has been compromised. There's nothing left to say. You are now running on autopilot, as the KPMG audit report says. The horse has bolted. The stable is broken. My lords and my ladies, it is my submission that when you look at the systemic issues arising and affecting the integrity of this election, should we even pay attention to the numbers which we are now being fronted? If the system was compromised from the beginning, the universe of the elections had been compromised from the beginning, that whatever numbers will come out of that universe of the election, the voter register, does not matter. And I do believe even the third respondent, if he was the one filing this petition, would raise the same issues that I'm raising today. What should we do in terms of my reliefs? I urge my lords and my ladies, the problems of IEBC, and specifically the second respondent, are systemic, as I've said. The court should consider the conduct of this second respondent, Wafula Chebukati, and Professor Gulie and Mr. Molu. The common constant, they were the only commissioners who were in the 2017 general elections. They are the only commissioners who procured the elections technology. And they are the only commissioners again today who are dissenting. They are the minority commissioners who are trying to countermand a decision of the commission. Appropriate sanctions need to arise. In light of the disobedience of the court orders in Maina Kiai, the court was very emphatic on what is the role of IEBC and what is the role of the chairperson. Very clear. When he unilaterally ignores that court order, I urge this court to take that into account when making appropriate sanctions. When the same person in 2017 again refused to accede to the orders of this honorable court in petition 1 of 2017, this court should take that into account. We can't be coming back to you every election with the same problem involving the same person. It is time that Mr. Chebukati is shown that the will of the people of Kenya is supreme, and he must work within the constitution and decisions by this court. That's why we are calling for criminal sanctions and appropriate reports to the DPP. Why should the people suffer constant anxiety around elections that are being bungled when the courts have sounded themselves hoarse and loud on what is your role, what are you supposed to do, what technology to deploy, how to protect that technology, and is not doing it? If you look at, we've attached the PSC report, Public Accounts Committee report, again, finds an indictment of the same person sitting in meetings where he's conflicted. Look at the KPMG report. The auditors are saying they are being given even the information requested so late in the day, on the 16th of June, for a register to be gazetted on the 20th of June. This was deliberate attempt to make sure that the election is compromised. Section 6 of the Elections Act required the register to be opened for inspection 90 days before the date, the notice of a general election. The notice came out on the 20th of January. The register ought to have been open 90 days before the 20th of January for inspection. He didn't do it. He gave the auditors the report so late, but they still pointed out that your register has a problem, and he took no remedial action. He proceeded to conduct the elections in the way that he desired. What he ended up doing is what my grandmother, Sophia Magambo, calls Nairobi Karafu. pata potea. Nairobi Karafu to mean at the National Tallying Center. It is, and we've advertised on our feed of it, the national chairperson of the commission called both Raila Odinga and William Ruto. The whole day, nobody knew who the winner was. Even the commissioners didn't know the results because tallying had stopped. I refer to the affidavit of the 11th respondents. They have confirmed, even them, they were concerned. Why has the open display stopped? Why are you not announcing the results per constituency as you were doing before? That is what I'm saying my grandmother calls Nairobi Karafu. And my niece Mimi calls Piki Piki Ponki Pakamielo Disco. Because he called both of them. He called both of them. And he was the only person who knew who the disco would land on. It could have been either of them. It could have been William Ruto, it could have been Raila Odinga. It fell on William Ruto and he says, voila, you are the president. Is that how we intend to choose our national executive? We've reduced it to Mimi's childhood game of Piki Piki Ponki Pakamielo Disco.
Council again.
Yes, my lord.
I did give you brotherly advice. Be careful. That language appears to be alien to this court.
I'll be guided, my lord. I'll be guided. But the main point, so that we don't lose the crux of the point, is that the lack of transparency in the tallying and verification of the results, contrary to Article 10 of our Constitution, completely eroded public confidence in our Constitution. It completely left a very core exercise of a sovereign donation by the people to the whims of an individual not subject to any control. And that, my lords and ladies, should not miss the attention of this court. My lords, in our submissions, we've spoken about the DCI report and the penetration of the system. Again, just to buttress the role of this chairperson. My lord, the DCI, as has been submitted, is set up as a government agency to investigate crime. They did find that indeed there were foreigners who had access to what we call critical election instruments. And their forensic report has established the presence of those persons. In other words, in layman's language, the DCI report has corroborated what the KPMG report has found and authorized users and access to critical elections technology. Should we ignore that and say, just look at the numbers, forget about the process? I humbly submit that we cannot now even focus on the numbers. We should not even, because the process through which those numbers are being arrived at has been compromised. So that anybody inviting you even to look at the number is inviting you down an alley, a process in which the wish of the people has been convoluted. My learned senior John Mohammed, representing a poor voter, did say that voter just wants to see, just wants to know, how was my vote converted into account and the result of the elections. If the infrastructure and the process set up for that poor voter does not guarantee integrity, then, my lords and my ladies, it is my humble submission that the number that an individual ultimately comes out with at the end does not matter. If that number comes out in a manner that infringes the Constitution, you've come up with your number in a manner that violates specific provisions of the Constitution, then that number does not matter. The Constitution has to be upheld. Because the Constitution is what established the framework through which we will start generating that number. You ignore the Constitution, then it doesn't matter. We've not organized ourselves as a sovereign on how to arrive at the number. My lords, as I move to conclude, I think it is very important that I buttress this point on the meaning of Article 138(3)(c), because I see I still have 4 more minutes and I will not wish to donate them at the moment, and Article 138(10). The Iebc shall tally and verify the count and declare the result. That's the first step. And I've invited the Honorable Court. There are numerous decisions from these courts on what a result is, outcome. So the first declaration to take ownership of the elections is done by the Iebc once they've verified and tallied the count. And some of the tools of verification, number one are the KIMS kits. Because the KIMS kits were meant to send you voter turnout per polling station. So part of how you verify, you ask yourself, this particular polling station, as per the KIMS kits, how many voters logged in? Thank you. How many voters logged in and voted in that polling station? Once you establish that, you check on the Form 34As, how many registered voters are entered to have voted in that station. If the numbers are different, then you ask for Form 32A, assuming some were identified manually. Those are the steps of verification. But if the numbers in your KIMS kits are less than the numbers of the votes returned and are not supported by any Forms 32As, then that's a polling station to be flagged. It means the verification has not returned or cleared that polling station. That is what the Iebc does. Verification is not, as they're trying to attempt to tell us, is about looking at the UV mark, looking at the serial number. Those are just part of verification. But the verification, number one, is to identify that indeed the true universe came out and voted. And that is very important. Once the commission satisfies itself, we go to Article 138(10), in which Article 138(10), the chairman now walks out of the commission meeting together with all his commissioners, if necessary, and proceeds to now declare the result. Because remember what I said, the first declaration was done by the Iebc when they concluded their verification and tallying. Then the other declaration, 138(10), is done by the chairperson. And then he issues the certificate as an individual. So that to assume that the chairperson on his own can conduct, or that the staff of the commission are the ones to do the tallying and verification, that is erroneous. It is the commission that does it. The staff of the commission are spread everywhere. They report to the commissioners who constitute the commission. And the commissioners take control of that process. And finally, my lords and my ladies, it is not the first time we are holding elections in this country. To say that Mr. Chebukati didn't know what the law was. He knew. These provisions have been applied in 2013. They were applied in 2017-1 and 2017-2. And the commission functioned as a commission to conduct those elections. Why should we now move away? My lords, finally, in this election, we submit the people had their say, but the machines, technology, had its way. Please correct it. Thank you very much.
Petition number 4 of 2022, David Kariuki Ngari.
My lady, this is petitioner number 5 in the consolidated petition. My name is Metuga. I will deal with issue number 6 as framed by the court. My colleague, Mr. Njiru Ndewa, will deal with issue number 8. The petition is dated 22nd of August 2022. We have filed submissions dated 25th of August.
So let us confirm, who is your client?
My client is David Kariuki Ngari.
Ngari.
Yes.
Then according to our records, it's number 4, petition number 4.
I do apologize, my lord. It would appear I printed some ruling that reflected him as petitioner number 5
okay. Maybe
in the
after
consolidated petition.
After the consolidation, yes.
Yes.
The party is the same, no problem.
Very well, my lady. We have filed petitioner submissions dated 25th of August 2022. They are supplementary submissions dated 28th of August 2022.
Sorry, you said that you'll address issue number?
I will address issue number 6.
And Mr.
Ndewa will address issue number 8.
Correct, thank you.
My lord, we have filed submissions dated 25th of August 2022. We have supplementary submissions dated 28th of August 2022. My lord, there is a quote attributed to the American statesman Harry Truman that the president, whoever he is, has to decide. He cannot pass the buck to anybody. No one else can do the deciding for him. This is his job. And my lord, it is my submission that constitutional mandates given to Iebc have to be performed by Iebc because the buck stops with the commission. Our constitution has been characterized as a transformative charter. My lord, the only way it can be a transformative charter is if we breathe life to it instead of paying lip service. The principles that run through the Constitution, including transparency, accountability, participation of the people, have to be given. We have to breathe life to those provisions if the Constitution has to live up to its characterization as a transformative charter. It can also live to its characterization as such if the independent institutions under the Constitution discharge their mandates according to what is provided there. One of the institutions is Iebc. Under Chapter 15 of the Constitution, it has a critical function which is captured under Article 249A. It must protect the sovereignty of the people. And one of the ways it protects the sovereignty of the people is to ensure that the will of the people in electing their representatives reflects what the people have voted it to be. This is because, my lord, sovereignty is exercised directly. It can also be exercised by the representatives they elect.
So by sticking to the principles that guide the process of election, that's how it can give the sovereignty of the people the life it deserves. Under Article 1, under Article 81 and Article 86, the electoral process has to observe, among other principles, transparency. It also has to be an accountable process. My lords, the commission is constituted under Article 88, and the national legislation that provides for the commission is the Independent Electoral and Boundary Commission, that is Act number 9 of 2011. Under Section 5, a commission is established, and under Section 11 and 11A, it's categorical that the Secretariat works under the Commission. So the staff of the Commission performs a delegated function. The buck stops with the Commission. My plain reading of Article 138(3)(c) is that the process of tallying, verification, and declaration of the result is the mandate of the Commission. It's not the mandate of the staff or the Secretariat. This is also reiterated under Section 39, 1C, paragraph B, which also states categorically that the function of tallying and verification is supposed to be done by the Commission. Was it done by the Commission? That is the only question, my Lord, I will answer. I will answer it through the eyes of the averments made by the 9th respondent, that is Professor Abdi Gulia, and the 4th respondent, that's in the consolidated petition, that's Honorable the Chairman Chebukati. This is how, from their own affidavit, without even going to the regulations in which they set out on how the verification was supposed to be done, from their own affidavits. When the other 4 commissioners are clear that they were not involved in the verification and tallying and declaration of the result, this is what they say in their respective affidavits. The affidavit of Professor Gulia, the 9th respondent, sworn on 20th of August 2022 in respect of petition 005, at paragraph 8, he is clear that once assigned a responsibility by the Commission, whatever recommendations he makes have to go back to the Commission for consideration. So from his own averment, it was clear that even when the Commission delegates a function to a commissioner, he has to report back to the Commission for approval. At paragraph 32 of his affidavit, this is how he described how verification was done and the results generated. That the Chief Executive Officer / the Commission Secretary came with the final result. That is on 15th of August 2022, when the commissioners were seated in a meeting. He acknowledges that the verification is not being done by the Commission. It is the Chief Executive Officer getting to the commissioners a result, a clear admission that
they were not involved in the tallying and the verification of the result. Now, in respect of the 27 constituencies which have been mentioned, whether, and there was doubt whether verification was done, this is how he puts it in paragraph 27, paragraph 35 of this affidavit, that these constituencies were verified in the presence of agents of candidates and included in the final tally. There's nowhere in that statement it says that verification was done by the commission. Now, on why he did not even announce the result for transparency, then he says there was no calmness in the auditorium for them to announce the result. But then the question is, when it was restored, the chairman of the Electoral Commission was able to read the result in Form 34C. The question is, during that period, how is it that they could not read the result for the 27 constituencies? The chairman of the commission, Honorable Chebukati, in his replying affidavit to the fourth petitioner's petition, the affidavit is undated, but it was filed on 27th of August 2022. This is how he characterizes the verification of the result by the commission. At paragraph 31, he avers under oath that the verification and tallying was undertaken by a staff of Iebc with some commissioners assigned the role. My Lord, from the chairman's own averment, the verification is being done by a commissioner assigned the role, and the staff of Iebc. There is no indication anywhere that that outcome of the verification was brought before the commissioners before an announcement was made. It is understandable that tallying and a verification of over 40,000 polling stations is an Herculean task, and it cannot be done by 7 commissioners. But, my lords, if they delegate that function to the staff of Iebc and a commissioner or 2 commissioners, it is my submission that whatever report that comes out of that tallying and verification has to be placed before the commissioners before a declaration is made. My Lord, that was not done. Now, an explanation is given by the chairman of the commission at paragraph 25 of his affidavit in reply to the fourth petitioner's petition, when the fourth petitioner avers that no announcement was made for 27 other constituencies for purposes of transparency, this is what he responds: there was no legal obligation to do that. My Lord, there is no explanation given why it was done in respect of 261 other constituencies and not the 27 constituencies. It's my submission that in respect of those other 27 constituencies, there was lack of transparency and accountability. The chairman avers in that paragraph 25 of his affidavit further that Professor Gulier was prevented from reading the result, but there is no explanation further why he could not read the result for the 27 constituencies after calm was restored. And if at all tallying was already done for the 27 constituencies and a report prepared, my lords, this should have been included in the reply of the chairman to the petition to confirm that indeed the tallying and the verification had already been done. It's my final submission that the result that was declared by the chairman of the commission did not reflect the will of Kenyans, and it should not be let to stand. My colleague will take over the issue number 8. Thank you, my lord.
My ladies, my lords, my name is Dego Njiru, permit me to address issue number 8 in respect to our petition. And while addressing that issue, my ladies, my lords, I'll be seeking to answer the question whether or not the election that was conducted on 9th of August was a constitutional election. While I do that, my ladies, my lords, permit me to refer you to various affidavits, and I begin by referring to paragraph 52, paragraph 53, and paragraph 54 of our petition. I'll also refer to paragraph 51 of the Vice Chair's replying affidavit, that's the 5th respondent. I'll also refer to paragraph 25 of the Chairman's Chebukati's replying affidavit. I'll finally look at paragraph 19 of the second respondent, William Samoei Ruto's affidavit. Why are these paragraphs important to these proceedings, my ladies, my lords? And while addressing that question, I am going to refer to various provisions of the Constitution. I'll begin by referring to Article 88 of the Constitution. I'll seek reliance again on Article 89, Article 97, Article 138, Clause 2. I'll also seek reliance on Section 2 of the Election Act, and I'll also seek reliance on Section 83 of the Election Act. My ladies, my lords, if you look at the affidavits that I have mentioned, and most importantly, affidavit by the chairman of the commission, at paragraph 25, he defines and says that he conducted tallying of election results in 291 constituencies. Paragraph 19 of Honorable William Ruto's affidavit, again he says that elections were conducted in 291 constituencies. The fundamental questions, my ladies, my lords, is how many constituencies do we have in this republic? If you look at Article 138, Clause 2, the Constitution provides that elections shall take place in each and every constituency in this Kenya. And when you define constituency, my ladies, my lords, you look at the provision of Article 4 and Article 5. Article 5 of the Constitution, which defines the territory of the Republic of Kenya. Then you further look at Article 89, Clause 1. It says there shall be 290 constituencies in the Republic of Kenya. And that is where the law contemplates that elections shall take place. But what happened on 9th of August is that we have submissions and averments that elections took place in 291 constituencies. The fundamental questions, my ladies, my lord, is where did this extra constituency come from? And is this extra constituency a constitutional constituency defined by the armpit of Article 89? There may be arguments that this was a constituency by the diaspora. Yes, they may have their rights under Article 38 to vote. But the question is Is it a constituency within the meaning of the law? We submit that to the extent that individuals not confined to Article 89 of the Constitution, to the extent that the elections of an extra constituency not defined under Article 97 took place during that particular time, that contaminated the election. You must then ask yourself, to what extent was the contamination? Article 138 Clause 4 requires the Commission to compute whether or not the president-elect has attained 50 plus 1%. We are submitting that these elections that took place in alien constituencies contributed to the computation of 50 plus 1%. Then you might ask yourself, my ladies, my lords, what then is the test that I'm trying to apply? I am applying the test proposed by Section 83 of the Constitution of the Election Act. It provides that an election can be voided if that election did not comply with the Constitution or other written law. And this is a fundamental question, my ladies, my lords, because a constituency as defined by Article 289, Article 89, that must be within the territory of Kenya as defined by Article 5, then contemplates a situation whereby there is a question of representation. It subjects the people of Kenya to exercising their sovereignty through the representation of those people. The question then that begs an answer is, how can an election that has been infiltrated by alien constituencies be regarded as a constitutional election? We submit thus that waives the fundamental requirement where Iebc under Article 88 Clause 5 is required to conduct an election within the armpits of the Constitution. It is a mandate within the Iebc that the mandate is so fundamental that it cannot be waived, it cannot be fettered, it cannot even be relaxed. An individual cannot create a constituency. If it was in the interest of Kenyans, while promulgating this constitution and adopting this constitution and giving this constitution unto themselves to create an extra constituency, there was nothing that was as easy as saying as such. My ladies, my lords, permit me to address the question of the 27 constituencies. Again, it has been submitted by my learned friend that under paragraph 25 of the Chairman Chebukati's replying affidavit, he has glossed over that weighty issue. He does not consider that 27 constituencies, which makes about 10% of the Kenyan constituencies, which translates to about 1.9 elected voters, were not included in the final tally. And what does he do? He makes and he amends and carefully uses the words which to apply. In his replying affidavit, he technically avoids the use of the word declaration and he uses the word announcement. The word announcement is not akin, is not similar, and does not mean declaration. Why, my ladies, my lords? Because Article 138, Clause 4, presupposes a declaration of all the polling results by the Iebc. So this declaration is not akin to announcement. And therefore, my ladies, my lords, we are submitting that the chairman of the Electoral Commission was lost on what he needed to do. He is making a declaration and reducing the question of declaration to the question of a master of ceremony. The Iebc chairman was not called upon to just officiate the process. He was called upon to execute a constitutional obligation. And therefore, when the law speaks about a declaration, there must be clear demonstration that the same was done. What happened, my ladies, my lords? He says that the law does not require him to do so. He does not annex any evidence that the same was declared. He does not annex any evidence in his affidavit that there was tallying. He does not aid this honorable court to make an opinion that yes, the requirements of the Constitution were met. Finally, my ladies, my lords, We need to interrogate the conduct of the chairman of the IEBC. We need to interrogate the previous and even the current conduct of the chairman. He was effectively described by my senior line friend, Mr. Norji, that is a person who has perfected the art of imperfection. And he has perfected the art of imperfection by making sure that he conducts a lone ranger process. Remember, my ladies, my lords, to the run-up of the second election in 2017, a similar issue arose, which necessitated the resignation of the commissioners. How long shall we allow an individual to keep on transgressing the law? How long shall we allow this individual to keep on putting Kenyans and to subject Kenyans into uncertainty? The law requires that there must be certainty. And the certainty contemplated by the law is that I shall cast my vote and my vote shall count. And where are the 27 constituencies fundamental and key to these proceedings? If you look at our paragraph 57, 52, 53, and 54, we have listed those constituencies. It is where an individual or the first petitioner has his supporters. It is where he has his support base. So were they left out as a matter of design? Were they left out by default? Or was he holding someone's brief? My ladies, my lords, we submit that to the extent that those constituencies were not tallied, were not verified, and the declarations were not made, then this election did not meet the provisions of the Constitution. Finally, my ladies, my lords, he says in paragraph 25 that he can announce elections anytime that he so wishes, even if there are some constituencies that have not generated their results. But what does section 39 subsection 2 of the Election Act provides? It provides, my ladies, my lords, I would wish to read this. The chairman may declare a candidate elected as president before all constituencies have transmitted their results. The operating word here, my ladies, my lords, is the word before. So if before, at the time he's declaring those elections, the constituencies have not generated their results, he can declare. But the station where we are in, my ladies, my lords, on 9th, going by the dictates of Maina Kiai's case, the chairman had received all the results from the polling stations. It was therefore incumbent upon him to make sure that they are included, to make sure that they are tallied, to make sure that they are verified. Finally, my ladies, my lords, permit me to delve on an issue that was dealt with in the morning by my senior line friend, Mr. Governor Orengo. My ladies, my lords, I am referring to the affidavit, replying affidavit filed by Honorable William Ruto, and I'm referring to page 111, where it indicates a preliminary statement of the IGAD election observation mission to the August elections. And that paragraph, my ladies, my lords, these were individuals who are observers of the elections, who are out there observing the elections. When it came to the question of analyzing the voters' turnout, the report says, it is annexed in its affidavit, that in most of the polling stations visited, voters' turnout was noticeably low and recorded around 55%. Those who are observers out there in the field observing the elections, giving a return of the 55%. And this 55%, and you can see how this computation of the turnout is fluid. It's so fluid, it's a lever. You are not able to hold it. The chairman is not able to tell about the voter turnout. The report is giving us a different voter turnout. So what exactly was the voter turnout? So that the voter turnout then can assist us in the computation of the sum of 50 plus 1%. Finally, my ladies, my lords, there's a question as to the computation of the 50+1%, that when the chairman gave his final public address about the voters' turnout, he deliberately exempted those individuals who voted manually. To date, we are not aware of how many people passed through the manual registration. How many people voted manually? I mean, my ladies, my lords, it is not within the armpit or within the purview or within the power or the discretion of the chairman of the Electoral Commission to do that what he wishes. He cannot deal with the question of elections from his aspirations or from his wishes. He must deal with the question of election as dictated by the Constitution, as dictated by the election laws. Finally, my ladies, my lords, we urge you to admit our petition and you dismiss the replies filed by all the respondents and find that this election was not conducted in accordance to the Constitution. And my ladies, my lords, that you give an order that the sovereignty of the people must be respected. And the sovereignty of the people cannot be respected, cannot be upheld where there is serious transgression at the wishes of the chairman of the Electoral Commission. Finally, my ladies, my lords, there needs to be a retribution. There needs to be a stop of all these transgressions. How many times shall we subject Kenyans to these processes? How many times should we appear before you with the same gravement every day, after every elections? There ought to be a stop. And a stop is making sure that the proper sanctions, criminal sanctions, as prescribed by the Election Act, are meted against any transgressor. And there is no one who is above the law, including the chairman, so that people may learn to respect the law. I'm so obliged. I donate the 26 minutes to the court.
Thank you.
Seconds.
Those are seconds. Thank you very much, Council. Regards petition number 7, we have Mr. Mutata appearing for himself, and Professor is appearing for the other. So I think you'll share the time, Prof.
Thank you, Your Ladyship. Well, our submissions will be in two parts. The first part will be qualitative, and I will address myself to the law and complement the submissions that have been made by learned friend, Senior Counsel James Orengo, learned friend, Senior Counsel Philip Murgor and Feroz Noroji, on the questions of compliance with the law and on the unconstitutional nature and the non-compliant nature that the first respondent, Mr. Chebukati, employed in running the presidential election of 9th August 2022. My lords, the person I do not want to be now is Professor Githu Muigai, because every single advocate in this court has spoken to the violations by his client. Violations, my lords, that border on the violation and speak to the violation of Article 3.2, the unconstitutional proceedings that led to the issuance of Gazette Notice 9773 of 2022, issued on 16th August 2022, that declared the president-elect. My lords, we shall be asking that that violation or that Gazette Notice be vacated as you make several orders, my lords, under Section 84 of the Elections Act and Article 143 of the Constitution. My lords and my ladies, let me start by submitting that my submission shall be around the issues framed by the court, particularly, my lords, issue number 8 on illegalities and irregularities that, if applied disjunctively as this court has ordained before, my lords, will lead to a compelling order of nullification of the elections of 9th of August 2022. But I will also, my lords, and in view of the powers of this court under Section 3 of the Supreme Court Act, delve into the interpretation of Article 143. And my lord, perhaps because this court is also the jurisprudential head of the judiciary, to see, my lords, whether there are possible sanctions or possible findings that this court can make other than the order of nullification. And my lord, that would be my last submission. My lord, let me just touch on the second part. The second part that my learned friend Mr. Omtata will deal with will be the maths, electromaths, the mathematics of the election. We will demonstrate by way of a PowerPoint presentation that none of the candidates met the 50% plus one vote as per the tallies that were read by Chairman Chebukati on the percentages weighed against the voter turnout and the votes cast, my lords. And that will show that if indeed no candidate attained the 50% plus one, then this court has a daunting task. One, of course, after the exercise that is ongoing, the exercise that is going on with the server, my lords, we will be asking this court, my lord, to think of the possibility of declaring a winner after the outcome of the access to the back end of the server. That's number one. But number two, my lords, patently, the results announced by the chairman of the Iebc were unconstitutional because they did not emerge from the commission. And granted, my lord, that they were unconstitutional, if the court then is unable to arrive at a result as to who won the election, my lord, then of necessity the court would then would have no option but to proceed to nullify or find that it was conducted illegally. My lord, let me just proceed because of time to the key submissions. My lord, it is patent and glaring that there was non-compliance A and D of the Constitution, read together with Article 86E of the Constitution. The elections were not verifiable in as much as voting took place. The process of tallying of the presidential vote from the polling station and the issuance of Forms 34As transmitted to the constituency tallying center and finally to the national tallying center, my lords, was not a verifiable process. My learned friend Philip Murgod has spoken largely to the access that two individuals had to the system. He had spoken of one Dahir and one Kwanusu, who had access over 1,000 times Mr. Kwanusu, the PA to the chairman, Mr. Professor Githu's client. Clearly, my lords,
I would like to request the Honorable Court that we conduct this petition in the tradition, in the very long honored tradition of each counsel arguing his case without any sideshow.
My lord, it is a fact that the chairman is Professor Githu's client, but I will, because of the discomfort, address myself to
yes, I'm speaking.
Yes, my lord.
I think you should treat your colleagues with respect. We all know that who is representing who. So make your point.
My lords, I will proceed. I will proceed. I will not mention Prof's name going forth. But my lords, the violation is glaring in view, my Lord, of the fact that the non-verifiability of the process from the tallying center as held by the Court of Appeal, my Lord, we've spoken to this severally, to the National Tallying Center of what each presidential candidate received, my Lord, is a subject of an unconstitutional act. My Lord, that is point number one. My Lord, therefore, the counting, there was a violation of the duty to count each vote cast by an individual as contained in the Form 34A transmitted to the National Tallying Center and as uploaded to the Form 34Bs and 34C that was used to declare the result in Form 34D, my Lords. My Lords, granted further, that violation is also reflected, my Lord, in the violation of the Elections Act itself. Because, my Lord, there was a requirement that once the tallying is done and the verification done under Article 138(3)(c, it was not the chairman but the commission that was required to undertake that process. And my Lord, I want to speak to the affidavit of the chairman himself. Other advocates have submitted on the self-importance that the chairman presumed in conducting the final tally, ignoring the mandatory nature of Article 138(3)(c. This court has dealt with the question of interpretation of statutes and of the Constitution, my Lord, where there's a compelling word, shall. Article 138(3)(c is compelling in nature. It does not give the chairman an option of consultation or of assuming the role of the commission. It states, my Lord, that the commission shall undertake the process, not the chairman. The same term, my Lord, is used in the second schedule to the Iebc Act and in sections 4 and 8 of the Elections Act. My Lord, if I may just read 138(3)(c. It provides, my Lord, that the process of tallying, my Lord, after counting the votes in the polling station, the independent electoral and the shall tally. My Lord, where shall is used before a verb, citing my learned friend, senior counsel, it leads to an inevitable and compelling option. And this is what the courts have interpreted in several cases that we have handed over to the court, my Lord. The cases in Kirain Investments and National Land Commission, this was the finding of the court, again citing the findings of the Court of Appeal on the same question. Wesley, Judge of Appeal, laying down the consequence of the use of the word shall as peremptory. So, my Lord, that of itself, any action reflected in the affidavit of Wafula Chebukati that denotes any action by himself in assigning other members work, my Lord, and in eventually purporting to act under 138(10) alone without consultation, invalidates the entire result that he purported to announce and invalidates the issuance of Form 34C and D, in which he purported to announce the results of the election. My Lord, ipso facto, the duty to transmit, tally, and collate was therefore violated. The regulations, my Lord, 39(1)(c) of the Elections Act required two tallies, the physical tally and the electronic tally that ought to have been transmitted. Non-compliance, my Lord, is evidenced in the affidavit filed by Cherere and by the 4 commissioners, my lord, and an admission by the chairman himself that the tally was not compliant with section 39 1D of the Elections Act. My lord, going forth, the complementary nature of compliance reflected from sections 39 to section 44 uppercase A of the Elections Act, my lord, denotes non-compliance by the commission, but also an admission, my lord, that there was no commission the moment the commission was divided and was working in different forms. My lord, Article 3(2) of the Constitution provides that there shall be no government established other than through the Constitution, so that any violation that leads to an unlawful process, my lord, cannot stand. And this court has the duty under Section 3 and Article 140 to invalidate an offensive action that is unconstitutional. My lords, we submit that through the affidavits that admit the interference with the transmission system, the interference with verification, and the duty to declare the presidential election by the commission, the result gazetted in Gazette Notice issued by the chairman, being Gazette Notice 9773 of 2022, was unconstitutional and cannot stand and must be invalidated by this court. My lord, in view of time, we wish to submit that even aside finding that even the duty of the commission as created and enshrined, my lords, in Article 249, is governed and dictated by the principles under Article 10, my lords. And my lords, where public officers do not act in a manner donated by Article 10, then their actions must be vitiated by the court. And this is the forum where such actions must be vitiated. My lords, the law is clear. The maxim ex turpi causa non action, which has been developed over the years, my lord, by Lord Mansfield, initially in Holtzman versus Johnson, later in Tinsley and Milligan, and now in Patel versus Mizra, speak to the fact that no circumstance can allow this action to stand. The opposing affidavits, my lord, the opposing affidavits filed by the 4 commissioners and the 3 that speak to the violation of paragraphs 5 and 7 of Schedule 2 can only lead this court compellably, my lord, to find that this is a matter that this court must handle in the manner that lex arbitri would dictate. My lord, the principle ex equo et bono used by international tribunals to settle questions. In the local framework, my lord, we refer to Solomonic wisdom in 1 Kings 14. The court should look at the opposing affidavits. The court should look at the misconduct of the chairman of the commission. The court will then compellably apply the dictates of fairness in this matter and find that the people of Kenya were violated by the conduct of an election outside the framework of the Constitution, through the violation of the process, through the violation of the outcome. And my lord, we want to demonstrate to the court, before I wind up, that mathematically, and this is where the law meets mathematics, no candidate attained the 50%. If the chairman read the results that he read and the percentages that he read out of the registered voters that cast their votes, my lord. My lords, the maxim, amiable compositeur, that I shall look at after my learned friend Mr. Mutata presents the results, my lord, will show you that this court has no option but to nullify this election. There's no option. There's no option. Mr. Mutata.
Gather because you're all senators, you're learning friends now?
Yes, my lord, Mr. Mutata is a serial litigator and a public interest, a public defender in this country. And I respect him for that role, my lords.
And now a senator? And now he's a senator?
Yes, a senator for Busia County. He replaced the Attorney General, who did not run for office.
Members of the Honorable Court, in my submissions, I will rely on the petition we filed jointly with the three others, which is dated 22nd of August. I also have submissions which I filed alone, which are dated 26th of August. And I also have a further affidavit, which is dated the 29th of August. My lords, before I remark on the mathematics, I just wanted to make a small observation as regards point number 1. And I think the elephant in the room is point number 1. What kind of election does the Constitution of Kenya anticipate? That's a question that I've seen documents and videos by some members of the court telling me that even this court does not comprehend the kind of election anticipated under Article 81 and 86 of the Constitution. Short of a digital election, you cannot meet the constitutional threshold.
Mr. Mutata, what
Yes.
did you say?
I said I've come across publications and video recordings by some members of the bench who complain that the 14 days the court is given to determine a dispute concerning the presidential election is too short. And I'm saying that statement demonstrates the failure of, with due respect, the honorable judges of this court to understand the electoral architecture in the Constitution of Kenya 2010. The Constitution of Kenya 2010 only anticipates a digital election. And if we are dealing with a digital election, 14 days is too much. But if you are dealing with a paper election, a manual election, you need maybe 2 months. That's where I wanted to begin. And this election does not meet the threshold in the Constitution at all. The presidential election that I'm referring to, that's before this court. It's not simple. That's why you have got spoiled ballots. In a digital election, you don't have spoiled ballots or rejected ballots. And you don't even have the question of whether the spoiled or rejected ballots count. It's not verifiable. Right now, I cannot verify where the ballots I cast went. I don't know. The moment I dropped them in that box, I lost all contact with those ballots. There's no mechanism of verifying. A digital election would give me a serial number by which I could track my ballots. So I'm saying that if you look at the threshold in the Constitution, we must work towards a digital election and move away from these paper elections, which allow human interference without sometimes leaving footprints. I would now go to my submissions. I was supposed to be given some aid. Yes. Where the...
If the time could stop running, we had supplied the electronic instruments to the court.
You begged the assistant.
I don't understand what you said. I come there. Oh, open for me the PowerPoint document. Go to the next slide. Yes, we're looking at an analysis of paragraph 26 of affidavit filed by Mr. Sunkuli in petition number 7, paragraph 226. And you can see that he's giving us, he gives data of how the KIMS kits transmitted on 9th August at 17 hours at the close of polls. He gives that figure. On 9th August at 20:45 hours, about some 3 hours and 45 minutes, he gives his figure of 13 million. Then, most surprisingly, you have two entries. It is the entry that which gives us at 14 hours and 14:40 hours. The KIMS kits are transmitting some 23 hours later, still transmitting data. And we are saying that that data is not acceptable. So we come to the next slide. I just run through given the short time I have. When you got that slide, you look, they tell you at 20:45 hours, on 9th August 2022, some 13,731,215 people voted. Polling turnout recorded on 10th August is 14,239,862 ballots. And on the 10th, that is the day after the voting, and we know that it's only elders where elections are taking place. Now, when you analyze that data, you find that 508,647 ballots are added on the 10th. And you saw Land Council Willis show that the audit of the register had almost the same number of ghost voters. So you can see from that data that they present, Mr. Sunguli presents, you are able to isolate 508,647 ghost cast votes, which are more than the difference between the two leading candidates. We've got the next slide. And if you look at the ballots that are recorded to have received, to have recorded on the next day, you are talking of some 1,665,412 curiously cast votes, which are coming out after the close of voting, and that's after 3 hours after the close of voting. So if we take the total tally now, you find that the tally is close to it's about 1.7 million votes. That spike in votes is not possible. That spike in votes is part of the problems we're having, that fellows were having access, the KIMS kits that were still transmitting data from locations that are not clear. Because the KIMS kits that were in polling stations, the voting stopped on 9th. And giving an allowance of 3 hours or 4 hours for people who are still on the queue, you would understand by why a KIMS kit would still be transmitting 23 hours after the close of elections is something that is difficult to comprehend. Also, my members of the Honorable Court, if you look at the Form 34C that has been published and interrogate the data there, if you look at the total of the variables ascribed to each candidate, the amount that you get is 110 votes less than the number that has been printed on that paper. Now, if you look at, that thing was boggling my mind. Initially, I thought it was a simple error of addition. But just come out, it was not a question of 1 + 1 = 3. Because when you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, yes, I'm on, yes, go to the next slide. Next. Yes, sorry, I forgot to, thank you for directing. If you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, the total voter turnout in the table when you subtract from it, as given in the table, the number of rejected votes on Form 34, you get exactly that figure of 14,213,137, which in that replying affidavit they claim was an error of addition. But if you interrogate the raw data, you find that that figure is the valid figure. So the votes attributed to the candidates are fictitious. From paragraph 32 of Mr. Sunkuli's replying affidavit. So, when you go on to the next slide. I've reproduced I've tried to factor in the figures that Mr. Sunkuli gives, and when you add them, you get the 14,213,137. Yet, when you add the figures attributed to the individual candidates on Form 34C, they come to 14,213,027. That is not an innocent mistake. It is a situation whereby somebody has left a trail, that they were working backwards from a certain figure which they had, and they were working backwards, and so they would going to get that. And most important, I would also refer to the affidavit signed by the chairman, filed by the chairman in petition number 5. At paragraph 95 of his replying affidavit, sworn on 26 August 2022, the chairman presents the exact figure of 14,213,137 as the total valid votes cast for all the 4 candidates. So if that is the figure that's coming from the raw data, that's the figure that's carried in the affidavit, then the values attributed to each one of the 4 candidates are fictitious and cannot count. And therefore, that Form 34C is an invalid document. Go to the next slide. Sorry, next. Yes, so in that slide I'm saying, we can only conclude that these figures, which form the content of Form 34C, are cooked. You cannot have both of them in the same document. And this court should not allow that document to stand at all. And the conflicting figures, and those conflicting figures for valid votes cast of 14,213,137,000, and the other one is the one when you add the values of the individual candidates, the 4 candidates, you get 14,213,027, is evidence that the results were worked backwards to achieve a desired or predetermined outcome. Therefore, the declared percentages for the 4 candidates, no, the votes attributed to the 4 candidates and the declared and the percentages attributed to them is all fiction. Now, I got to address the question of whether you can achieve, if assuming that what in the totality of the announcements made by the chairman, any of the candidates realized 50% plus 1 vote.
Just checking on the time.
Yes. There's no display for the time, unfortunately.
According to mine, time is over. If you could just finish your slides.
Okay, thank you.
Because they seem to have lost theirs.
Okay, so a further analysis of Form 34C on voter turnout, the chairman announced, and that issue has not been retracted at the close of voting. He was answering a particular question, and a journalist asked him, as matters stand now, what is the national voter turnout? And he said, oh, that one, I can deal with it. And he said, as at the time he was announcing, it was 65.4%. And according to what the KIMS kits had reported. And he expected that value to go up when all the KIMS kits had reported and the manual had been included in it. So when you calculate that against the total voter register, the national voter register of 22,120,458 votes, you get that the voter turnout as at that time was 14,466,799 votes. The next slide. So from Form 34, the tallies are ascribed in Form 34. You get, when you factor in the rejected votes, you get a total value of 14 million.
engage or even consider participating in such kind of petty business. Petty business? Then why are you asking? Forget I even asked.
You people, you don't know what is going on out there.
What's wrong? What's going on?
Bosira has gone Ruwashi.
Huh?
Hey, he has gone Banana Garisi.
How dare you?
How dare me what?
How can you compare my executive business with that of a petty cow's business?
Like seriously, teacher, where do you think you're going?
I'm going to save the world.
Save the world from what?
From drought and starvation, of course, from Bosire, Doka.
You kill voters and include new voters. So Raila gets 48.372118662. The next page, Wahiga would get 31,090. Most important is the fact that because when I did the first line, the petition, I did not have the information that came from Mr. Sunguli's affidavit. So I would request the court to pay particular attention to the further affidavit. That's why I had the benefit to compute the figures with the figures that the commission supplied. That's all my
Thank you. Compelling are the figures that finally mathematics finds its way into invalidating.
So, Gender, you have no leave to address the court after time. Why don't you start from there?
Yes.
From where? From what time? Start from there.
Senior counsel, we agreed on the ground rules yesterday. Your time is up. In fact, his time went over because he was on the PowerPoint. We noted he went over by 6 minutes. So please, yes, if you have anything, you can reply when you have time to reply. Rejoinder. I will now invite counsel in petition number 6, Njuria Yokabichege and others.
May it please, Madam Chief Justice, Deputy Chief Justice, and other members of the court. My name is Kibe Mongai, appearing with Ms. Wairi Mokeru for Julia Nyukafishege and 3 others. First of all, let me say that I'm very happy to be responding last, and particularly to have had that very good presentation by my long-term friend, Mr. Okiya Mtata. My Lord and my ladies, the petition before the court has been introduced. The petition is dated 22nd of August this year. It is supported by 2 affidavits, an affidavit sworn on 22nd of August by Julia Shege, and a further affidavit that she swore on 28th of August 2022. We have done submissions which were filed on the 30th of August 2022. That is when they were stamped. And we have also done a bundle of authorities as required. Now, having introduced the pleadings that we have filed, I wish to, looks like I don't have the petition, but basically the petition before the court, the petitioners are basically arguing for invalidation on the simple ground that there are so many violations of the constitutions and the electoral law by Iebc and its chairman, as the case may be, and as a result of which, those violations constitute such severe illegalities and irregularities that the results announced ought to be nullified. We have pointed out, for purposes of the specific issues raised by the court, we want to dwell with issues number 6 to 9 that were identified by the court. And to sum up, because before we go to the exact issues, is we shall basically be talking about 3 violations before we refer to the conclusion. Now, the first issue is the fact that over 700,000 people who ought to have voted during the general election held on 9th of August were deprived of the opportunity to do so. Number 2, we shall be arguing that the third respondent, that is the Commission, contravened or violated its duty of accountability, transparency, and public participation during the 4 stages that we shall shortly be outlining, and in a manner that it declared the results of the presidential election. The third issue that we shall be referring to is the fact that the third and fourth respondents violated the procedure set out in Article 138 of the Constitution in discharging their mandate of tallying and verifying the vote at the Bomas of Kenya. I start with issue number 1. The constitutional basis for issue number 1 is Article 38 and 138A of the Constitution. And in this, we are referring to the number of people, 700,000 by our count, who ought to have voted and were deprived of the opportunity to vote. Now, what is the complaint? The complaint, members of the court, is laid out at paragraphs 56 to 60 of the petition, paragraphs 56 to 60 of the Constitution. And the supporting evidence is laid out in paragraphs 24 to 28 of the supporting affidavit sworn on 22nd of August 2022. The long and short of those paragraphs is that the petitioners are basically saying that by virtue of Article 1 of the Constitution, the people's sovereignty is exercised in Kenya by 2 major methods: through voting, and collectively we only exercise that right during a presidential elections. And number 2, by voting in a referendum. Now, under Article 38, it is expected that the right to vote for a candidate of your choice is recognized. The same way under Article 138(3)A of the Constitution, voting at a place appointed by the Iebc by all persons eligible to vote. Now, on that basis, Regulation 90 of the Elections General Regulations Act, General Regulations 2012, were done under the Elections Act. Regulations 90 provides, is a short provision that I need to read, that the Commission may make provisions for the voting by election officials, observers, patients admitted in hospital, older members of the societies, members of the defense and security forces on duty, prisoners and nomadic pastoralists, and other persons who by reasons of any special need, including disability, are unable to access a polling station. 2, the Commission may from time to time publish notices on the manner and procedure of the conduct of special voting, and such notices shall be read as part of these regulations. So the long and short of it, but I want to tie up with the facts, in paragraphs 50, the petitioner says no such notices were issued with regard to the persons in contentions in this particular contest. Who are those persons? Those persons include at least 500,000 elections officials. They include at least 180,000 members of the security forces. It includes those people who are in hospitals and others who may not be in hospital. But they are placed in such circumstances that special arrangements ought to have been done to ensure that they were able to exercise their rights under Article 1 and Article 38 of the Constitution. Now, why have we chosen the figure 700? The figure 700, as you will see from the affidavit, has been chosen for the simple reason that there should be no contentions about it. These figures, these are elections officials. The Iebc chairman is quoted in the newspaper report that is attached to that affidavit, in fact confirming that indeed all this number of peoples will be engaged during the election day. Their engagement during the elections day follows up of necessity and in the nature of their duty that starts at earlier than 6 a.m. and ends long past the counting period that those are the people envisaged under Regulation 90, that special arrangements to ensure that they vote would be made. It is not denied in the face of how these complaints being made that those arrangements in fact were not made by the Commission. Now it is important to point out these regulations were made in the year 2012. Of course, it is interesting to know, faced by these complaints, how did Chebukati answer them? He answered them in his affidavit by first of all saying prisoners were allowed to vote under Regulations 90. He says diaspora Kenyans were allowed to vote under Regulation 90. And he also says very old people and sick people would be first on queue, and so such instructions were issued to ensure that those kind of people would vote first with a little bit more convenience than others. But Your Lordships, it is important to note that when it comes, for example, that prisoners voted, prisoners have been voting in Kenya in the presidential elections, not so much because Iebc has been complying with the law, but because I believe it was Judge Lenola when he was at the High Court, made an order first that prisoners who vote in the presidential elections, and number 2 in the referendum. And that was done. Even the reasons why diaspora voters vote in Kenya is again because of another subsequent court decision. So that where we stand today, for purposes of Regulation 90, the Iebc cannot give a single instance that in support of ensuring that as many Kenyans as possible will vote for the presidents of Kenya and exercise their rights to franchise has ever done anything. There is no evidence of that. Now, during the preparation of this petition and afterwards, for purposes of these kinds of violations of the right to franchise, it is a very serious thing across the world, because as many of us are entitled, and that is why even this right was given to prisoners, to ensure that we vote. You find in very many other countries where elections have been nullified because of the issue of franchise. But you do not have a single instance, that is to the best of my knowledge, that this has ever happened in Kenya. And this could probably explain why even after the Constitution is clear on this issue, that facilitations be made to ensure as many people as possible and those in special circumstances, those arrangements have never been done by Iebc. It is my submissions that given the results that were declared on the 15th of August this year, voting by up to 700,000 voters, even if that was adjusted, how many of them could have been registered and how many of them could actually have voted to the actual averages, you would still have arrived at a very big figure of more than 300,000. That directly, and on account of non-compliance with an express provision of the law, were unable to vote. Did the failure to make that accommodation, those arrangements, to ensure those people voted affect the results of the elections? Undeniably. If those people had voted, it is our submissions that the results of the elections could have been affected. And my Lord, it's in my submissions that unless and until this honorable court take up that issue as a serious issue of violations of constitutional law, then Regulation 90 could as well be an empty piece of legislation. And therefore, part of the enforcement of ensuring that the universality, that the free franchise and universality of it is respected, would be to ensure that a very serious elections was violated on its account. And it is on that reason that when we read our submissions, we are urging the court to do exactly that. Issue number 2 has got everything to do with the fact that the duty of accountability and verification, as we had said, was violated at various stages. It is my submissions that there are at least 4 stages in which this happened. Number 1, stage 1 ordinarily occurs the stage between 20th, the election period. A gazette notice was issued on 20th of January to signify the commencement of the election period. That period ended on the 8th of August. Then there is stage 2, voting day. Then there is stage 3, which is a 7 days period under the procedure set out under Article 138 of the Constitution. Stage 4, in my submission for purposes of a presidential election, it is the 21 days period under Article 40 of the Constitutions that you are dealing with right now. Now, what are the stages at stage 1? The issues at stage 1, and I will link them up with how they tie to the elections, is the fact that in this particular case, Iebc, according to my clients, was supposed to ensure that they set up a technology system that was transparent enough to ensure that the outcome would have credibility in the eyes of the electorate. The one single issue that we have pointed out for purposes of that in an elections where you've said you have recognized voters using KIMS kit, it has been recorded, it is our submissions that on day 1, in their affidavit they say 6 hours, that at least 6 hours after the conclusions of voting, Kenyans ought to have known what many people voted electronically and using any other complementary system of voting. And my lords, it is my submission that the failure to do that, one cannot be able to speak of a technology that worked if the most important component that a voter ought to know, the right of a voter to know, yes, we voted. If we reach this number, this man is president. If we reach this number, this one is president, or is in the opposition. That number ought to have been given without any dispute. There should be no controversy about it. Yet the fact that you have all these controversies about the register just points out to the issue that on that critical element, there was serious failure of that technology. But it may not necessarily have to be a serious failure of the technology. in the sense that it could well be that the manner in which now you conclude voting, Forms 34A were uploaded, but the actual figures were being named on day 2. This is day 2 after the arrival of all Forms 34A. It is our submissions and my hypothesis that any person, and nowadays there are so many books that you can read anywhere and you can buy anywhere that says how do you rig elections. If one was set out to rig an election such as this one, then one of the most important variable would be the voters register. And in this case, it is our submission that the fact that on day 1, 6 hours after the election, we were not told in a controversial manner, and after Kenyans have invested in a technology, that this number of people voted, this opened the system in the subsequent verification process to the kind of abuse that more other able people in that area have spoken about today. But that, on the face of it, appears to be where the opportunity arose. I go to the issue of still at stage 1, the issues of the nomination. We have said in our affidavit that for purposes of Article 99 of the Constitution, the presidential candidates were supposed to be subjected to qualifications under Article 99. The manner in which that was done for purposes of presidential election, the second respondent was actually not subjected to it, and at the end of the day, persons with unresolved questions under Chapter 6 is today Deputy-elect of the Republic of Kenya, arising out of the failure of Iebc to enforce the law. The next issue is the publication of a Gazette Notice number 9540 on 8th of August. This Gazette Notice in our submissions was an instrument of illegality. My learned colleague Mr. Nyambodi says that Iebc chairman is always inclined to produce Gazette notices even where none is required. I read it differently. If you read Gazette notice as an instruction manual, it makes a lot of sense. In this sense, that in the ordinary scheme of things, and particularly when I was working in the human rights movement, when you deal with a lot of police officers and other people on those junior ranks, this activity will be carried this way. They'll not tell you the penal code says this, the police act says this. They will tell you the forces standing order, which they are socialized to understand, says this. So this was the forces standing orders. So that for purposes of the day when this verification was being carried out under this, what we are calling stage 2, it was being, and it was published on the eve of the election. There is also the bad faith that on the eve of the elections, you publish such kind of a Gazette notice that runs directly counter to the Constitution. Why would anybody do that in good faith? There was lack of good faith. Because in the Republic of Kenya, during my practice of a couple of years in public law, we are aware this is the kind of stuff that we present in constitutional division and the judicial review courts to confirm whether or not it complies with the constitutions or statute. Therefore, when you publish such a Gazette notice, an instruction manual that would be deployed during the verification exercise, and the following day is a public holiday, you cannot be taken to have been done that with the best of intentions. We go to stage 2, voting day. Voting day, the first violations as we talked about, not everybody entitled to vote under Article 138 in the presidential elections actually voted on account of non-compliance with the law by the Iebc. The second issue for purposes of that day, I've already talked about it, is a voters register. That on the elections day, and we have said 6 hours, you needed to know how many of us voted. The moment that information was not provided, the system and the process was exposed to anything could happen. And actually by the 15th of August, the worst, and all that could go wrong actually went wrong on the 15th of August. And therefore, this is why we are saying these violations were not just minor violations. They were violations that indeed went into the heart of what is before this court, the disputed elections. At stage 3 is what we call the procedure under Article 138. Well, my constitutional law mentor, Dr. Gibson Kamau always used to tell me, and I believe most of the people who had the privilege to be his pupils, that the Constitution must be understood in a historical context. And therefore it is important that we understand Article 138 in a historical context. What is this context? This context, my lords, is this, that we do not have an equivalent of Article 138. We do 6 elections. The Constitution has not told you this is a procedure at the parliamentary elections or the governor or anybody else. It is only reserved for one position, the president position. The procedure are the presidential elections. And this was to leave no room of doubt that this is how in which the verification process ought to be carried about. My lords, the process after we vote in a presidential elections, I first voted in 1992. And since that year, the first multi-party elections, after voting, of course in Kenya they tell you, vote, go home, watch it on television, you will get to know the outcome. How it has always worked is that you are there at home, results are read from constituencies, from everywhere else across the country. It is a ritual that happens every year as far as I can remember since the year 1992. Now, what is the importance of this ritual? It is important to remember that in the year 2007, this ritual was disrupted by the events that happened at KICC. The disruptions of this ritual led to the post-elections violence, and the rest of it we are all aware what happened after that. So that it is not a simple ritual. And so that in the year 2010, when the Constitution was written, it provided for a sections and 7 days and a procedure, setting out in no uncertain terms, this is how after people vote for their president, we are going to process the issues. So that the Constitution having dealt with that issue against that historical background, you cannot have a situation where subversion through a gazette notice is tried to be effected. That would be treason in every sense of the word. I got to the issue of what's the importance of the ritual. To the winner of an elections, this ritual that we saw in this constituency, what you got in my neighborhood is very important. Because the people, while we are seeing all this being displayed, and remember that during Bomas, the display to show Kenyans that these are the results that were coming in, this is how the figures were adding up, that was disabled at some stage. So that what effectively this meant, that the true purpose of Article 138 ends up being defeated. Defeated in the sense that for the winner goes and declares that I had the most numbers in accordance to Chebukati. And the loser, everybody else says, I do not know how you got those numbers. I actually thought I had more than you had. This is what was tried to be prevented. But it is equally important, the procedure under Article 138 for the loser. Why is it important for the loser? Because the loser, and in this case the loser is a loser with say about 6.9 million votes, quite a number of Kenyans. This is a loser on his 5th time seeking the presidency. The last one says he lost under controversial circumstances. There was everything necessary to ensure that for purposes of these elections, if you are to lose the election, the math must make sense. It must add up. The Kenyans, those people who voted for you, must also see
that you did not do very well because it is clear these people in that other place did not vote for you as you expected. Now, but when you have now a true situation on the 15th, the dramatic events of the 15th of August, where even 27th constituency, my clients are there waiting at home. I was also equally waiting at home. Those results are not announced. Then how do the people who are supposed to be losers understand that they genuinely lost in the elections? That would strip the process of legitimacy. But it is equally important for another reason that Wallace Soyinka talks about in one of his essays. And I believe the essay is published in a book called Climate of Fear. And Wallace Soyinka, in an essay titled The Quest for Human Dignity, says that in war, it is important that those who lose a war should not be stripped of their dignity. And basically what this means is this, that even after losing war, you are not stripped naked in the sense that you are told you lost half of your country, but you must be left with the other half. That is if you are in the Russia-Ukrainian kind of situation. That is a whole idea that nobody should lose absolutely. And when the Constitution talks about fairness, about transparency, it is to enable that this is processed in a manner that everybody else would be able to understand and to process the victory or to process the loss, if it turns out that it was a loss. Now we go to the issue number 4. I wish I could say more. I'm just trying to watch myself. Stage number 4, the final issue is the Supreme Court issue. We served Chebukati with our affidavit. And I would not say he's arrogant because that may not be a permitted language. But the language that he used is one that shows lack of remorse. You will read the affidavit. On the issue of why didn't you make arrangements for everybody to vote? We were talking about specific people, election officials. Then he says, oh, prisoners voted, diaspora's people voted, and all these other people voted. Now, that was not the issue. I think they are needed, and this is accountability to the Supreme Court. And that is the design of the Constitution. That now that a violation has been committed, what do you have to tell the court about it? You could not even say it was an oversight. The next one I will recommend to the next chair to ensure it is done. There was no such thing. Then we go to the next issue. In our affidavit, the third petitioner says, I was disturbed about the events of 15th because in the morning of 15th at around 7:30 a.m., I was shown some text that seemed to show the results that now are being announced later. Why was it disturbed? Because at that time, votes were still being counted. People are being told in constituency A, this is what people got. How does Chebukati react to that? Oh, everybody with a good calculator could have downloaded these forms 34A and calculated. Now, Kenya is a country with extremely low digital literacy. To say, and when such a thing that would cause concern, that there was a problem, and you say this information was readily available, leaves a lot to be desired on the part of a public officer. I start with finishing with the issue of legitimacy. It is important that winners should have legitimacy. And it is also important that the losers also should be treated with dignity. When we read the affidavit of Honorable William Ruto, he says, oh, so many people, why are you pretending that you are acting for all Kenyans? So many people agree with my victory. But it is also equally true, so many other Kenyans don't agree with it. And therefore, in a constitutional democracy, as I conclude, it is absolutely important that when you win, and Article 38 says you win it this way, it must be confirmed. Thank you very much.
Thank you very much, Council. We would like to take the submissions by, I think, 4 respondents who are supporting the petition. That is the 4 commissioners. According to the time schedule we allocated yesterday, they were to share the 1 hour. But before Council, you take the podium, we are proposing just a 15 minutes health break. Then we come back because we will hear those submissions, and if there are questions from the bench to all the submissions that have been made, they will be directed to Council. So we'll need about 1.5 hours when we return to finish today's proceedings.
Tire, on the word from Justice Lenola, could the court find out what's happening to the question of scrutiny? Because it looks like we still have a crisis.
Yes, we shall. I'm aware.
Good morning, ladies and gentlemen. Welcome to the Supreme Court of Kenya for the hearing of Presidential Election Petition number 5 of 2022, as consolidated with petitions number 1, 2, 3, 4, 7, and 8 of 2022, the Honorable Raila Odinga and 7 others versus the Honorable William Ruto and others. The Ready Chief Justice will preside.
Thank you very much, our court assistant. Good morning, running council and the parties, distinguished ladies and gentlemen present this morning. We finalized the pretrial issues this morning, and on behalf of the 7 justices of the Supreme Court, we welcome you to this morning's proceedings. We have a tight schedule. Therefore, without much ado, we will ask the petitioner to start their case. But we will take the appearances. The quorum sheet, I believe, has been filled, but we can take the appearances.
My Lady, the Chief Justice and the President of the Court and members of the Court, for the first and second petitioner, my name is James Orengo. I appear with my learned...
With submissions by the petition, on behalf of petition number 2 of 2022, that is the Youth Advocacy Africa and Peter Kireka. We would like to clarify some issues arising from the scrutiny that is going on, and I will request my brother, Mr. Justice Laura, to do that on our behalf.
Thank you, CJ. We have received information from the Registrar of the Court that parties have been unable to agree on how to conduct the exercise in order number 7 of the directions given in the ruling on scrutiny and recount. That order reads as follows. That IEBC should provide certified copies of Forms 32A and 34A Book 2 used in the imputed election, subject to the applicants providing the IEBC specific contested polling stations for compliance thereof. We thought, in our wisdom, that that order is specific to contested polling stations, but what we have instead, Otieno Gola writes and said he wants the Forms 32A for all 229 stations. Joachim Bosch and company write and say they want for 238 stations. I believe the petitioners, first petitioners, have asked for 517 stations. Obviously, with the time we have, and you've already spent the whole day haggling on this, 24 hours or 48 hours are gone, it is now impossible to comply with that order, and therefore, the court directs as follows. The applicants shall only, the IEBC shall only provide the 32As and 34As Book 2 from 41 stations, polling stations, that are in the affidavit of Celestine Anyango Opio. That is the only way that exercise can be a meaning, can have meaning. And that those forms will be a sample for which you can submit in accordance with your pleadings. We cannot allow you, we said, to go outside your pleadings, because what's happening now, we are creating a new case out of these forms. So please stick to your pleadings, and once we get those, the report on those forms, you submit on them in the context of your pleadings. And so, Caleb Khalifa's petition, Willis Otieno's petition, that Willis Otieno, the petition by Raila Odinga, and the petition by Joachim Bosch. Those are the three petitions where these issues arise. Please submit only on those issues. I hope I'm clear. And we don't expect debate on this. We expect compliance. I thank you very much, CJ. I thank you, Council. And remember, CJ, and Council, this exercise must be conducted before 2 p.m. tomorrow. What will be undone by tomorrow will be undone. I thank you.
Thank you, Justice Renauer.
My lady, the Chief Justice and members of the court, we are also having difficulties with the orders relating to inspection of the servers. We have been given restricted access only to the result transmission system, and only it has not been granted yet, only to one server. And it is established that the IEBC has got 8 servers. We have taken the decision to write formally to the registrar in the hope that the court eventually can resolve this matter as quickly as possible, because we are running out of time. But there's no compliance in terms of the orders that the court gave.
We are aware about that issue. We are following up on the question, and as far as we know, the exercise is continuing. Should there be an issue later in the day or tomorrow morning, we shall receive a report. But as far as we know, by the time we got out of here, the exercise had commenced. There was an agreement on how to access the server that was given, and the issue of cloning is being addressed. So let's leave it for now. Let's report again tomorrow morning. I thank you, CJ. I thank you, Mr. Orengo. We are aware about that issue.
May I, with your very kind permission, Madam Chief Justice, I would like to rectify a mistake. We intimated to you yesterday that the 2 commissioners, Professor Guleye and Boya Molu, would have separate representation. That has been achieved, and we have Dr. Willie Mutumbwa, who is in court, and we have for Mr. Professor Gule and Mr. Peter Wanyama for Commissioner Molu. Thank you.
That is noted. We can now proceed to invite counsel for petitioner in petition number E002 of 2022.
Thank you very much, Your Ladyship, the Chief Justice, members of the court. I wish to make submissions this afternoon before you on behalf of the third petitioners in the consolidated petition. The petition filed by the third petitioner, initially as petition number 2 of 2022, raises or has issues that deal with all the issues that had been framed all 9 issues that had been framed for determination by the court. But in respect of issues number 1, 2, 3, 4, 5, and 6, I will rely on the written submissions that we have filed or that have been filed on behalf of the third petitioner. And I will utilize my time on my feet this afternoon to focus on issue number 6, the conjoined issue number 7, number 8, and number 9 of the issues that the court framed or the court has framed for determination. I wish to get straight into issue number 6. And my humble understanding of issue number 6, and I will read it just for clarity, whether the Iebc has carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 138(10) of the Constitution. Again, it is my humble understanding from the manner in which that issue is phrased, that what the court is inquiring into is not whether tallying and verification should be done in accordance with Article 138(3)(c) and 138(10), but indeed whether tallying was carried out by Article 138(3)(c) 3C and 138(10) by the Iebc. Time was taken by my learned senior colleague, Mr. Paul Mwangi, earlier on this morning, to make submissions as to what the Iebc is, the meaning and definition of the Iebc, and what amounts or what body or group of people then amount to the Iebc. And that is a submission of law, and I don't intend to repeat the submissions that were made by my learned senior colleague. But the issue as framed in number 6 invites a detailed factual inquiry. And that factual inquiry is the factual question of was the tallying and verification during the or after the presidential election that is the subject of these petitions indeed carried out by the Iebc. I wish to start my submissions by referring you to a press statement. And that press statement is by the chairman of the Iebc. I believe he's the second respondent. That press statement is dated the 17th of August 2022, and that press statement is to be found in volume 4 of the third petitioner's documents at pages 493 to 496. That press statement is dated the 17th of August. It is headed, the subject is staff murder, profiling, and misleading reports on the presidential election. It is under the hand of the chairman of the Iebc, and it is divided into 3 parts. I wish to focus my submissions on part 3. And part 3 is headed Declaration of Presidential Results. And I submit that this press statement is important because it is the first account by the second respondent as to how tallying and verification took place. In line 12, he states, for the avoidance of doubt, the law provides that the chairperson of the commission is the returning officer of the presidential election. I will emphasize on that the chairperson of the commission is the returning officer of the presidential election. I will submit in my submissions, and I will hope to persuade you that there is no such position as the returning officer of the presidential election. It is a creation of the chairperson of the Iebc, and it is created for the purposes of executing a very calculated scheme. Be that as it may, I wish you to then go on to the second paragraph from the end at line 34, where he says, as per Article 86C of the Constitution of Kenya, the results from the polling stations are openly and accurately collated and promptly announced by the returning officer. The next sentence is important. It is also important to note that Regulation 87 of the Election General Regulations provides, and he then goes on to state, that he, as the chairperson, is the one who is then empowered to tally or to verify and tally the results. Again, later on on page 495, he goes on to state, this constitutional mandate, and he's talking about the mandate to tally and verify, this constitutional mandate falls squarely on the chairman of the commission, who is the national returning officer. Again, he repeats that, as gazetted in Gazette Notice number 4956 of the 28th of April 2022. The role of the national returning officer for the presidential election is not a shared responsibility and not subject to plenary discussion of the commission. Very important, because at the end of the day, this is how the second respondent then tallied, verified, and declared the results, but we will get to that later on. He states in the paragraph beginning as the gazetted national returning officer that in the spirit of teamwork, the chairperson involved the commissioners. That is all he did. In the spirit of teamwork, he felt that there was no duty to involve them. All he did was involve the commissioners. And again, later on during my submissions, I will get to that. My learned senior colleagues who submitted before me dwelt in detail on the content of Regulation 83. The content of Regulation 83.2 and Regulation 87.3.1, Regulation 87.3 in its entirety, and the manner in which those two regulations enable the chairperson singularly to tally or to verify and tally results in the presidential election. I do not wish to take any time to go through those two regulations, merely to state that it is my humble and respectful position that those two regulations are inconsistent with the provisions of Article 138(3)(c) of the Constitution, because they enable the result in the presidential election to be verified and tallied in a manner other than envisaged by the Constitution. There is a substantive prayer in the petition to declare those two regulations unconstitutional. And I state for that reason that relief should be granted. Later on in my submissions, I will then make submissions as to the consequence of those regulations being unconstitutional and having then hopefully being declared unconstitutional by this court. The fact that the tallying and verification of the result in the presidential election was done solely by the chairman is laid bare in the provisions of Gazette Notice number 9540 of 8th of August 2022. This again was referred to by my learned senior colleague Mr. Firoz Noroji whilst he's on his feet, and this Gazette Notice is to be found at page 36 of the affidavit sworn by the second respondent and drawn by the firm of my good and learned friend, Mr. Eric Gumbo and Associates, at page 36 of that affidavit. Mr. Noroji took the court through that affidavit extensively, through that Gazette notice extensively. I only want to emphasize that before the election, the chairman of the commission is clear that it is he who will tally, who will verify and tally the results. And for some reason, the chairman has the chairman of the IEBC had the propensity to publish Gazette notices even where he didn't need to, because there was no need, there is no statutory basis or regulatory basis or even constitutional basis for gazetting the result pathway. But he went ahead and did it. And it is clear, and I submit it is admitted by the chairman of the IEBC that he exclusively, to the exclusion of the rest of the commissioners of the IEBC, tallied and verified the result for the presidential election. So as to determine conclusively that the tallying and verification was done exclusively by the chairman, it is again important to ask the question, where were the other commissioners? Where was the rest of the IEBC as the chairman was tallying and verifying the results? Again, I wish to refer you to the same affidavit that I have, the affidavit sworn by the chairman and drawn by the firm of G&A Advocates on the 26th of August this year. And it starts from the second paragraph. He states in the second paragraph that in my capacity as the chairperson of the commission, I was the returning officer of the presidential election. He then goes on later on in the affidavit at paragraph 45 to state that for the proper management of roles at the tallying center of the presidential elections, I had designated in writing specific roles to each of the commissioners and other commission staff. Annexed here to as WWC 9 is a bundle containing the said communication. Again, this bundle and this communication is important, members of the court, because it states clearly what the other commissioners or the roles that the chairman had designated the other commissioners to do. At page 41, there is an internal memo or a letter signed by the chairman on the 22nd of July, addressed to the Vice Chairperson Juliana Cherere and Commissioner Boya Molu. And it is headed Appointment to the Media and Call Center Management Team for the Presidential Tallying Center, Bomas of Kenya. And he goes on, he says, consequently, you are hereby appointed to the Media and Incident Reporting Team of the Presidential Election Tallying Center as follows. Juliana Cherere, team leader. Commissioner Boya Molu, alternate team leader. And their roles are set out there. Terms of reference of your appointment provide liaison between the presidential returning officer, who is himself, and the National Communication Center, preparing periodic briefs for the presidential returning officer to address the media, briefing the presidential returning officer on electoral activities across the country. Nothing to do with tallying and verification. The two subjects of that letter are commissioners of the IEBC. The next letter is on page 42, also dated the 22nd of July. This one is addressed to Commissioner Francis Wanderi and Commissioner Irene Masit. Again, under the hand of the chairman, and it is appointment to the Logistics, Welfare and Security Team at the Presidential Tally Center, Bomas of Kenya. Again, he appoints them in the second paragraph. Consequently, you are hereby appointed to oversight, provide policy direction and strategy formulation for the Welfare and Security Team of the Presidential Election Tallying Center. He then states their names and he states their terms of reference as security of the Tally Center and installations, the Tallying Center's logistics, planning and organization, security of members of the commission, staff, VIPs and other visitors, transport for commission staff, any other duties assigned. Important, those are two commissioners. None of them has been assigned to tally and verify. The third letter is on page 43, and this one is addressed to Commissioner Justus Nyang'aya. Again, Justice Changaya is appointed to be in charge of dignitaries and protocol. And in the second paragraph, he is told that as team leader for dignitaries and protocol, he will be responsible for providing support services to the Commission, managing protocol of dignitaries and VIPs, managing access to the Presidential Tally Center for accreditation, for accredited media, observers and agents, and any other responsibility. Now, those are out of 6 commissioners. Those are 5 commissioners. None of them is assigned to tallying and verification. There is a last letter, also dated the 22nd of July on page 44. This one is addressed to Commissioner Professor Abdi Guliye and Mr. Marjan Hussein Marjan. I wish to point out to this court and ask the court to note that Marjan Hussein Marjan is not a commissioner, but he is merely the CEO of the Iebc. Now, these two are appointed to the results management team at the Presidential Tally Center. Their duties are undertaking quality assurance of result forms received from the Presidential Returning Office desk, tallying and processing of election results. I urge that that is the language of Article 183.3, and assisting the Presidential Returning Officer in managing a record of the election results. Tallying and verification, I submit, on the admission of the chairman of the Iebc was done by Professor Abdi Guliye and Marjan Hussein Marjan, and not by the Iebc. The tallying process continues unconstitutionally as it was being conducted, and I want to pose the question and attempt an answer to the question, how does that process then end? That process ends as set out in paragraphs, again, the same affidavit of the chairman, at paragraph 76 onwards. But the story that he tells, or the deposition that he makes, starts in paragraph 66. And I will read it because it is important. He deposed, shortly after 2 p.m., the commissioners and I had a meeting to be briefed on the final results by the commission secretary, stroke CEO, an alternate leader of the Tally Center. The meeting was only for a briefing. He then goes on to say, the briefing was to be done before my declaration in accordance with Article 138(10) of the Constitution. So according to the chairman, all that was going to take place between him and the commissioners was a briefing, and he then goes on and declares the results. What did he do? After he narrates the story of the visit between paragraph 67 and 75, he then goes on under the substantive heading, Commission Briefing of Final Results. After the NSAC team had left, the Commission Secretary and Chief Executive Officer, who was also the alternate leader of the team of the Tallying Center, Mr. Marjan Hussein Marjan, walked into the boardroom. The purpose of the meeting was to receive the final tally of results of the presidential election before I could proceed to declare. From the chairman's own evidence, he assembles a team that comprises Professor Guliye and Mr. Marjan. They tally and verify the result, and Mr. Marjan is merely coming to brief the commission. What happens after that? There is between paragraph 77, where he states that copies of the results were handed to the commissioners, and that is all that was done. The result had been tallied and verified elsewhere. The copies are merely handed. There is a conversation. There is no agreement. And of importance, at paragraph 81, the chairman deposed as follows. I walked out of the meeting room accompanied by Commissioner Professor Guliye, Commissioner Molu, and the Chief Executive Officer. And he then went to the auditorium and declared the results. In the chairman's own words. And I submit that his narrative of what took place is important. That is how the tallying...
Decisions as an institution are by the majority. So do not depart from that principle, a principle that has found judicial anchorage and recognition in a number of decisions cited by my colleague Paul Mwangi, the minor KI decision, the Michael Kamau case, and the other decisions. Corporate decision, and that position has been addressed, and I do not want to take the time of the court by going through it again. With regard to each one of these 4 commissioners, I ask this honorable court to bear in mind that each one of them went through a very rigorous vetting by the National Assembly, at which there was full public participation before they got appointed, so that anyone who had any issue with any of them, that was the time to raise the issues. Again, the law is clear about how one can complain about a commissioner enjoying constitutional security of tenure. So do not be influenced with innuendos and insinuations about these 4 commissioners. They were vetted by the people's elected representatives. Now, coming specifically, this is the second fundamental submission I'd like to make. This so-called walking out from Bomas. Look at the affidavits of the 4 commissioners. The vice chair saw 2 affidavits, so there are 5 affidavits in total. And I invite this honorable court, when it retires, to read through those affidavits in their entirety. We adopt them. We rely wholly on the averment in those affidavits. And you will find in those affidavits that all that these 4 commissioners were demanding of the chair at Bomas at the tail end of the tallying and the verification. Their narrative, which I invite this court to accept, is that they were not involved in the tallying and verification, and in particular regarding the 27 constituencies. So they were demanding of their chair, you cannot bring a paper here and tell us that these have been verified and tallied by the chief executive. The work of the chief executive is to implement decisions of the commission. He is not part of the commission, any more than the registrar, the chief registrar, implements, or any registrar of the High Court implements the decision of the judges, not the other way around. So they were saying we need to tally and verify the results in respect of these 27 constituencies. And the chair would not allow that, which was typical of the relationship between the chair and these 4 commissioners. And a twist is being given that it is these 4 commissioners that wanted to force a runoff. It is the exact opposite, your leaderships and my lords, and that is what we state in the affidavits. It is them who were asking, how do we confirm that the candidate you are about to announce has received 50+1 votes? And his response was, are you trying to force a runoff? I am not conducting another election. So this acrimonious relationship is what was there between the chair and his 2 allied commissioners, and the other 4 commissioners. Now, I would like to submit that the 4 commissioners were fully justified in saying we cannot own results we have not tallied and we have not verified. The law has been referred to this honorable court severally, that it is the commission that should do the verification and the tally. This legal notice that appointed the chair as the returning officer, you've been invited to hold that legal notice, that regulation is unconstitutional and valid because it contradicts the Constitution and the Elections Act. But beyond that, it is the chair himself alone who appointed himself as the returning officer for the presidential elections. You will not find any minutes of any meeting by the commission appointing the returning officer. So quite apart from the fact that it was unconstitutional, it did not have the authority of the commission. I would like to cede ground to my colleague Apollo so that we operate within the 60 minutes accorded to us. I ask that this court upholds the position of the 4 commissioners, that the results that were announced were not the results tallied and verified by the commission. I thank you.
The Chief Justice and members of the court, without wasting more time, I'll pick it up from where the senior counsel has left. My name is Apollo Mboya. I am on record for the fifth respondent. Your Ladyship and my lords, the actions of the chairman of the Electoral Commission can be evaluated using several instruments. And I believe the first instrument that we need to use in examining the whole issues that are before this court is the oath that the commissioners take. The oath is in the 3rd schedule of the Iebc Act, so that for every action we juxtapose that oath to those actions, so that we test if the actions meet the tenets of that oath. And permit me to read what that oath says, and it's taken by all the commissioners. It states, I, then they say their name, having been appointed chairperson or member, as it can be, of the Independent Electoral and Boundaries Commission, do solemnly swear that I will at all times obey, respect, and uphold the Constitution of Kenya and all other laws of the Republic of Kenya. That is the oath they take. That I will faithfully and fully, impartially, and to the best of my ability discharge that trust and perform the functions and exercise the powers devolving upon me by virtue of the appointment without fear, favor, bias, affection, ill will, or prejudice. That is the promise that they are giving to the people of Kenya and to the whole world. Now, for every action that the chairman did, which I'll not go into because this particular affidavit of the 5th respondent has been cross-referenced by my other senior counsel and also learned colleagues who spoke before me. We juxtapose those actions against that oath that they took. So, for example, if we are talking about issuing a gazette notice, you look at that gazette notice with the law, then juxtapose it to the oath, if it meets that promise that they gave. Your Ladyship and my Lords, the fifth respondent is now affectionately called opaque. Affectionately. I say that because arising out of what transpired at the National Tallying Center, the four issued a statement in which they said they cannot own the results that were going to be announced by the chairman, and therefore they were opaque. Your Ladyship and my Lords, that term opaque is not coming from the ordinary. It's a term that was given by the Court of Appeal when they were making a decision in another matter which is now famous here called the Maina matter, which when they were looking at the role of the chairman vis-a-vis the other commissioners. And the court did indicate that to suggest that one individual alone can tally and verify the votes for presidential election is to suggest otherwise, to introduce opaqueness and arbitrariness to the electoral process. Those were the words of that court. Members of the court, we might ask if the chairman, as indicated from the affidavits that we have had, that it was his responsibility alone to tally and verify the results, then the question is, what were the other commissioners supposed to be doing on that election day? Were they supposed to sit at home and watch the screens just like any other Kenyans? But then again, the chairman went ahead and allocated them duties. With respect to the fifth respondent was given the role of media. In that role, the fifth respondent was supposed to explain even to the media why what they were reading, the results they were reading, are not being projected on the screens. The results that they read were not projected from Friday 13th. And when that question was put to the chairman to refresh, the chairman said, no, I'm tallying from the back end. Your Ladyship and my Lords, the sum total of this whole transaction is that the chairman usurped the powers of the commission. And it's our submission that after all is said and done, and after we get the reports of the verification, I believe that this court will arrive at a conclusion that the chairman of the Electoral Commission was actually an agent of a presidential candidate. That presidential candidate we will know by 5th of September. And if that's going to be the case, lastly, it's our submission that this court must go further and look at the theory of agency all the conspirators that did any illegalities, all irregularities, are agents of one another. The person who benefited from those irregularities and illegalities is a co-conspirator with the persons who perpetrated it, and they are agents of one another. And for that reason, we would urge that this court makes appropriate decision with that particular issue in mind. I call upon my learned colleague, Jotham Arua, to take over from me. Thank you very much.
The Honorable Chief Justice and the honorable members of the court, my name is Jotham Arua. I appear for the 7th respondent, Commissioner Justice Nyang'aya. I will be making submissions on the following issues. Issue number 2, whether there was interference with the uploading and transmission of Form 34As. I'll also speak to the issue whether there were irregularities and whether the irregularities affected the results. I'll mention briefly something to do with the reliefs that this court ought to make, and also issue number 6, whether Iebc carried out the verification exercise. So on the first issue, my lady and the honorable members of the court, the position of my client is that there were indeed interference with the uploading and transmission of Form 34As. My client maintains that this was done without the involvement of the commissioners, specifically the 4 commissioners. And it is their position, my lady and the honorable members, that it was done in clear violation of Article 81E of the Constitution and Article 86. Before I proceed, I wish to clarify that we have made reference to a number of authorities in our written submissions, but I will not refer to them because of time constraints. As regards interference with the ICT infrastructure, the Commissioner, in his affidavit, which has been filed before this court, and specifically in paragraphs 33 to 34, raises a number of issues. First, he maintains, my lady and the honorable members, that the server was accessed by unauthorized persons, and these included foreigners and some members of the Iebc. He mentions them by name. He further maintains that one foreigner by the name Gudino Omar accessed the server several times. He explains that a number of forms were pulled down and others uploaded. And he also maintains that there was revision of Form 34Bs. My lady and the honorable members, these allegations are contained in his affidavit, and I wish to point out that they have been responded to by Iebc. In their response, the first thing I wish to point out is that there is no denial that the logs that he annexed to his affidavit emanated from Iebc. The only contention being raised is how did he get them? That contention, in our humble submission, has no merit, considering, as he puts in his affidavit, that he was the commissioner in charge of ICT at the commission. If a commissioner who is in charge of ICT cannot access that kind of information, it is my submission that nobody else in Iebc can access them. The next thing that, and that admission, Madam Chief Justice and the honorable members, is found in the affidavit of Hilda Kavonga. That affidavit is filed by the firm of Iseme Kamau and Maema Advocates and is sworn on 27th of August 2022. And the admission is contained in paragraph 13, Roman 4. Beyond that, Madam Chief Justice and the honorable members, there is also an admission, and this, according to me, is a serious admission. There is an admission that the server was accessed by a foreigner by the name Gudino Omar, as mentioned in the affidavit of Justice Nyang'aya. But I wish to read to the court what is said as concerns this foreigner. At page 5, paragraph 13.7 of her affidavit, that is Hilda Kavonga, she says, Gudino Omar is the technical lead for Smartmatic, who provides support on the technology provided by Smartmatic. He's the technical deployment lead, and then in paragraph 8, she continues, they said Gudino Omar, being a technical deployment lead, his role is to deploy infrastructure, that is networks, server platforms, and services. In his capacity, he is supposed to have access to the said infrastructure to monitor by ensuring the system is properly running at all times. Now, the first point that we need to bear in mind, Madam Chief Justice and the honorable members, is, did IBC formally gazette Gudino Omar as one of the persons who had access to the server? Secondly, IEBC is enjoined under Article 81E to uphold the secrecy of the vote. How secret can the vote be if it is being constantly accessed by a foreigner from a distant location? What is the guarantee that this foreigner will not grant further access to other unauthorized persons to commit all manner of mischiefs? But more important, Madam Chief Justice and the honorable members, is the complaint by Justice Nyang'aya that Gudino Omar was uploading and downloading forms. There is silence with regards to that issue. Then there was the contention that other unauthorized IEBC staff also had access to the server. And their names were provided, Madam Chief Justice and the honorable members. In the replying affidavit by Hilda Kavonga, again they make this admission And with respect to one Abdidahir Maalim, it is argued, and I'm referring the court to paragraph 13, Roman 6 of Hilda's affidavit. She says, Abdidahir Maalim was a returning officer, and this access was limited to transmitting Form 34Bs and not to any other function. Madam Chief Justice and the honorable members, the list of all the returning officers, who participated are included in the affidavit of Juliana Cherera and specifically marked as Annex J C2. Unfortunately, the name of Abdidahir Mohammed does not appear. It is not indicated with respect to which constituency or which county he was the returning officer. It would appear clearly that there was a lie. Beyond that, the logs that were filed by Justice Nyang'aya were also analyzed by a forensic analyst, George Njoroge, and he submitted an affidavit to which he annexed a report. And in that report, Madam Chief Justice and the honorable members, it is clarified that Abdidahir Mohammed accessed the server more than 1,000 times. The question one would ask is, why would he access the server so many times? What was he doing? Madam Chief Justice and the honorable members, it is quite clear that the server was defiled. The next issue I would wish to speak to, and I can see I'm having serious time issues, is whether the IEBC verified the results. And it is my submissions that that did not happen. And I'm saying so for two reasons. First, and this is important because it's not been captured by my colleagues, according to the Constitution, it is not only verification by IEBC that is required. Verification is supposed to happen at two levels. First by IEBC, but secondly by Kenyans. That's why both Article 86 and Article 81E institutionalize transparency. IEBC should make sure that every processes that they are undertaking are laid bare for the public to see, so that the public can also follow the processes and undertake their own verification. For reasons that have already been explained, it is clear that this verification by the public was not possible due to the opacity that has been referred to by my learned colleague, Apollo Mboya. But then there is the issue of verification by IEBC, which also did not happen and could not happen given the circumstances of this matter. Madam Chief Justice and honorable members, you have been told how 4 IEBC commissioners were sidelined in the entire process. It is our submissions that it could not have been the intention of Kenyans that IEBC commissioners be reduced to spectators in a presidential contest. That is something which is inconceivable, and we would humbly urge this court to put a stop to this practice. There are other issues that I would have wished to deal with, but because of time, allow me to cede the floor to my colleague, Jeremy. Thank you very much.
Yes, my Lady the Chief Justice and the honorable members of the court. My name is Gordon Ogola, and I'm representing the sixth respondent, that is Irene Masit. My Lord, I'll rush through my submissions because I don't want to give more time to my brothers. I've been sent here by the sixth respondent to tell the court and the whole world that she's not coming here as a second-tier petitioner. She's not coming here as a surrogate of anybody, but she's coming here as a demonstration of her undertaking to protect, uphold, and defend the integrity of the Constitution. Indeed, while taking oath of office, she undertook to carry out her duties in compliance with the Constitution. In that regard, the sixth respondent was alive to the fact that in conducting the general elections, they had to be guided by the provisions of not only Article 81, 86, and 138, but also Article 10 of the Constitution. My Lord, the sixth respondent submits that the manner in which the election process was managed by the fourth respondent, up to and including the tallying, verification, and the declaration of the results, flies in the face of the provisions of the articles that I've cited. As will be seen in the affidavit of Irene Masit and corroborated with the affidavits of the other form commissioners, the chairperson excluded the majority of the commissioners from the tallying and the verification process. In fact, if you go through the affidavits, you will note that the only duty that they were assigned or that they undertook as regards verification and tallying was when they were summoned by the chairperson to be given the results in the office. My Lord, and the other thing that they only did is after he told them this is the results I'm going to read, was to give them the form 34C. They did not take part in the tabulation of what resulted in form 34C. My Lord, the sixth respondent had a legitimate expectation that as stipulated under 138 3C, that the tallying and the verification ought to have been done by the commission and not by an individual commissioner in the person of Chebukati. In fact, the exclusion of these commissioners did not start at that point while they're in Bomas, but it started at the point when he, Mr. Chebukati, unilaterally reassigned them duties that they would take at the floor of Bomas, which were completely at variance with the duties that they were holding as in the subcommittees that were running at the commission. My Lord, before the declaration of the results, the commissioners were expected to ascertain and satisfy themselves that whatever was being put into 34C was a true reflection of the contents of 34A and 34B, but they were never given that opportunity. My clients and the three commissioners have confirmed that they were not involved in the process at all that gave birth to 34C. My Lord, even during the declaration of the results done by the four commissioners, evidence that can be found in the affidavits shows that the only things they were given were handwritten pieces of paper with results in them. Those documents that they were given and which they were reading out to the public are not part of any accountable documents that can even be brought to this honorable court. Secondly, at the time of the declaration, my Lord, you will note that there were 27 constituencies whose results had not been verified. Even though the chairperson claims that they could not announce or declare the results of those 27 constituencies because of the chaos that erupted, but they had an opportunity again when things were calmed down and they came back to declare the results of the presidential elect. Can it therefore, my Lord, be said that the process that led to the declaration of the results were transparent, were accountable, or were verifiable if indeed the declared results were accurate? my answer and the answer of the sixth respondent is in the negative. In respect to my client's position as to whether she accepts or agrees with the results that were announced, at paragraph 73 of her affidavit, she states that without verification of results from the 27 constituencies, I believe it was not possible to determine a winner in the hotly contested 2022 presidential elections, and to that extent, I cannot vouch for the veracity of the result declared by Wafula Chebukati on the 15th, for there was no transparency on his part towards the declaration of results and final figures, and were not verified. I was kept in the dark by the chairperson with respect to tallying. That is her position. She cannot vouch for the results that declared William Ruto as the president-elect. My Lord, lastly, the conduct of exclusion by the chairperson of the other commissioners from vital activities of the commission was not limited only to the events that happened at Bomas. I will just cite a few. One of them was the manner in which he assigned the commissioners' roles to play at the Bomas. That was a unilateral decision. Secondly, the unilateral deployment, transfer, and gazettement of returning officers nationwide. That can be found in the affidavits of the sixth respondent at paragraphs 16 and 17. Then the third one is the deliberate failure to facilitate the contract implementation committee to oversee the implementation of the ballot papers, contracts, and task of inspection of the printed ballots at the vendor's factory in Greece. That is a function that ought to have been done to ensure that there was due diligence of the ballot papers that were being printed. That one, again, they were not involved, and that did not take place. Lastly, second last is the postponement of the elections in specific areas, including Mombasa, Kakamega, Kacheliba, Rongai, Pokot, South, among others. And lastly was the appointment and gazettement of the chairperson as the national returning officer. That again is not a decision that was taken by the commission unanimously. My Lord, in the end, it is apparent that in managing the affairs of the commission with regards to the elections, the fourth respondent as the chairperson deliberately created a dysfunctional system to aid and abet his criminal and evil acts that would be interpreted to mean that he had intention to subvert the sovereign will of the people of Kenya. We beseech you, therefore, to find that nothing good can come out of a dysfunctional body. I'll therefore call my friend Jeremy to continue.
Yes, my ladies and my lords, I'll be very brief. My learned friends have touched most of the issues. My name is Jenga Jeremy, appearing for the eighth respondent. I want to give time to my learned friend Issa Mansour. So just a few points for clarification. One, speaking for the eighth respondent. My ladies and my lords, the eighth respondent per se, because of his position, is still a commissioner with the Iebc. He does not want to be classified as opposing or supporting the petition. But the reality is this, that by him, and I think that's the position of the other, from the fifth to the eighth respondents, by telling the court the truth, by telling Kenyans the truth, what happened at Iebc before the elections, during the elections, and after the elections, by telling the court the truth. Unfortunately, they have no apologies for this. That evidence addresses some of the issues that have been framed by the court. One of those issues that, according to the eighth respondent, is addressed by his position, the one that is taken in his affidavit, is issue number 6. That is whether the IEBC carried out the verification, tallying, declaration of results in accordance with Article 138. My learned friends have covered that. The 8th respondent's affidavit has covered that. They were not involved in the tallying verification. So answering that question, the 8th respondent, it is his position that the presidential elections that were announced by the, I think the third respondent, did not comply. Now the other issue that I want to clarify, my ladies and my lords, or maybe I should address whether the issue number 1, 5, and 7. Again, because of the peculiar nature of the way the IEBC is run by the chairman, it is the 8th respondent's position that despite being a commissioner, he cannot even help the court in addressing those issues because the results that were announced on the 15th of August, the systems that had been put in place, the person who was in charge of them, it was not the commission, it was not IEBC, but that is the chairman. The chairman is the one who can be able to answer most of those questions. The results that were announced, his position is that those were not the results of the commission, those were the results of the chairman. Maybe the other issue that I should mention is that the 5th to 8th respondents, they've been branded all sorts of names. Some of them appear in the documents that are before court. Others have been mentioned out there. And my lord, what the 5th to the 8th respondents did by walking out of Bomas is because they did not want to give legitimacy to a process which they were not involved in. My lord, by taking the my ladies and my lords, by taking the position they did, as has been mentioned by my learned friends, they took an oath of office, and the oath of office that they took was to uphold and protect the Constitution. When they realized that the Constitution was being abused, their role that they were supposed to play was being abused by the chairman of the commission. That's why they took that position. Did they take that position so that they could support any of the parties? My lord, that is not the position. They were just exercising their right, what they had taken oath to do, uphold and protect the Constitution. So all these names, the way they are being seen, that like they are taking sides, they are not taking sides because they had any interest in the outcome of the elections. They took the position they did because they wanted to uphold the Constitution. My ladies and my lord, we have there are some authorities in our list of authorities that we would kindly request that you look at them. I know you've been referred to authorities within Kenya. We have gone out of the country. We have some very good authorities from India, the Supreme Court of India. I will not take time to go through them, but they will be of great help to the court even as you retire to come down with your judgment. My lady, because of constraints of time, I will leave the remaining time to my learned friend, Mr. Issa.
Good evening. My Lady Chief Justice, the Deputy Chief Justice and Justice of the Supreme Court. My lords and my ladies and my lords, in summarizing the position of the 4 commissioners who are now respondents in this consolidated presidential petition, Lords, we want to make the following submissions. One, as a commission, it is the position of the 4 commissioners that they did what was within their mandate to deliver a free and fair election as required by the Constitution. But in their quest to do what is right, what is required of them, there are problems that have been set out in the respective affidavits. And my lords, the first issue that you would note that springs from these 4 affidavits by the 4 commissioners is a question of lack of transparency. On the day after the voting ended, and also predates the general elections. You'd note one thing that is common and that cuts through the 4 affidavits is that they were excluded from the process that was going on in terms of verification. And what is clear when you look at all these 4 affidavits is that yes, there was that process where they appeared to read results. These results, and they've said this under oath and has not been controverted, were the results that were being processed on the floor of the National Tallying Center. They were handwritten. And that's important because they were handwritten. They would come out and read them to the agents and to the nation so that for each and every constituency, and these results were per constituency, people would know that these results have been verified at the National Tallying Center. You would note that in this affidavit, for the first 2 days, from the 9th to the 12th, these results were being posted or they were being aired in a screen that was available to the agents, the presidential agents, and to the media. That screen was paused or it went off. In all the affidavits, they said and they requested that this screen should be on so that as we go through progressively verifying and tallying the results, anything we announce here can be confirmed by both the presidential agents and by the voters who voted. That request was declined. The question is why? Why did the chairman refuse to put on those results and to verify the numbers that were being read to the nation? The second question that you'll see that arises in terms of the process of verification and tallying, that has been covered by some of the parties that have submitted today. You'd note that when that process reached the tail end, the 27 constituencies that had not been announced had not been publicly confirmed to have been verified. And in fact, when you look at the affidavit of Commissioner Wanderi, he says he had taken a break because he had been there overnight. When he came back, the first expectation was that these results would be confirmed, they had been verified, and that they had been announced to all the agents. The chairman takes the position there was no constitutional requirement or he had no legal requirement to do that. No, he had. Because the Constitution requires transparency and accountability. That is a process that takes place at the National Tallying Center. It is not a perfunctory exercise. It is not a ceremony. It is a constitutional process. And why this is important is that the document that was given to the commissioners by Mr. Marjan, as confirmed by Mr. Chebukati, was not a Form 34C. That was being undertaken not by the commissioners, but members of staff in the back office of the chairman. The commissioners did not see Form 34C, did not verify it, and they did not approve it before it was generated. In fact, in all of their affidavits, they say they never saw the Form 34C. What was given was a 3-page document, and that document has a problem. That document appears in the vice chairman's affidavit and the other 3 commissioners' affidavits. What you note about that document, and that was generated by Mr. Marjan as has been confirmed and presented to the commissioners, is a summary of 47 counties. It does not have the results that are required to be confirmed and verified at the National Tallying Center of the 290 constituencies. Why is that important? Because at this point in time, before the Form 34C can be generated, these 7 commissioners, and I'm talking to them as a commission, needed to verify that what we have announced before the nation and to the presidential agents, these are the results that have been announced publicly, and this is what has been tabulated for each and every constituency, and these are the results garnered by each and every candidate. And on the basis of that, then a Form 34C is prepared. That 3-page document is not a Form 34C. That is a document that the chairman came with, or he was presented, and then he went and declared the result. That was unconstitutional because the Form 34C needs to precede the Form 34D in terms of the commissioners approving that document. And before, because that is their role, that is a constitutional role. In fact, we engage these commissioners. We invest the billions that we invest in the commission, so that when this solemn exercise comes along every 5 years, that process, they take it seriously and they do it in accordance with the law. And the third issue about transparency. The commissioners were not aware of how many voters, and that figure was not confirmed at the time this figure was being given to them. The figures, and you'd note about the different figures that have been given, and in fact, I was asked to highlight this. When you look at the affidavit of Mr. Sonkuli, sorry, let me start with the chairman, Commissioner Chebukati, at paragraph 30 of his affidavit, the one that he saw, sorry, on the 26th of August. This is the one that has been prepared jointly by the firm of Gumbo and Company, my good friend. At paragraph 30, he gives the percentage 64.6. In Mr. Sunkuli's affidavit of the same day, and I know that an explanation has been given, on the 26th of August, at paragraph 25, he says at the close of voting that the turnout that had been reported in Kimskits was at 63.6%, and he gives the figures. Now, the commissioners needed to verify and confirm what the turnout was. And that required, and this is in public knowledge, and it has been confirmed by all the commissioners, that in a number of polling stations, the Kimskit failed, and they, in compliance with the law, they resorted to the printed manual register. The number of voters who voted without being biometrically verified had not been verified and confirmed by the commissioners. In fact, that information was never given to them. The number of voters who had been confirmed as having voted biometrically had not been given to the commissioners. So yes, they cannot change any of the results, but the process of verification and tallying and the constitutional process of determining who has attained the threshold is a joint process by all the commissioners. And that's where they come and say, what is a voter turnout? They confirm that process, because yes, they cannot change anything in the Form 34, even if they see glaring illegalities, they can note them. 2, that transparency required, then they confirm, because this Form 32As are not transmitted electronically. They are brought by this individual, returning officers from the 290 constituencies. There was a possibility. There were some places where voters could not be identified because their biometrics had a problem, and they could not be. And then there was, and that was allowed by the Court of Appeal. The final resort was to resort to the register, the printed register, to confirm that these persons, because they had the IDs of were registered voters. That is also a solemn process, because then they confirm, out of all this, were there any other voters that were identified manually, and then that number is verified, so we can come to the determination whether the 50+1 had been attained. They were not allowed to do that. And they requested, it's not that because there was an oversight, they requested and the chairman declined. So this transparency at the National Tallying Center is critical, because as a commission, you have to come and defend the process from the Gazette notice that was issued in January of 2022 to the final declaration. And the fact that the chairman was stubborn is a question, as set out in these 4 affidavits, is that he has contempt not only for his fellow commissioners, but also for the voters, and also for the people of this republic, as well as the institutions, because that's exactly what he was told as the chairman, not him as a person, in Maina Kiai, that the chairman of Iebc does not have that role singularly. That is a role vested in the commission. failure to adhere to a decision that is binding on the Commission and the chairman of the Commission is contempt not only of the Constitution, but of the institutions, of the judicial institutions that have said this over and over again. And let me go back to the lack of transparency in the process. When you look at the affidavit, which is the most detailed of the Vice Chairperson of the Commission, there was lack of transparency regarding even when the ballot papers came to this country. The chairman calls it the Vice Chairperson the night before the ballot papers are to land here and tells, oh, you're aware that tomorrow we are getting ballot papers. The other commissioners were not aware. This is part of the critical process that was meant to be undertaken by the Commission. So transparency is just not at the tallying center, it's about the whole process. Well, if you look at paragraph 8 of Vice Chairman of the Commission, Juliana Cherera, she says, when it came to the issues raised about the voter register that were being addressed in one of the petitions, serious issues had been raised by KPMG. And so that required prompt, because this process was already late, it required a plenary decision on how to address the shortcomings and the lack of integrity of the data in that voter register. The Vice Chair says they were excluded from that process by the Chairperson. So if there was any problem with the voter register, it was meant to be addressed by the commissioners, because they take ownership of the voter register. They were excluded. He made the decision on how to implement the decision and even what to disclose to the public. So these are the processes we're saying. Transparency and accountability in the whole process, and Article 81 and 86 is just not about the final product that appears on the telly. It's about what the commissioners are meant to do. And lastly, when you look at the affidavit of Commissioner Justice Nyang'ai, if anyone was to be given access to the voter identification, the result transmission system, or the back end, the commissioners needed to know we are giving the following persons access and the following rights, so that if there's any query, they can answer on behalf of the commission. That information was kept away by the commissioners, from the commissioners. And in fact, the commissioner in charge of that process. Lack of accountability and lack of transparency. And then these 4 commissioners who are being vilified are expected to come and stand behind the chairman and take ownership of such a process that has so many questions, and then confirm that a person has been declared the president without following due process under the Constitution. They took an oath, and they have a responsibility and a constitutional obligation to the voters and to the people of Kenya not to take part in such a process. And that's what they did on the day of 15th. And the day of 15th is important because if it was the last day, there could have been an explanation as to why the chairman was in a hurry. There was one more extra day. Why was the chairman in a hurry while the choir was singing? The country was peaceful. He had one more day to ensure that the whole process was undertaken in a manner contemplated under the Constitution. And so, my ladies and my lords, we submit that these 4 commissioners, and although they have taken a position here and they've now been they've been sued as respondents, had every right not to give a seal of approval to that process that was not verifiable, it was not accountable, and had not been undertaken in conformity with the Constitution. They respect the work that all the staff of the Commission had done, but they were betrayed by the chairman. Thank you, Chief Justice and judges of the Supreme Court.
Thank you very much. It is now time for the judges to ask any questions or clarifications in regard to the submissions we have heard today. We expect the answers when you will be making a rejoinder. We are not expecting the answers now. It's when you're making the rejoinder. I will start with the Honorable Justice Ouko.
Thank you, Judge President. I have three very short clarifications that I want to seek from the team representing the first petitioner. The first one, perhaps I can direct it directly to Senior Counsel James Orengo. What is the relevance of rejected votes when computing the results or the outcome of a vote? The relevance of rejected votes. The second one, I would have addressed it to Ms. Soweto, but the team can deal with it, and you are not answering us today. The postponement of elections in certain areas, and you say this resulted in voter suppression. That people wake up one morning to go and vote for a particular category of candidates, that I go to the voting or polling station to vote for an MCA, or is it called MC? That people go to vote for a senator, but not the other positions. Do we have any scientific nexus on this, or is it just an assumption that this happens? The last question for me is on the reliefs that most of the petitioners have sought. We were addressed by Senior Counsel Feroz Noroji and also Senior Counsel Professor Jenda on the reliefs or the relief in Section 80, subsection 4. And I'm wondering, what are some of the elements that must be satisfied before the court can act or can grant the relief under Section 80, subsection 4? That would be all from me, my lady.
Thank you. Justice Renara.
Thank you very much, Chief Justice. Thank you, Counsel. You've been most helpful to us, particularly to myself. I have three questions, four, I think, very short ones. The first is to Senior Counsel Philip Murgor. You addressed us on the PDF format of the forms, but in the pleadings, there is a JPEG question. Would you like to?
I would like to immediately correct that. It should be
Yes.
JPEG, not PDF.
Oh, okay. So it was JPEG. It was JPEG.
JPEG to CSV.
Okay. Would you then like to connect? Because you addressed us, I think you didn't connect the JPEG to PDF, and then you said CDF.
I will, but I'd just like to clarify that that was a mistake on my part.
Okay. Correct. But just clarify when you answer, so that we can get it right. And also in the context of the staging and tampering and so on, explain to us how that happens in real time. Give us, say, Kagera Primary School Form 34A. What exactly happened in your theory, because you say some of these things you don't have? How was Kagera Primary School interfered with the Form 34A? Number two, Mr. Arwa, and this could also go to the other counsel appearing for the commissioners. You've raised many issues going way back before the election. The Venezuelans, mistreatment by the chairman, we're not allowed to do this and that. But we saw your clans in public reading out results. And that's what I'm calling my acquiescence question. They did all these things until the 11th hour. What evidence do we have that this is not an afterthought, that they're not doing this in good faith? What evidence do we have, apart from the question of the instructions to counsel, the meeting they called? why do we have anything showing that for the last 3-4 months they documented these grievances and that there was therefore a storm brewing? My own sense of things is that when you come only at the point of final declaration, how then do we trust that in fact there were issues before? Tied to that, what role did violence play at Bomas? Because we have the evidence of the chairman that I couldn't do this because I was attacked, Gulia was attacked, we couldn't announce 27 polling station results, constituency results. What role did violence play at Bomas? I think you need to explain that as the commission, which is what you've said. For Firoz Noroji, Regulation 87.3, you've asked us to declare it unconstitutional, declare it inoperative. Please address that issue in the context of retroactivity and retrospectivity. At the time these things were happening, it was the law. You're telling us to now declare it unconstitutional. What happens to events? And you know what I'm asking about this. Mr. Ndegwa, you made a very innovative, I must say, submission regarding the diaspora vote, the number of constituencies. In answering my question, please go back to Article 89.1. 89.1 says there shall be 290 constituencies for the purposes of the election of the members of the National Assembly. We are addressing a vote in a presidential election. Please connect 89.1 with the presidential election. Otherwise, the way you left it hanging, someone would ask the question, what has this got to do with this court and the petition before us? I thank you, CJ. I thank you, Council.
Yes, let me just take up from where Justice Lenaula has with Mr. Ndwiga. Mr. Ndwiga, if you look at Article 38.2, every citizen has a right to participate in elections. How then do you reconcile that with your argument on Article 89? Because constituencies don't vote, citizens do. So again, prisoners, persons in the diaspora, how are they to be provided for if we are to follow your line of argument? My next question was to Philip Murgo. I was drawing a chart when you explained to us that what you're telling us is that in the evidence that you have is that the Form 34 went into the Kim's kit at the polling station to the constituency. Then between the constituency and the public portal, the Form 38's numbers were changed. They were changed in that sequence, if I'm to understand you. Now, I don't understand much about ICT, but I presume that at the polling station, when the Kim's kit takes the image, these forms are written in handwriting. How can you explain then, so that I can understand, how a form can be changed in handwriting? This is not typing, it's in handwriting. All these forms are being uploaded and changed, different people's handwritings. How does that happen? For Ms. Soweto, she's not here, but since we'll answer later, I was curious about the issue of voter repression and her arguments on that. If we look at the Constitution, Articles 136, 177, 180, each of these elections are separately provided for. So you have the presidential election, which has its qualifications, nomination process, even the dispute resolution process of a presidential election is separate, the governor is separate, the member of parliament is separate, the MCA is separate, and what happens when a voter goes to vote, they get 6 ballots. So it's 6 ballots into 6 ballot boxes. What we have then is 6 different elections, but on the same day. So if your argument is voter repression, then is the voter repression only to the presidential election? Or is that an argument that can be used by an MCA in Kakamega County to say that because the gubernatorial elections were cancelled on that day, my MCA votes have also been affected. Or, I mean, is it just the presidential election that the voter suppression argument is standing for, or is it all? Because they are all separate elections. So how does one election affect the other? I think those are my questions for now. Thank you.
Thank you. Thank you, Chief Justice. Just a few questions. I think this could go to, I think, Mr. Orengo. You started us off with this elephant in the room, this 50% plus one. And I've read the submissions, I've read the affidavits. There is something still surrounding this question of voter turnout, the percentage. It's like the beginning of where the controversy is located. What is the relevance of the percentage of voter turnout to determining whether a candidate marshaled the magical number? And then back to Mr. Murgur, this staging. Again, I've been intrigued. I've been reading. If I understood you correctly, and if I understand the affidavits correctly, we are having this Form 34A. The original, which is filled, leaves the polling station to go to the National Talent Center by road, let's say, for ease of understanding. Its image leaves to go to the same destination, but this time by air. Somewhere along the line, in mid-air, the image is captured. And then all sorts of things are done before it is re-uploaded. Which means, therefore, if you go to that captured image, which has been re-uploaded, you will find different content from what it had at the polling station. So, to determine whether that has actually taken place, you would have to go now to the tallying center and locate that one that left by road and compare. Is it possible that that capturing in mid-air also somehow magically changes the content of the one that left by road? Okay, just because I just want to understand. Then let's get back to the 4 commissioners, because this is serious. We were informed by, I think this must have been Mr. Nyamodi, quite graphically, that the 4 commissioners were located roles other than those for which they were appointed as commissioners. Some were heads of protocol, I think others were media, welfare. Interesting stuff here, allocating such roles to commissioners. Why didn't they protest? Is this chairperson we are dealing with such a terror that nobody can face him and tell him you can't do this? Because now what we are hearing, these are serious disclosures. Because you can imagine I being, but because I was annoyed by, not annoyed, upset by my friend Willis for having tried to compare. So I'm just wondering, why is it that very serious Kenyans did not seize that chance and protest to the Kenyan people that what we are being given, the roles we are being assigned, have nothing to do with tallying and verification and carrying out our constitutional mandate. I think this is tied to my colleague here, is why to the tail end. Because I'm sure the voter out there also wants to know. So let me leave it at that.
Thank you, Honorable President. I have a few questions. And the first one would refer to the lead petitioner, or rather the main petitioner, the first petitioner, if I may say, in the lead file, which actually initially was petition number 5, E005, Raila, Odinga, and Martha Karua versus the respondents. And later on, after consolidation, it became the lead file and file number 1. I'm concerned with the reliefs that are sought, the alternative relief sought. The first relief relates to the issue of scrutiny, which is ongoing, and the issue of the threshold, constitutional threshold of 50+1. And after the inquiry, you would like that after the scrutiny election and the inquiry on the election technology, all the claims which have been made, and that after there should be nullification of the results, and then an exercise of recount, and after the recount and tally, that the chair be directed to declare the petitioners as the petitioners. That's the two petitioners, Raila and Martha Karua, to be the successful, or to be the winners of the elections. That's one of the. So I was saying that we would like you to lay a basis, legal basis for this in your rejoinder. No remedy that has been pleaded is going to be taken casually. Every pleading, every relief that you have sought, we are taking it seriously as a court. Therefore, because you will not just do it cosmetically, you must be meaning it. So, is this doable? Is this feasible in law and in all other practical ways? We want one justification, and from, I think even suggestions were there in 2017, but now we are here. So I would like you to firm up that and give us justify the legal basis, the constitutional basis of that, and whether lawfully, constitutionally, that is possible. Of course, we'll be coming to the issue of the capacity, after all the allegations, the capacity of that chair carrying out to be in charge of the exercise of the next process, if you are successful. But before that, okay, there's the alternative that if that's not workable, then a fresh elections take place. Now, that's the problem I'm having is that if an election is to be ordered to be done now, yet one of the reliefs you are seeking is that the chair and substantially the commission, but effectively the chair, you want us to hold him or to declare that he is not fit to hold public office because of his malfeasance, because of his the illegalities, irregularities, even allegations of fraud that he is perpetrated, that is not fit to carry out that exercise, to be in charge of such elections. Our Constitution, I believe, has never contemplated and envisaged such a serious situation, such a lacuna. And you know, we are all peaceful, loving people. We believe in the rule of law. We believe in constitutionalism. How is that possible? What are your proposals practically on the ground? If suppose this was done, how do you want us to navigate and apply the law? Is that possible within the law? These are serious issues. These are serious remedies you're asking for. In the meantime, what is the de facto state? What is the status quo? Is that underpinned under the law? These are the questions that we would like to ask, because as you know, in Kenya we have never had a state of emergency, and we all never contemplated, and I don't wish to think about it. Finally, Yeah, actually, that is all. Because the other questions have been asked quite exhaustively by my colleagues. Thank you.
Thank you, Judge President. The challenge one faces when they talk about the same subject at the end of a conversation by many people is that they find themselves repeating issues. But I will still ask what I had noted down during the proceedings, and you can choose the manner in which you will answer them. For Team Orengo, my concern is, and actually for everyone who has spoken about the commission, what we have heard is what, about this commission, is what some time back we had someone describing, was it an accident or something on TV, and we were told it looked like a video and drama. At least that's how I perceived the submissions on the commission. And so my concern is, when did this commission become this dysfunctional? The effect of becoming that dysfunctional? What corrective measures were attempted, if any, and with what result? My second concern is from 34A. Minor Kiai told us that this election is done not at Bomas, but at the polling station. And for the presidential election, the return of that form is first by electronic transmission. And so, the way I understand it is that a photo would be taken of the form at the polling station. A photo. I want you to tell me whether it's called a photo or what it is called. Is it called a photo? Is it called an image? Is it called what? That's the question I'm asking. And so that time when it is taken, and as it is being sent originally, is it in PDF form? So the journey, because this has to be understood, the journey from the polling station to Bomas, the things that happen in between must be described by the nature of that image at the original place, at the starting point. My other concern, which ought to have followed the first one before this PDF language, is what is to be done as a corrective measure against the chair of this dysfunctional commission. And is it to ignore the constitutional procedures and safeguards that are already in place? My final concern is concerning the relief to declare. What I have heard since morning, because of the dysfunctionality of the commission and a few other things, is that nearly everything about Articles 81, 86, the Act, have been impugned. In fact, one of you told us that everything that would possibly go wrong went wrong. So if every process that was undertaken in this process has so far been impugned, are we nevertheless to declare a winner? The figures, in the event that we arrive at figures that show that either the current president-elect has more votes than others, and or the petitioner in petition number 5, in fact, has more numbers, what are we to do? Are we still to declare? Irrespective of all the other processes having been impugned as you have submitted to us today. If you assist me with some direction in those issues, I shall be in a position to deal with the petitioner's case. We'll see what we'll do with the respondents when their time comes. Thank you, Judge President.
Thank you. I think all the questions I had have been asked, but I'd just like to follow up on what Justice Ibrahim asked. The team on the Reid petition, they have been called Team Senior Counsel Orengo. You have asked us to find the chairman culpable of various breaches of the Constitution. And as Judge Ibrahim explained, you have even told us to find that he cannot. Should we find that there should be a repeat election, he cannot preside. My dilemma is, this is a constitutional office order, under Article 251(2) of the Constitution, there is a detailed procedure that is provided for the removal of a constitutional office order. And what I would like you to address us is, how do we go about that? Would we be making an order that is contrary to the Constitution? Because like the judge was explaining, we are a country that believes in the rule of law, in the right of a person to have a reply, to be tried. So, you know, for the breaches that EOC has committed. Mm-hmm. And that is also related to the issues you have also cited about criminal culpability. I want you to address us on, because we have an Election Offences Act, so that if somebody has committed an election offense, they ought to have been charged and tried before the court with the jurisdiction. In this case, I know we gazetted some magistrates to deal with election offences, and my question is whether we wouldn't be usurping the powers of the magistrates if we have to make any order regarding election offences. Then to the team led by Senior Counsel Mr. Mwite, for the 4 commissioners. I still want to understand at what point the commission ceased to function as a corporate entity. Is it when the 27 constituencies were not announced? Or is it when, I am really trying to understand that, because we saw them announce regularly the results at the plenary in Bomas. We really want to understand, like the Vice President is asking, when did the Commission become so dysfunctional? We really want to understand that. Is there a stage where they were working together in tallying and verifying, and then they went and announced, and then suddenly there was a stoppage because the announcements also stopped streaming live? So we really want to understand that. Then my last clarification will go to Mr. Kibe Mungai. And I want you to answer this and tell us how you know that IEBC did not make arrangements for certain categories of people to vote, especially the IEBC staff. How do you know they did not vote first before they started the exercise? Because they were in a polling station, they could have transferred their vote to the station where they were conducting the exercise and voted. You know, because this seems quite subjective, so you needed to explain more that you know 700,000 people did not vote because IEBC did not make arrangements. I think those will be my questions or clarifications that I will be seeking from Council.
Justice, I have one follow-up. May I piggyback on your last question? Section 6 of the IEBC Act, 6.1, says that the chairperson of the commission shall be a person who is qualified to hold the office of judge of the Supreme Court under the Constitution. Then 7A says that the chairperson or member of the commission shall become, the office shall become vacant if the holder dies, resigns from office by notice writing to the president, or is removed from office under Chapter 6 or Article 251. In that context, if perchance we were to order removal of Chebukati as chairman, would the commission still be intact with the remaining 6 commissioners without a chairman of that qualification? I'm just wondering for my own sake. Thank you very much, Chief Justice.
I think that brings us to the end of today's proceedings. It was a long day.
Information, Madam Chief Justice. There is still an issue arising out of the scrutiny. I am told I would like my learned junior to explain, because he's the one covering the technical issue of the scrutiny.
Good evening, my lady, the Chief Justice and the Honorable Judges of the Supreme Court. My name is Eric Gumbo. We've had interaction with my colleagues who are handling the scrutiny, and they give us the indication that there's been very good progress so far, but there's one specific issue which they would want to get clarification from this court on, that arises from order number 2. Specifically, the use of the word forensic image. Now, the applicants appear to be interpreting that to mean an opportunity to get the image of the entire server. Now that is causing a bit of a concern, because then it means if they have the image of a server, technically they'll have gotten access to everything that certainly is contained in that server. It means that that order will be so far-reaching that after that event, it may not be possible for the Iebc to use that server again. It then particularly concerns the Commission, because if perchance there was an order for a repeat election and you don't have that infrastructure, it then means that that election may not be conducted. The other concern is the potential breaches that might be in relation to third-party licenses that are contained, and so therefore it really is important that we get clarity on that question so that then the exercise can proceed smoothly. I am most obliged.
Yes, with your permission, Madam Chief Justice, ladies. I raise because after we broke off over lunchtime, I personally went to the Iebc offices, 21st floor, where the exercise was going on. And I'm sorry, but I don't think what my learned friend has said is exactly what was going on. First, the team that was sent by this court to supervise did come up with what was an implementation matrix and laid it out. I think this was done yesterday. And what I learned is the biggest problem that has been going the whole day are arguments about this implementation matrix. And as by the time I left at 3 o'clock, nothing had happened. And even some of the simplest issues as giving copies of the technology system security policy had not happened. So what I met is an argument between technical computer people about what they should comply or not comply with, about what forensic, for instance, the issue of the forensic image is not correct, that the demand was for an image of the entire server. In fact, what I meant had been agreed on was that the part of the server that was supposed to be forensically imaged was going to be cloned so that there's no access to the, and that had also been agreed on. But when it came to implementing it, there were always new arguments. And in my estimation, what I found is that there is nobody at Iebc who this order is directed at, who is responsible for ensuring that these matters are done. I went, the CEO of Iebc was there, the director of ICT was there. There were 2 or 3 lawyers from Iebc and a host of other technical people. And all that was happening was arguments happening between one team and another team. The CEO says this, but he doesn't talk, so other tech people come, argue with the people from the political parties. That is the confusion that is going on. And therefore, unless this court addresses its order at a specific person, who then can come in case there is doubt as to what these terms mean, can themselves come for clarification, then that confusion will go on. But either way, we did try to sort out the problems that were there. I left at about 4 o'clock, the process now starting. The advice I give to the team is, let us first see what happens in the several hours, and then they will say what is it they are not getting, and we can report that to court. I will be going there after this to find out how far that has gone. I still feel very strongly that this court needs to make somebody from Iebc responsible for the implementation of this order. Thank you.
My lady, my lord, sorry. Without appearing to belabor the point, sorry.
Sorry, yeah, being given an example of one of the issues that arose is because there's also an argument going on as to how many servers are involved. There was talk of only accessing one server, then there's a whole range of technical arguments as to how many servers are involved in an RTS and how many should be shown. Team is saying that there are about 8 servers involved, that they've only gotten access to 1, that they're not getting access to the other 7. There's nobody at Iebc who takes responsibility to answer that question, so nothing gets done. Thank you.
Sorry, my lady. Sorry, my lady and my ladies and my lords. Without appearing to want to belabor that point too much, I think when we got back after the short break that the court took, Justice Lenola did indicate that there was fairly good progress in all the fronts, both in for the House and in anniversary. So it certainly cannot be true what Council is saying, that there has not been progress, because then that would impute that Council is even saying that the court is not saying what is happening. We have gotten very clear indications that there's been, there are 4 compliance items that were raised. There were 4 compliance items that were raised. Out of those 4, item number 2 has been resolved, item number 3 has been resolved, item number 4 has been resolved. That is the current update that we are getting from our team. The only item that is outstanding is the question of forensic image. And I think there's substantially good progress. It is not accurate to report that there's no progress. We have our director of ICT who's personally taking charge there and is the one who's updating us on what is happening. I think if we could get a clarification in relation to what that forensic image is, then we will be able to complete the exercise. I'm most obliged.
Thank you, Councillor. I think from what we understood when we took the break for lunch and when we came back, the issue of order number 2 had been resolved by the question of cloning as opposed to the security question of forensically imaging the server. So what we gathered, and that's what I said when we came from lunch, was that there is progress. Let us revisit it later today after we leave here. But as far as we were concerned, the resolution was that they'll do some cloning, and then any concerns that this team would have would then be presented to us tomorrow, having also gotten a report from our team. But at the time we came, there was good progress, and that's what Mr. Gumbo is saying, so far as we knew from our team out there. So perhaps, CJ, the way to go, let us go back ourselves, perhaps get our report from our team, and should there be any need for a direction tonight, we could do that remotely, and if not, then we give a report in the morning, because we gathered that the progress was immense and that something would be perhaps actually finalized tonight. I think that's the best way to go, instead of us going back and forth, and we don't have a report from our team. So would you allow us to do that, then we come back to you. Thank you, CJ.
Thank you very much. I think fatigue has settled until even my own gown has tethered me to the seat. I cannot move. But with that clarification, and just to remind ourselves that our team is led by the registrar of the court, who is going to make a report to this court. Council Paul Mwangi, I think what you are making to us was a kind of a report. So let us see how we can cooperate and get the best evidence that can assist the court. With that, allow me to wish all of you a good night and look forward to seeing you here tomorrow at 9 when we start the questions will be answered in the rejoinder. Yes, have a very good night.
morning, ladies and gentlemen. Welcome to the Supreme Court of Kenya for the hearing of Presidential Election Petition number 5 of 2022, as consolidated with petitions number 1, 2, 3, 4, 7, and 8 of 2022, the Honorable Raila Odinga and 7 others versus the Honorable William Ruto and others. The Ready Chief Justice will preside.
Thank you very much, our court assistant. Good morning, learned counsel and the parties, distinguished ladies and gentlemen present this morning. We finalized the pretrial issues this morning, and on behalf of the 7 justices of the Supreme Court, we welcome you to this morning's proceedings. We have a tight schedule. Therefore, without much ado, we will ask the petitioner to start their case. But we will take the appearances. The quorum sheet, I believe, has been found, but we can take the appearances.
My lady, the Chief Justice and the President of the Court and members of the Court, for the first and second petitioner, my name is James Orengo. I appear with my learned learned counsel, senior counsel, Firoz Noroji, together with my learned friends, Mr. Paul Mwangi and Ms. Julie Soweto. We also appear with senior counsel, Mr. Philip Murgor,
of the Iebc that should inform this court's decision, not the views of the minority. The official position of the Commission is as per the views and the majority of the commissioners. And that has to be so in law. The reason being that under the Constitution, and in fact under the statute, the Iebc is a corporate entity. Therefore, in the absence of consensus, its decisions as an institution are by the majority. So do not depart from that principle, a principle that has found judicial anchorage and recognition in a number of decisions cited by my colleague Paul Mwangi, the minor KI decision, the Michael Kamau case, and the other decisions. Corporate decision, and that position has been addressed, and I do not want to take the time of the court by going through it again. With regard to each one of these 4 committees.
Good afternoon. Let's proceed with the continuation of the hearing of Presidential Election Petition number 5, as consolidated with petitions number 1, 2, 3, 4, 7, and 8 of 2022. Raila Odinga and 7 others versus William Ruto and others. The Honorable Chief Justice will preside.
Thank you very much. Good afternoon, everybody. Before we proceed with submissions by the petition, on behalf of petition number 2 of 2022, that is the Youth Advocacy Africa and Peter Kireka, We would like to clarify some issues arising from the scrutiny that is going on, and I will request my brother, Mr. Justice Renaura, to do that on our behalf.
Thank you, CJ. We have received information from the Registrar of the Court that parties have been unable to agree on how to conduct the exercise in order number 7 of the directions given in the ruling on scrutiny and recount. That order reads as follows. That Iebc should provide certified copies of Forms 32A and 34A Book 2 used in the imputed election, subject to the applicants providing the Iebc specific contested polling stations for compliance thereof. We thought, in our wisdom, that that order is specific to contested polling stations, but what we have instead, Otieno Ogola writes and said he wants the Forms 32A for all 229 stations. Joachim Bosch and company write and say they want for 238 stations. I believe the petitioners, first petitioners, have asked for 517 stations. Obviously, with the time we have, and you've already spent the whole day haggling on this, 24 hours or 48 hours are gone, it is now impossible to comply with that order, and therefore, the court directs as follows. The applicants shall only, the Iebc shall only provide the 32As and 34As Book 2 from 41 stations, polling stations, that are in the affidavit of Celestine Anyango Opio. That is the only way that exercise can be a meaning, can have meaning. And that those forms will be a sample for which you can submit in accordance with your pleadings. We cannot allow you, we said, to go outside your pleadings, because what's happening now, we are creating a new case out of these forms. So please stick to your pleadings, and once we get those, the report on those forms, you submit on them in the context of your pleadings. And so, Caleb Khalifa's petition, Willis Otieno's petition, Willis Otieno, the petition by Raila Odinga, and the petition by Joachim Bosch. Those are the 3 petitions where these issues arise. Please submit only on those issues. I hope I'm clear. And we don't expect debate on these. We expect compliance. I thank you very much, CJ. I thank you, Council. And remember, CJ, and Council, this exercise must be conducted before 2 p.m. tomorrow. What is will be undone by tomorrow will be undone. I thank you.
Thank you, Justice Renaura.
My lady, the Chief Justice and members of the court, we are also having difficulties with the orders relating to inspection of the servers. We have been given restricted access only to the result transmission system, and only it has not been granted yet, only to one server, and it is established that the Iebc has got 8 servers. We have taken the decision to write formally to the registrar in the hope that the court eventually can resolve this matter as quickly as possible, because we are running out of time. But there's no compliance in terms of the orders that the court gave.
We are aware about that issue. We are following up on the question, and as far as we know, the exercise is continuing. Should there be an issue later in the day or tomorrow morning, we shall receive a report. But as far as we know, by the time we got out of here, the exercise had commenced. There was an agreement on how to access the server that was given, and the issue of cloning is being addressed. So let's leave it for now. Let's report again tomorrow morning. I thank you, CJ. I thank you, Mr. Orengo. We are aware about that issue.
May I, with your very kind permission, Madam Chief Justice, I would like to rectify a mistake. We intimated to you yesterday that the two commissioners, Professor Guleye and Boya Molu, would have separate representation. That has been achieved, and we have Dr. Willie Mutumbwa, who is in court, and we have for Mr. Professor Guleye and Mr. Peter Wanyama for Commissioner Molu. Thank you.
That is noted. We can now proceed to invite counsel for petitioner in petition number E002 of 2022.
Thank you very much, Your Ladyship, the Chief Justice, members of the court. I wish to make submissions this afternoon before you on behalf of the third petitioners in the consolidated petition. The petition filed by the third petitioner, initially as petition number 2 of 2022, raises or has issues that deal with all the issues that had been framed all 9 issues that had been framed for determination by the court. But in respect of issues number 1, 2, 3, 4, 5, and 6, I will rely on the written submissions that we have filed or that have been filed on behalf of the third petitioner. And I will utilize my time on my feet this afternoon to focus on issue number 6, the cojoined issue number 7, number 8, and number 9 of the issues that the court framed or the court has framed for determination. I wish to get straight into issue number 6. And my humble understanding of issue number 6, and I will read it just for clarity, whether the Iebc has carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 138(10) of the Constitution. Again, it is my humble understanding from the manner in which that issue is phrased, that what the court is inquiring into is not whether tallying and verification should be done in accordance with Article 138(3)(c) and 138(10), but indeed whether tallying was carried out by Article 138(3)(c) and 138(10) by the Iebc. Time was taken by my learned senior colleague, Mr. Paul Mwangi, earlier on this morning, to make submissions as to what the Iebc is, the meaning and definition of the Iebc, and what amounts or what body or group of people then amount to the Iebc. And that is a submission of law, and I don't intend to repeat the submissions that were made by my learned senior colleague. But the issue as framed in number 6 invites a detailed factual inquiry. And that factual inquiry is the factual question of was the tallying and verification during the or after the presidential election that is the subject of these petitions indeed carried out by the Iebc. I wish to start my submissions by referring you to a press statement. And that press statement is by the chairman of the Iebc. I believe he's the second respondent. That press statement is dated the 17th of August 2022, and that press statement is to be found in volume 4 of the third petitioner's documents at pages 493 to 496. That press statement is dated the 17th of August. It is headed, the subject is staff murder, profiling, and misleading reports on the presidential election. It is under the hand of the chairman of the Iebc, and it is divided into 3 parts. I wish to focus my submissions on part 3. And part 3 is headed Declaration of Presidential Results. And I submit that this press statement is important because it is the first account by the second respondent as to how tallying and verification took place. In line 12, he states, for the avoidance of doubt, the law provides that the chairperson of the commission is the returning officer of the presidential election. I will emphasize on that the chairperson of the commission is the returning officer of the presidential election. I will make submissions later on in my submissions, and I will hope to persuade you that there is no such position as the returning officer of the presidential election. It is a creation of the chairperson of the Iebc, and it is created for the purposes of executing a very calculated scheme. Be that as it may, I wish you to then go on to the second paragraph from the end at line 34, where he says, as per Article 86C of the Constitution of Kenya, the results from the polling stations are openly and accurately collated and promptly announced by the returning officer. The next sentence is important. It is also important to note that Regulation 87 of the Election General Regulations provides, and he then goes on to state, that he, as the chairperson, is the one who is then empowered to tally or to verify and tally the results. Again, later on on page 495, he goes on to state, this constitutional mandate, and he's talking about the mandate to tally and verify, this constitutional mandate falls squarely on the chairman of the commission, who is the national returning officer. Again, he repeats that, as gazetted in Gazette Notice number 4956 of the 28th of April 2022. The role of the national returning officer for the presidential election is not a shared responsibility and not subject to plenary discussion of the commission. Very important, because at the end of the day, this is how the second respondent then tallied, verified, and declared the results, but we will get to that later on. He states in the paragraph beginning as the gazetted national returning officer that in the spirit of teamwork, the chairperson involved the commissioners. That is all he did. In the spirit of teamwork, he felt that there was no duty to involve them. All he did was involve the commissioners. And again, later on during my submissions, I will get to that. My learned senior colleagues who submitted before me dwelt in detail on the content of Regulation 83. The content of Regulation 83.2 and Regulation 87.3.1, Regulation 87.3 in its entirety, and the manner in which those two regulations enable the chairperson singularly to tally or to verify and tally results in the presidential election. I do not wish to take any time to go through those two regulations, merely to state that it is my humble and respectful position that those two regulations are inconsistent with the provisions of Article 138(3)(c) of the Constitution, because they enable the result in the presidential election to be verified and tallied in a manner other than envisaged by the Constitution. There is a substantive prayer in the petition to declare those two regulations unconstitutional. And I state for that reason that relief should be granted. Later on in my submissions, I will then make submissions as to the consequence of those regulations being unconstitutional and having then hopefully being declared unconstitutional by this court. The fact that the tallying and verification of the result in the presidential election was done solely by the chairman is laid bare in the provisions of Gazette Notice number 9540 of 8th of August 2022. This again was referred to by my learned senior colleague Mr. Firoz Noroji whilst he's on his feet. And this Gazette Notice is to be found at page 36 of the affidavit sworn by the second respondent and drawn by the firm of my good and learned friend Mr. Eric Gumbo and Associates at page 36 of that affidavit. Mr. Noroji took the court through that affidavit extensively, through that Gazette Notice extensively. I only want to emphasize that before the election, the chairman of the commission is clear that it is he who will tally, who will verify and tally the results. And for some reason, the chairman has the chairman of the Iebc had the propensity to publish Gazette notices even where he didn't need to, because there was no need, there is no statutory basis or regulatory basis or even constitutional basis for gazetting the result pathway. But he went ahead and did it. And it is clear, and I submit it is admitted by the chairman of the Iebc that he exclusively, to the exclusion of the rest of the commissioners of the Iebc, tallied and verified the result for the presidential election. So as to determine conclusively that the tallying and verification was done exclusively by the chairman, it is again important to ask the question, where were the other commissioners? Where was the rest of the Iebc as the chairman was tallying and verifying the results? Again, I wish to refer you to the same affidavit that I have, the affidavit sworn by the chairman and drawn by the firm of G&A Advocates on the 26th of August this year. And it starts from the second paragraph. He states in the second paragraph that in my capacity as the chairperson of the commission, I was the returning officer of the presidential election. He then goes on later on in the affidavit at paragraph 45 to state that for the proper management of roles at the tallying center of the presidential elections, I had designated in writing specific roles to each of the commissioners and other commission staff. Annexed here to as WWC 9 is a bundle containing the said communication. Again, this bundle and this communication is important, members of the court, because it states clearly what the other commissioners or the roles that the chairman had designated the other commissioners to do. At page 41, there is an internal memo or a letter signed by the chairman on the 22nd of July addressed to the vice chairperson Juliana Cherere and Commissioner Boya Molu. And it is headed Appointment to the Media and Call Center Management Team for the Presidential Tallying Center, Bomas of Kenya. And he goes on, he says, consequently, you are hereby appointed to the Media and Incident Reporting Team of the Presidential Election Tallying Center as follows. Juliana Cherere, team leader. Commissioner Boya Molu, alternate team leader. And their roles are set out there. Terms of reference of your appointment provide liaison between the presidential returning officer, who is himself, and the National Communication Center, preparing periodic briefs for the presidential returning officer to address the media, briefing the presidential returning officer on electoral activities across the country. Nothing to do with tallying and verification. The two subjects of that letter are commissioners of the Iebc. The next letter is on page 42, also dated the 22nd of July. This one is addressed to Commissioner Francis Wanderi and Commissioner Irene Masit. Again, under the hand of the chairman, and it is appointment to the Logistics, Welfare and Security Team at the Presidential Tally Center, Bomas of Kenya. Again, he appoints them in the second paragraph. Consequently, you are hereby appointed to oversight, provide policy direction and strategy formulation for the welfare and security team of the Presidential Election Tallying Center. He then states their names and he states their terms of reference as security of the tally center and installations, the tallying center's logistics, planning and organization, security of members of the commission, staff, VIPs and other visitors, transport for commission staff, any other duties assigned. Important, those are 2 commissioners. None of them has been assigned to tally and verify. The third letter is on page 43, and this one is addressed to Commissioner Justus Nyang'aya. Again, Justus Nyang'aya is appointed to be in charge of dignitaries and protocol. And in the second paragraph, he is told that as team leader for dignitaries and protocol, he will be responsible for providing support services to the Commission, managing protocol of dignitaries and VIPs, managing access to the Presidential Tally Center for accreditation, for accredited media, observers and agents, and any other responsibility. Now, those are out of 6 commissioners. Those are 5 commissioners. None of them is assigned to tallying and verification. There is a last letter, also dated the 22nd of July on page 44. This one is addressed to Commissioner Professor Abdi Guliye and Mr. Marjan Hussein Marjan. I wish to point out to this court and ask the court to note that Marjan Hussein Marjan is not a commissioner, but he is merely the CEO of the Iebc. Now, these 2 are appointed to the results management team at the Presidential Tally Center. Their duties are undertaking quality assurance of result forms received from the Presidential Returning Office desk, tallying and processing of election results. I urge that that is the language of Article 183.3, and assisting the Presidential Returning Officer in managing a record of the election results. Tallying and verification, I submit, on the admission of the chairman of the Iebc was done by Professor Abdi Guliye and Marjan Hussein Marjan, and not by the Iebc. The tallying process continues unconstitutionally as it was being conducted, and I want to pose the question and attempt an answer to the question, how does that process then end? That process ends as set out in paragraphs, again, the same affidavit of the chairman, at paragraph 76 onwards. But the story that he tells, or the deposition that he makes, starts in paragraph 66. And I will read it because it is important. He deposed, shortly after 2 p.m., the commissioners and I had a meeting to be briefed on the final results by the commission secretary, stroke CEO, an alternate leader of the Tally Center. The meeting was only for a briefing. He then goes on to say, the briefing was to be done before my declaration in accordance with Article 138(10) of the Constitution. So according to the chairman, all that was going to take place between him and the commissioners was a briefing, and he then goes on and declares the results. What did he do? After he narrates the story of the visit between paragraph 67 and 75, he then goes on under the substantive heading, Commission Briefing of Final Results. After the NSAC team had left, the Commission Secretary and Chief Executive Officer, who was also the alternate leader of the team of the Tallying Center, Mr. Marjan Hussein Marjan, walked into the boardroom. The purpose of the meeting was to receive the final tally of results of the presidential election before I could proceed to declare. From the chairman's own evidence, he assembles a team that comprises Professor Guliye and Mr. Marjan. They tally and verify the result, and Mr. Marjan is merely coming to brief the commission. What happens after that? There is between paragraph 77, where he states that copies of the results were handed to the commissioners, and that is all that was done. The result had been tallied and verified elsewhere. The copies are merely handed. There is a conversation. There is no agreement. and of importance. At paragraph 81, the chairman deposed as follows. I walked out of the meeting room accompanied by Commissioner Professor Gulie, Commissioner Molu, and the Chief Executive Officer. And he then went to the auditorium and declared the results. In the chairman's own words, and I submit that his narrative of what took place is important. That is how the tallying and verification of the result in the presidential election took place. To answer or to attempt an answer to the question that is sought by this court by framing ground number 6 as it is, whether Iebc carried out verification, tallying, and declaration of the results in accordance with Article 138.3c and 138.10, I would answer that question in the negative. Tallying was carried out by the chairman alone. At best, the chairman, Professor Gulie, and Mr. Marjan. A quick look at Section 5.1 of the Iebc Act would disclose that those 3 gentlemen, however eminent, are not the Iebc. What the Constitution enables the chairman to do on his own is to declare the result. I submit that the election is a process, it is a progressive process, and the completion of one process enables another. If you do not complete voting, you cannot tally. If you don't complete tallying, you cannot declare. I submit that tallying and verification, having not taken place, as provided by the Constitution, then there was no result for the chairman to declare. There is an attempted justification by the chairman for his decision to tally and verify the result on his own. That justification exists in an affidavit sworn by the chairman. This time it is drawn by the firm of Iseme Kamau and Maema Advocates. It is at page 14, at paragraph 62. The chairman attempts to justify his decision to tally and verify alone from this court's decision in Raila 2017. With tremendous respect to the chairman, the issue of his ability to tally and verify on his own was not an issue in Raila 2017. And with the clear provisions of the Constitution, in Article 138.3c, there can be no judicial foundation for the chairman's tallying and verification on his own. At the beginning of my submissions, I had submitted that I wish to demonstrate to this court that the chairman executed a very well calculated scheme to grab the election and to run the election on his own. And this is how, in my estimation, he did it. Elections are normally commenced by a notice of elections that is issued under Section 14 of the Elections Act. Regulation 12 of the Elections General Regulations then provide that certain specific notices will be issued for the presidential election. Regulation 12.2 provides as follows: immediately after the publication of a notice under Section 14, and the notice under Section 14 of the Act is published by the Commission, the returning officer of every constituency shall notify the holding of a presidential election in Form 8. Now that's important, because I had also said that earlier on that there is no such role as a presidential returning officer or national returning officer. And I say so because of the provisions of Article 138.2 of the Constitution. Article 138(2) of the Constitution says, if two or more candidates for president are nominated, an election shall be held in each constituency. An election shall be held in each constituency. A returning officer is defined in Section 2 of the Elections Act as a person who conducts an election. The chairman is merely enabled to declare. The conduct of the election by dint of Article 138(2) is by 290 returning officers. The notice that they were required to publish under Regulation 12(2) was never published. The 290 notices from the 290 returning officers was never published. There is no position like the national returning officer. So the first infraction is that there are no notices. The chairman constitutes himself as the national returning officer, and the notices are not published. The chairman gazetted himself. I believe the gazette notice is the gazette notice, I think it is the 22nd or 28th of May. He gazetted himself as the national returning officer. As a matter of good electoral practice, returning officers are gazetted with deputies. The chairman gazetted himself with no deputy. It was his election to run as he saw fit. There is the issue of the deployment or the unilateral transfer of returning officers. My learned colleagues who appear for the commissioners have dealt with that extensively in their affidavits, and I'm sure they will submit on it when they have their time on their feet. Again, the deployment of commissioners at Bomas was not accidental, it was deliberate, it is documented, and the details are spelled out, the duties are spelled out in detail. Again, the postponement of the elections is another issue, and I wish to pose this question at this juncture. We have interpreted constitutional time as being strict, but the chairman of the Iebc has on more than one occasion dealt with constitutional time as if it is elastic. The elections that he postponed on the 8th of August were not the first elections that he postponed. In the second week of March 2000, the then sitting MP for a constituency in Kwale called Msambweni passed away. The Constitution provided that by-election be held within 90 days. That by-election was not held until the 20th of December 2000, or not 2000, 2020. Again, that is another election that was postponed, and it just went by. The manner in which the commission conducted itself, or the chairman conducted himself, around the commission dealing with these very petitions is also instructive in the manner in which the chairman had, assumed certain roles and capacities to himself. I wish to refer to the affidavit of Juliana Cherere, filed in this court on the 26th of August. And I wish to refer members of the court to the to annexure JC12. That annexure is correspondence, it is internal memos within the commission. The first one is signed by the 4 commissioners, and it is a request for a special meeting whose agenda is to deliberate the commission's position in light of the presidential elections petition filed in court on the 22nd of August. That letter is dated the 24th of August, 2 days after the petition is filed. Annexure JC12 or JC13 is a follow-up to that letter. There is no response, or there is no response by the chairman to the initial memo, and there is a follow-up now asking for a meeting on Friday the 26th at 9 a.m. at the commission's offices to discuss that purpose. Of tremendous importance is the letter, or is the internal memo exhibited as JC14. This is a response to the request for a meeting. This one is not under the hand of the chairman, but under the hand of the CEO, where he convenes that meeting for today, the 31st, the first day of hearing. Is that a chairman acting in the best interest of the commission? Is that a chairman acting constitutionally responsibly. The effect of the unconstitutionality in the election was dealt with by this court's decision in Joho 2014. Anything done under that unconstitutional piece of legislation is a nullity. In the brief time that I have left, to answer the ground number 7, it is impossible to tell whether the returned candidate garnered 50% plus 1, because the process by which that finding would have been made did not take place constitutionally. The election having been conducted as it was, there is no result. The votes that were cast by the people of Kenya having not been properly tallied and verified, or verified and tallied, there can be no declaration. I wish to assert the submission made by my learned senior colleagues that an election is a sovereign process that belongs to all Kenyans. And via the Constitution, we have delegated the management of that sovereign process to the Iebc. It was a constitutional infraction of monumental proportions for the chairman to seize the election as he did. And for those reasons, it is my humble request that all...
Good morning, ladies and gentlemen. Welcome to the Supreme Court of Kenya for the hearing of Presidential Election Petition number 5 of 2022, as consolidated the petitions number 1, 2, 3, 4, 7, and 8 of 2022, the Honorable Raila Odinga and 7 others versus the Honorable William Ruto and others. The Ready Chief Justice will preside.
Thank you very much, our court assistant. Good morning, learned counsel and the parties, distinguished ladies and gentlemen present this morning. We finalized the pretrial issues this morning, and on behalf of the 7 justices of the Supreme Court, we welcome you to this morning's proceedings. We have a tight schedule. Therefore, without much ado, we will ask the petitioner to start their case. But we will take the appearances. The quorum sheet, I believe, has been found, but we can take the appearances.
My Lady, the Chief Justice and the President of the Court and members of the Court, for the first and second petitioner, my name is James Orengo. I appear with my learned senior counsel, Firoz Noroji, together with my learned friends, Mr. Paul Mwangi and Ms. Julie Soweto. We also appear with senior counsel, Mr. Philip Murgor, is not in the court, but once I've concluded my submissions, he'll come in to continue to deal with an aspect of our case.
May it please Your Ladyship, Chief Justice, Your Ladyships, my lords, for the first and second respondents, the appearance is as follows. My name is Ngatia.
I appear together with my learned friend Kioko Kilukumi, Senior Counsel, Mr. Kirago Kimani, Senior Counsel, and Professor Kindiki. That is the team representing the first and second respondents. Thank you.
Madam Chief Justice and the Honorable Judges of this court, my name is Githu Muigai. I appear for Iebc and the second Mr. Wafula Chebukati jointly. I lead that team. The team for Iebc is Eric Gumbo, George Murugu, Dr. Willie Mutumbwa, Mr. Wekesa Simiu, Mr. Wambua Kilonzo, Mr. Moni Mokele, Mr. Mwangi Kibicho, Mr. Peter Wanyama, Miss Maggie Ngetich, Mr. Emmanuel Wetangula, and Miss Mase Mwinzi. The team for Mr. Wafula Chebukati is Abdikadir Mohammed, Senior Counsel, Kamau Karori, Senior Counsel, Michael Mushemi, Mr. Tito Tiego, George Gilbert, Collins Bush, Herman Omiti, Nancy Kangede, Moses Kipkogei, Innocent Muganda, and Mahat Jomen. Thank you very much.
Chief Justice, Deputy Chief Justice, Your Ladyship, my Lords, Justices of the Supreme Court, Paul Muite, in terms of the orders of this Honorable Court yesterday, Issa and I, in addition to the lawyer counsel on record for the fifth respondent, the sixth respondent, seventh respondent, and eighth respondent. In summary, the four commissioners, in addition to the respective counsel appearing for them, we've agreed in terms of the orders of this court that Issa and I will act collectively for the four commissioners whose views need to be heard. I need to add, for the sake of clarity, that we are not asking for any extra time. We will address this Honorable Court on behalf of those four commissioners by sharing time with the individual counsel for each of the commissioners. I thank you.
Your Ladyship, Madam Chief Justice, Deputy Chief Justice, and Judges of Appeal, for the fifth petitioners, I appear together with Lydia Mwalimu and Millie Odhiambo, not in court. Okiya Omtata will appear in person. I think that is in order. My name is Professor Tom Ojenda, Senior Counsel, just for record so that I don't come back.
Your Ladyship, the Chief Justice, Your Ladyship, the Deputy Chief Justice, my Lady, my Lords of the Supreme Court, my name is George Oraro, appear for the Attorney General.
Madam Chief Justice, Madam Deputy Chief Justice, Judges of the Supreme Court, my name is Jan Mohammed. I appear with Mrs. Wambugu for the second petitioner when you had consolidated the cases yesterday.
Your Ladyship, the Chief Justice, members of the court, together with Tom Masharia, Njoki Mboshe, Steve Wandeto, John Njomo, and Paul Kiragu, I am Paul Nyamodi for the third petitioner.
You may please, my Lady Chief Justice, Deputy Chief Justice, my Lady Justice Njoki Ndogu, and my Lords, I'm Mutieno Willis. I do appear together with Mr. Nelson Osiemo, Ms. Caroline Kituku, Ms. Lea Chanimbanga, and Mr. Victor Oduol for the fourth petitioner.
May it please you, my Lady the Chief Justice, my Lady the Deputy Chief Justice, and the Justice of the Honorable Court. My name is Degwa Njiro. Together with Mr. Mituga and Mr. Morara, we appear for the fifth petitioner.
My Lady, my name is Ochiel Dudley for the International Commission of Jurists as Amicus Curiae, the second amicus. I appear alongside Mr. Isaac Okero and Ms. Anne Ngige. Thank you.
May it please the court, my Lady the Chief Justice, the Deputy Chief Justice, and other judges of the Honorable Court. My name is Kibe Mongai, appearing for the seventh petitioner alongside Ms. Wairimo Keru.
Honorable Chief Justice, good morning. Members of the court, on behalf of the Law Society of Kenya's amicus, my name is Stephen Mwenesi. I am in this matter alongside the President of the Law Society, Mr. Eric Theuri, and we have a team of the Public Interest Litigation Committee guided by Counsel Maura Kabata and Dr. Musau and Dan Oino Kemo and others. I thank you for allowing us to participate.
Thank you very much. We have taken the appearances. We will straight away go to the petitioner's case.
It may please the court, I'm going to deal with the issue number 6 amongst the 9 issues that were crafted by the court for purposes of determination. And yes, and my learned friends, Mr. Firoz Norji, will deal with the issues captured in number 8 and 9. And my learned friend, Mr. Mwangi, will deal with the issue number 6. My learned friend, Mr. Philip Murgor, will deal with the issue number 1, 2, and part of 3. And my learned friend, Ms. Julie Soweto, will deal with the issues 3, 4, 5. I appear together with my colleagues for the first and second petitioners in the consolidated petition. The petition was filed on the 22nd of August this year, following the declaration of the results of the presidential elections that were held in the general elections on the 9th of August 2022. And those results were declared on the 15th of August 2022. Following that declaration, the petitioners, the first and second petitioners, were aggrieved with that announcement and consequently filed this petition. The petition is accompanied with a host of affidavits, and it may please the court, I'll refer to about 5 or 6 affidavits in my address. But as a matter of opening, I would want to deal with some constitutional issues as set out in the various articles of the Constitution. My lords and my ladies, after many years, the Kenyan people came about with the Constitution 2010. They enacted this, the Constitution 2010, and as opposed to the previous occasions, we had a constitution which was enacted by the people, in which they declared their sovereign authority. Therefore, anything done in the name of the Republic, in exercise of powers that spelled out in the Constitution, is based on donated or delegated authority as set out in Article 1 of the Constitution. Now, my lords and my ladies, it is important to put into consideration Article 2 on the supremacy of the Constitution, together with Article 3, which talks about the defense of the Constitution. As opposed to the previous periods when we had a constitution which was negotiated at the time of independence with the colonial authorities, this constitution established a republic in which the doctrine of separation of powers was embedded. And more particularly, my lords and my ladies, in this constitution, there were several constitution bodies and agencies that were created, which includes the first respondent, the Independent Electoral and Boundaries Commission. And in accordance with the dictates of the Constitution, the Independent Electoral and Boundaries Commission, just like any other body established under the Constitution, and for that matter, any person who resides in the Republic of Kenya is required not only to recognize the supremacy of the Constitution, but act in accordance of the Constitution and in defense of the Constitution. Under Article 249, all independent offices and independent commissions are required to respect the sovereignty of the people and also to promote constitutionalism. This is important because Article 249, as read with Article 88 of the Constitution, which vests powers on or to the Independent Electoral and Boundaries Commission, requires that those powers must be exercised in accordance with the Constitution. Now, my lords and my ladies, the story that emerges out of the events that occurred on the 9th of August this year, and subsequently following to the 15th of August, upon the declaration of the Constitution, of the elections, the presidential elections, goes contrary to the established provisions in the Constitution, and will enumerate those violations at the appropriate time. But in opening, I want to say this, my ladies and my lords, that this grievance that we place before you, the highest court in the land, is not just a conspiracy theory. It is not just any ordinary event. If you look at the evidence that is placed before you in totality, we invite your Lordship to come to the conclusion that what happened on the 9th of August this year and the subsequent events that followed on the 15th of August mark a pattern of violations against the Constitution in order to undermine the authority or the sovereign will of the people, and in effect preside, that is the commission, preside over an election that in effect did not represent the will of the people of Kenya. Now, in saying this, my ladies and my lords, you will be taken through a host of evidence borne out in the affidavits that show clearly that the Electoral Commission, just like they did in 2017, did not preside over an election that was in accord with the requirements of the Constitution as laid out in Article 81 of the Constitution. Article 81 of the Constitution requires that an election held in the Republic of Kenya should abide by the general principles set out in that article, and more particularly, Article 81 Article 81E, that the elections must be free and fair, and Roman 4, the elections must be transparent, and Roman 5 of that article, that the election should be administered in an impartial, neutral, efficient, accurate, and accountable manner. My lords and my ladies, I want to emphasize the words accurate and accountable manner. And those provisions in Article 81 read together with Article 86, which requires that at every election, the Independent Electoral Commission shall ensure that whatever voting method that is used, the system is simple, accurate, again, the word accurate, verifiable, secure, accountable, and transparent. And more importantly, that the votes cast are counted, tabulated, and the results announced promptly, and that is at the polling stations. My lords, you would notice that as we appear before you today, we have something that has never happened in this country, that you have a commission that is divided right in the middle. That speaks to a dysfunctional constitutional body that is not capable, leave alone the transgressions that we are going to talk about. But we are talking about an electoral commission that is dysfunctional and cannot be able to preside over an election that would give it the stamp of legality and legitimacy as spelled out in the Constitution. And I think that is a matter that this court should not disregard. And we'll come to that a little later in our address. Indeed, the Tower of Babel has been brought down by the appearance of two factions within the commission before your lordships and my ladies. And this, in event, has created a situation where no Kenyan can believe that the pronouncement of the first, of the ninth, I think the second respondent, Mr. William Samoei Ruto, as president-elect, came out of circumstances as envisioned in the Constitution of the Republic of Kenya. And your lordships, we would invite you, and my learned friends are going to address you on this point as to what really happened within the commission. Now, coming to the subject matter that I'm going to address you on in the question of the issue number 7, that states that the declared president-elect, whether the declared president-elect attained 50% plus 1 vote of all the votes cast in accordance with Article 138, sub-Article 4 of the Constitution. We want to persuade you that the second respondent never attained that constitutional threshold. And going back to the Constitution on that particular article, Article 138, sub-Article 4, it was made part of the Constitution by the framers of the Constitution to give legitimacy to anybody elected as president, to the effect that he had widespread support of the Kenyan people, and that is evidenced by the requirement that the president-elect must have at least 25% of the votes cast in each of the more than half of the counties. We are not dealing with that point. We're dealing with Article 4A, that it is a requirement, mandatory requirement, that the person elected as president must receive more than half of all the votes cast in the election. Now, talking about numbers in those two provisions speaks to the need for accuracy and accountability to give an election the legitimacy that the holder of that office would carry while exercising the powers of the President of the Republic of Kenya. And it's not an idle matter, because we went through an experience, before the enactment and proclamation of this Constitution, that a person would be elected by way of a simple majority, and in circumstances in which you would find that the person elected as president did not garner more than half the votes which are cast in a presidential election. So this is an important matter. And the difficulty about this particular article is that it requires, at the end of an election before the declaration, that the Commission carries out some mathematics, some mathematical calculation and computation based on proper returns of the votes that were cast in the polling stations and transmitted, as it were, the results thereof to the National Tallying Center and verified accordingly in terms of the Article 38 and the Elections Act. Now, my lords and my ladies, my starting point would be the fact that in this election, it was declared that, and that is found in paragraph 7 of our petition, that the second respondent in the declared result garnered 7,176,141 votes, which according to the Electoral Commission represented 50.49% of the votes cast in the election. Now, this figure would be correct depending on the calculations that were carried out or computation done by the Electoral Commission based on the votes cast during the elections held on the 9th of August 2022. Now, the complaint on this in this particular regard is contained in paragraph 43 to paragraph 48 of the petition. And for purpose of clarity, with your permission, my lords and my ladies, I would want to read out those particular paragraphs of the petition so that I can properly put it in context. Paragraph 43 bars that the number of voters who turned out to vote in the general election held on the 9th of August 2022 remains indeterminate. The second respondent has been issuing contradictory figures on the voter turnout. On the 9th of August 2022, on or about 1600 hours, 1 hour before the close of polls, the first respondent reported through various public news media outlets the voter turnout around the country was fairly low and was at an average of 52% of the registered number of voters. On 10th of August 2022, at or about 13 hours, in his first media briefing to the public following the close of polling, their second respondent announced that the total voter turnout in the general election as captured in the electronic voter identification kits, that is the KIM kits, was 65.4%, equivalent to 14,466,779 voters. Roman 3, the second respondent, however, indicated that he expected the above number to rise once the number of votes identified manually was taken into account. Contrary to the above declaration and reasonable legitimate expectation, the final voter turnout captured and declared in the final results of the presidential election in Form 3C is stated to be 14,213,137 votes, which is absurdly lower and not higher as anticipated. Notwithstanding a computation using addition of the valid votes in figures for the presidential elections, candidates in the aggregate results shows that the total number of valid votes is 14,213,027. Now, my ladies and my lords, the first point that is being made there, that if you look at the results as announced by the Electoral Commission and what is stated in Form C as the turnout of voters, and that is 14,213,137 votes. If you compute or add the number of votes cast for each candidate individually, that is the petitioner, the second respondent, and the two other candidates, that the figure that results is not the figure that was stated in Form 34C. The figure is 14,213,037. That is the first point. And this is important because as we proceed, we are going to demonstrate that the number of voters who took part in the elections and the number of votes cast in the election is indeterminate and is a moving target. It keeps on shifting. And I invite your lordships and my ladies to look at the results as set out in Form 34C and I equally invite the court to calculate the number of votes garnered by each